Hearing of the Parliamentary Joint Committee on Corporations and Financial Services into wholesale investors and wholesale client tests. I begin today by acknowledging the traditional custodians of the land on which we meet and pay my respects to elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via teleconference and in person. These are public proceedings being streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they're protected by parliamentary privilege. It's unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as contempt. It's also a contempt to give false misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind any committee members and witnesses who are appearing via video conference and who are not speaking to mute their microphones. I now welcome Ms. Glenda Hansen, Ms. Fiona Smedley from Herbert Smith Freehills, and representatives from the Law Council of Australia. Thank you for joining us. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. So for the Hansard record, would you please state your full name and the capacity in which you appear today? We might start down this end with...
Fiona Smedley from Herbert Smith Freehills.
Thank you, Ms. Smedley.
Nathan Hodge from the Law Council.
Sarah Dulhunty, Deputy Chair of the Corporations Committee of the Law Council.
Glenda Hansen, Senior Lawyer with the title Consultant, employed by King & Wood Mallisons, but appearing today in my private capacity.
Andrew Clements, Representative of the Tax Committee of the Law Council.
Thank you very much. And Ms Hansen, that is noted. Why is that the case? You're here in your private capacity, not representing King & Wood Mallisons, to whose submission I believe you're going to speak.
I just wanted to refer to the submission, but I'm appearing in my personal capacity. I'm not a partner of the firm.
Okay.
And I'm aware that there are different views held by clients of our firm as to what should be done with this test, and I thought it would be more informative for the committee to
be free to give the full range.
Neutral.
Wonderful. Okay, thank you for that explanation. I knew there would be one. Clearly the committee has interest in this matter, and I'm going to invite you to make a short opening statement. Can I get an indication of who is proposing to do that? Ms Dulhunty?
No, excuse me, Chair. There is actually another witness online.
Ms Bell, sorry. Do you want to give us your full name and the capacity in which you appear?
Yes. Pip Bell, Co-Chair of the Law Council Business Law Section's Financial Services Committee. Chair, I note the opening remarks made reference to people appearing by video conference. I'm just appearing by audio conference today, as that was my understanding of the way the proceedings would be conducted.
Ms Bell?
So, thank you.
Yes, thank you. Thank you very much indeed. And we will now have those opening statements. So who is proposing to give us an opening statement? Mr Hodge, do you have one?
The opening statement from the Law Council.
Ms Bell, you're the opening statement. Thank you very much. Off you go.
Yes, thank you. Thank you, Chair. The Law Council of Australia welcomes the opportunity to appear before the committee this morning in relation to its inquiry into the wholesale investor test for offers of securities and the wholesale client test for financial products and services contained in Chapters 16 and 7 of the Corporations Act, respectively. The Law Council's submission to this inquiry is drawn on the experience of its Business Law Section's Corporations Committee, Financial Services Committee and Taxation Committee. Additional comments have also been provided by the Legal Practice Section's Superannuation Committee. As a general observation, the current legal requirements for the wholesale investor and wholesale client tests are complex, and the Law Council would welcome measures intended to address the inaccessibility of the existing framework. In its review of the legislative framework for corporations and financial services regulation, the Australian Law Reform Commission noted that the classification of a client as retail or wholesale is of greater consequence now than it was at the time of the 2001 reforms. This is because the application of the test has greatly expanded from the origins in whether or not a person required the level of disclosure in a regulated prospectus to be appropriately informed about an investment. As a result of this expansion, many matters now are impacted by the wholesale investor and wholesale client test, for which there would necessarily be ramifications in the event that changes were made to these tests. A number of these intersections are detailed in our written submission and relate to impacts on investors, operators of managed investment schemes and corporate collective investment vehicles, licensed providers of financial services, exempt providers and regulators, including the Australian Securities and Investments Commission and the Australian Financial Complaints Authority. Due to these wide-ranging consequences of reform, the Law Council considers that any consultation process must take account of the broad range of stakeholders who would be impacted if any changes were made to the test. Any such process should firstly be well publicised in a manner that is likely to come to the attention of affected stakeholders. Secondly, there should be at least 3 months for stakeholders to provide feedback. And finally, there should be the opportunity for roundtable discussions to be held with stakeholder groups. Our submission highlights several areas for improvement to Chapter 6D and Chapter 7 of the Corporations Act, including the need to address inconsistencies in the use of defined terms and ensure that regulations containing long-term modifications to the Corporations Act are promptly reflected through reforms to primary legislation. The Legal Practice Section Superannuation Committee has added further areas for consideration, including relating to the application of the wholesale client test, where the client is the trustee of a superannuation fund. The Superannuation Committee has submitted that to remove this uncertainty, the law should be amended to clearly provide that a superannuation trustee is a wholesale client if it satisfies any of the tests that apply to other categories of investors. The Business Law Section's Taxation Committee has further noted that while tax considerations may not directly influence the outcome of this inquiry, it is important to recognise that changes to the test can have unintended adverse impacts on the tax status of commonly used investment vehicles in the managed funds industry. I refer to our written submissions and its attachments for further reflections on the wholesale investor and wholesale client tests. Again, we thank you for the opportunity to appear and we look forward to responding to your questions. When it comes to responding to questions, I will respond to those relating to Chapter 7 of the Corporations Act on behalf of the Law Council. When it comes to Chapter 6D, we have Ms. Delhunty from the Corporations Committee. We have Mr. Clements from the Taxation Committee to respond to tax-specific questions, and Mr. Hodge to deal with any questions relating to the specific superannuation points from the Legal Practice Section Superannuation Committee. Thank you.
Thank you very much, Ms. Bell. Do you want to make an opening statement, Ms. Hansen?
Yes.
Thank you.
Thank you, Chair. I would like to thank the committee also for the opportunity to comment on the wholesale client test, which, as we know, is a fundamental part of financial services regulation. Just to give the background to my observations, I've spent 28 years at King & Wood Mallisons practicing the investment funds and financial services area, so a lot of my comments are from the perspective of managed investment scheme regulation. I'm also author of the chapter on collective investments in the LexisNexis Loose Leaf Service Australian Corporations practice, which I've done for 15 years. I'm chair of the Legal and Compliance Expert Group at the Financial Services Council, pardon me, and was an expert reader on the Australian Law Reform Commission's report on the Corporations Act. And before I went into legal practice, I was managing a financial services business in funds management. So a very, very long experience in this area. The first point that I would like to make to the committee is that there is no legal reason why the tests for capital raising under Chapter 6D, where enterprises, in particular small enterprises, and I gather you'll hear from some of them this afternoon, there's no reason why the test that governs capital raising for them should be identical to the test in Chapter 7, which has more of a consumer protection function. And I noticed from the terms of reference that there were the two were grouped together, and there are a lot of commonalities in the tests, but I'm drawing this to your attention because I think it may offer a way forward if the committee is minded to recommend that there not be very significant changes in the small business capital raising area. It will still be possible for reforms to be made in the other area.
Stop you there for a second because we've had this little beep sound. Can I just get you to identify?
Get your own.
Hello? Could you? It's the Corporations Committee. Somebody's gone. They've got to get their own, whatever that means. But we don't know who that was. Okay. Random call. Sorry. Back to you, Ms. Hansen. Thank you.
Thank you, Chair. So just to finish that point, it would be simpler in terms of administering the law for the tests that relate to active businesses, which are taxed at source and so clearly distinguishable from investment funds, which are not. It would be simpler for the tests to be the same, but there is no legal reason why they must be. And so I felt that that was important to point out because it would give a way forward to make recommendations if you were minded to give different considerations in the area of active businesses needing to raise capital for enterprise. So that point is dealt with in some detail in the King and Wood Mallison submission, which I've provided a copy to the committee. The second point I'd like to make is that there is a technical issue with the sophisticated investor test as it applies to financial products, which is ripe for law reform. And I'm speaking of the test in Section 761GA of the Corporations Act, the Chapter 7 test, which, for example, applies to whether you can subscribe to a managed fund. And that test is expressed in different language to the test in Chapter 6D about prospectuses. It says that effectively the issuer of the financial product must be the one that provides a certificate that confirms that a person has the relevant expertise to be regarded as a wholesale client, even if they don't meet any of the other tests. You would be aware of this, where they can certify that they have relevant experience. And if you look at the wording carefully, it says that the issuer, the licensee, is the one that must give the certificate. The problem with that is that the issuer has an incentive to certify people to come into their fund. And I think there is some agreement that it could be beneficial if that test is more used, particularly if the thresholds for the other tests are raised. That test may be more used, and it will be important to look at the potential conflict issue in that area. Finally, I wanted to draw to your attention a point about process which has been raised in a lot of submissions, and that is that the Law Council and my colleagues generally would agree with me, I think, that the Corporations and Markets Advisory Committee, which was abolished in 2018, would have been an excellent vehicle to examine a complex point such as this. It has been reported that the cost saving from the abolition of that committee, which existed in different forms since 1983, the cost saving from the abolition was only about $1 million a year, because a lot of people contributed their efforts to it voluntarily. And as we see today, people are keen to contribute to law reform. it had a significant output with a full-time staff of only 2 people, and produced some outstanding reports, including the 1993 report, Other People's Money, which was the basis of the managed investments regime, which endures today as an excellent piece of legislation. So to close my remarks, I think that idea would be supported by all of us who care about the stewardship of legislation and would be willing to provide our support to such a mechanism. I'd be happy to elaborate on any of these points later. Thank you, Chair.
Wonderful. Thank you very much for your very cogent explanation there of what you've included in your opening statements, Ms Hansen. And can I thank all of you for the submissions, which are comprehensive. I do note your declaration at the outset of how varied the perspectives are about this matter. And if I can go to just one question immediately on notice, this committee is at the same time as we're conducting this inquiry looking into financial abuse. And I just want to take the opportunity to trigger that as a lens through which much consideration of financial product needs to be applied. And I don't see that in any of the submissions. While we hear about safety by design principles in financial products, and Catherine Fitzpatrick's work in that area, which is being applauded and acknowledged across the financial services sector, it struck me that these changes may well have some implications in terms of somebody determined to perpetrate financial abuse, and that it's something that we need collectively to begin to think about in our submissions, rather than just the traditional structures of the law, because there is a power asymmetry often that is exacerbated by high wealth in particular. That can be a honeypot to which people might be drawn and to abuse. So I would just ask you to give consideration to that post facto. I'd be really keen to have any of your insights. If I can just ask one question before I go to my colleagues. The disincentive, the incentive for people to act improperly is well embedded in your second statement there. The issuer being perhaps incentivised, but certainly to be in a position of potential conflict if the tests are raised. I just wonder if you've had a chance to look at the submissions from Chartered Accountants Australia, New Zealand, CPA, IPA, and their discussion around this matter as well, of incentivising perhaps inappropriate behaviours by professionals. Have you looked at that submission? No. Can I ask you to have a look at it, because they talk about a rise in the number of accountants being asked to certify people's sophistication with regard to money, and sadly it echoes some of the concerns that have been raised in other inquiries for me about one sophisticated investor in a partnership, an intimate relationship, or in a family situation where there may indeed be very complex trust arrangements as well, and the marketing of a product that people become aware of that perpetrates financial abuse and exacerbates the power asymmetry that may exist. So, like you, that fear about incentives for people to do the wrong thing in certification is an issue. Have you any thoughts about the model of certification? Because there's quite a range of arguments across the submissions here. There's a proposal for people to go and get an education, to do some sort of a perhaps threshold test to indicate. There's a range of other things. Have across different jurisdictions, has had a long experience, as you described, of your own experience in financial services that would, summarily really bring you to a point where you'd be considered a sophisticated investor. Have you given any thought to what really needs to be in place to protect and enable the proper functioning of this wholesale investor space in terms of qualifications and eligibility? Ms Smedley?
Thank you. We have been talking to Treasury and ASIC over a number of years in relation to these types of tests, including in relation to the MIS review,
Yes.
which was last year. And during that process, we engaged with a number of the accounting groups, and we talked to them about their experiences of how their accounting members are feeding back to them information in relation to how the tests are being used. And they reported to us that they felt that there was an uptick in relation to the number of people seeking certificates. Those certificates are certificates in relation to usually the income or the net asset position of the potential investor, and it might also cover what they control. It might identify the companies or the trusts that they control as well, and therefore those assets and income of the controlled entities, which can also be brought into the test. I think some of the accountants feel a little bit uncomfortable about being asked to give those certificates, particularly when the assets comprise the residential home. And one of the questions that has come up a number of times for us has been, if you are looking at someone's certification as a wholesale client and you're looking at their net asset position, should you take account of the residential home or not? And one suggestion that we made at Herbert Smith Freehills was you could potentially have a two-step test. So you have a lower threshold for the net asset test if you exclude the family home, and then you have a higher, substantially higher test if you do include the family home. But most accountants that I have spoken to, and it's just my experience, have said to me that they wouldn't usually count the family home when looking at the net asset test of 2.5 million. They're not comfortable with that. And when they're giving their certificates, they're doing so in accordance with their accounting guidelines and standards.
Yes, which we have seen aren't always adhered to in all circumstances. And we know that we certainly have some concerns follow our inquiries into audit and also our inquiry into ethics and professionalism about the fact that there are accountants out there, whether they're certified and as chartered or not, who are making money out of doing the bidding of their client because there's a profit incentive. In the way that you described, perhaps there could be a conflict of interest for the issuer. So it's the same problem, different situation, but the same problem. It's an ethics problem, it's a power problem, and it's incentivised by profit making, which jettisons ethics. So everyone's got a very different solution to how this ecosystem might look, and one of the recommendations you all make is that there needs to be a period of consultation. Some are very specific, need at least 3 months for that sort of consultation. Please, Ms Smedley.
In relation to the qualified accountant certificate, there are only certain types of accountants who can actually certify those certificates. It's not any accountant. And there are particular categories, and what we do see sometimes in practice is that people will present certificates and you have to reject it because it hasn't been signed off by the right type of accountant. So it might also be interesting to observe whether there are different conduct rules that apply between those different categories of accountants.
And how they're observed, and how many people have been sanctioned, and how much disincentive there is, because all of that ecosystem seems very fragile to me from my observation, and even immature. So the laws can be made, and the expectation of good people who want to abide by the law are met by the tests, but we are dealing with people who are looking for avenues to scam the system, and we need to think about that when we're making law as well, not just in terms of productivity and efficiency, but also in terms of avenues for exploitation. If the colleagues can bear one more question, if I can, on the Chapter 6, Chapter 7 matters. So you make a very interesting point about the potential different treatment of those, Ms Hansen, and I just want to give you the opportunity to speak to that, because the drafting errors that you refer to as well in the Law Council review, perhaps this is Ms Bell, she talks about the revision of certain parts of 761G 6C of the Corporations Act. So lest we think 6 and 7 are perfect, there are some submissions that indicate there are problems, there are already definitional problems. So Ms Hansen, to you first, and then Ms Bell.
There are definitely drafting problems in the tests. One of them is that the tests refer to you qualifying if if the service is not provided in connection with a business. And that is very ambiguous and unclear. What exactly does that mean? A business that's not a small business is one of the categories of exemption. And the thresholds for not being a small business are clear. But what does it mean not in connection with the business? You might be insuring in connection with the business, or you might take your funds out of the business and then invest them in something. It's it's very fluffy language that would be better to be improved. The other difficulty, which has been a focus of the Law Reform Commission, is that a huge number of the rules on this are in the regulations, and then further things in ASIC instruments that affect all of the interpretation of this. So it's incredibly difficult for an ordinary citizen, even well-informed, to actually understand this area of law. So there's a case for consolidation and bringing together, if there's a redrafting of these rules, so that they are coherent and all in one place, as the Law Reform Commission recommended in its report last year.
So some sort of harmonisation effort is required, if I can shorthand it in that way.
Yes, and simplification generally. It could all be a lot simpler. May I go back to your point about the qualifications on the tests? Fiona spoke very well concerning the point on the accountant's test, but on the sophisticated investor test, which is a separate thing where there's a certification of a person's experience rather than their assets and income, we find, because we mostly act for what you might call the big end of town, the clients who are large, well-resourced and concerned to protect their reputations, I don't see any instances of them relying on that method of certification of saying, I think you're a suitably qualified, experienced person to invest in my product. That is not used at all, partly because of this conflict that I pointed out, but also because it's just a bit of a compliance nightmare. How do you check that that's been done properly? So it's really not used. The people who may use that are the ones that you're concerned about, Chair, which are at the end of the market where people are being persuaded to invest in products that are not necessarily put forward by financial institutions that, you know...
Reputation.
Exactly, yes.
Yeah,
so
double the risk. Did Ms Bell want to speak to the Chapter 6, Chapter 7 differentiation, concerns about the 761G, 6C, drafting errors?
Thank you, Chair. I'm just looking at our submission, and I note that that was relevant to the points made by the superannuation committee. So it may be the case that Mr Hodge is better placed than me to respond to that very specific provision, which related to whether the superannuation fund had net assets of at least 10 million. But if there was something different that you were asking or meaning to ask, I'm very happy to try and respond.
Thanks. Well, there's a section in your submission, paragraphs 8, 9, 10, 11, 12, 13 and 14 that deal with this, and it goes to those definitional matters, I think. So, Mr. Hodge,
thank you. No, that it was mentioned more than once in the submission, so I was looking at a later reference to that, and that was what specifically that paragraph was.
Is the specific one, yeah. Mr. Hodge,
thank you.
Did you add to that? Or do you want to take it on notice?
Notice, please.
Sure, sure. Okay, hopefully we'll get a couple of rounds here. Over to you, Deputy Chair. Mr Hawke.
Yeah, thank you, Chair. Just happy to take a bit of a step back just about a couple of points you've made in your submission and your presentation today. They're related, but they're slightly separate lines of inquiry. So just going to the sophisticated investor test for a minute, and I think you're quite right, Ms. Hansen, about the complexity of these parts of the Corporation Act. But I just want to get an opinion more than anything else, because with the sophisticated investor test, we've got some submissions saying it's pretty subjective. I think you're saying here there's a technical issue if you raise the thresholds. I understand that. I think that's fairly simple to understand. But again, I'm not meeting with the Treasury bureaucrats where there's a government intention to do something in this space. So I don't understand the motivation. But is there a problem here that really needs addressing, even with the increase of investors under this test going from, about 2 to 16% since it was introduced 20 years ago? I mean, sometimes government does things, but what is the purpose behind doing them? Is there a problem here that needs to be solved in the sophisticated investor test, in your opinion? Or, I mean, to me, it's such a technical area and such a sophisticated area, without using the same word. It just appears that what problem are we trying to solve with the changes to the thresholds? I mean, it might be cleaner to define people, in a certain way, but is there an actual issue in this space?
Could I just be clear, Deputy Chair, what you meant by the sophisticated test? Do you mean the tests overall and whether the thresholds should be raised? Or were you
both.
Specifically?
Both, yeah, exactly. Why are we doing this in the first place? Like, should we raise the thresholds? Because your submission's highlighting what will happen if you do raise the thresholds.
Yes.
And the impact that will have under the current law. But yeah, I am asking, I guess I'm the policy person, I'm asking, in your opinion, why would we do that in the first place? Is it needed? Do we need to change this? Is it necessary, in your experience?
Yes, Madeleine.
Could I jump in there? Deputy Chair, I think from my perspective, I think the wholesale client tests are currently working well. They're not broken, so you don't need wholesale reform, pardon the pun. But there are certain elements of the settings which haven't moved since they were introduced in 2001. So, for example, we have a test which says an investor is regarded as wholesale if they're investing more than $500,000. And that number hasn't changed since 2001. So a lot of people are looking at that and saying, well, if you think about at least the time value of money, surely that needs an uplift now. And we would be open to doing that. But there's one really important consequence of that, because a lot of investors will have gone into funds and structures on the basis that they're wholesale, and so therefore they're allowed to access a wholesale product or fund. If they are reclassified going forwards as a result of the change of law as a retail client, then all of a sudden that fund has a big problem, because it could be operated by someone whose license doesn't allow them to look after retail clients. So that could then become a poison pill in the fund, which could then cause the whole fund to unravel, which could have disastrous consequences for the other investors in the fund. So
that's a good explanation. Hence my question, why do it in the first place? I understand the neatness argument, like sometimes we want to index things, but if that amount isn't hurting anybody and changing it might create a lot of unravelling of a range of funds and other issues, why are we doing it in the first place? Like, what is the purpose of indexing that amount?
So, as I understand it, when the threshold was originally set, when all of the financial thresholds were set, about 2% of the population would have been categorised as wholesale clients. And the consequence of that, of course, is that if you're a wholesale client, you don't get access to the protections under the law that apply to retail clients. And over time, over 20 years or so, we now have about 16% of the population who are classified as wholesale. So I think the tricky balance now is to work out whether, if we're balancing business facilitation but also looking at for consumer protection, have we got that setting right? Have we got the balance right so that the wholesale client test...
Well, that's what I'm asking you.
Exactly.
You know better than me.
So we're
I'd make this observation. Nobody's banging down our door in government to do this, right? I'm not aware of any lobby that's saying alter this or change it and so you've got a lot of pieces in here on consultation and going out, and government's proposing something. Now, look, Treasury often comes around and says, what are we doing here, and this and that and this and that. But again, I'm just coming back to you guys. You're legal experts in this field. What would be the purpose of doing this? Like, to take that back to 2%? Is that really a worthy objective, or is that something we'd want to do? Is 16% a problem? I mean, you're not policy people either in that sense, but I'm asking for opinions. Do you have any opinion on this? I mean, is it better to leave the threshold where it is?
I'd be happy if you wanted to leave the threshold where it is, but I think a lot of people would say those numbers haven't changed for a long time. It just feels right to uplift them a bit. I don't think the change would need to be...
Isn't it a good reason in government to... But look, we're being funny here, and I'm not being rude to you at all. I understand that it might feel right. Yeah, I understand the arguments about indexation, changing figures, cleaning things up. I understand about simplification as well, like in law, but again, if something, I tend to find in policy and legislation, if people aren't being hurt by it, if we're not suffering a revenue loss from the government's perspective, we're always interested in more revenue. If we're not hurting people's investment profiles, if people aren't being scammed, what is the purpose of changing this threshold?
So I think it's not so much a legal question, and I'm just a lawyer, so I administer the rules as opposed to set the settings. But I think if you look back at some of the corporate collapses or fund collapses in recent years, I'm thinking back to Mayfair, Sterling recently, going back to things like West Point. What happened in some of those situations was that investors were encouraged to liquidate their assets. They would then realise just over $500,000, and then they would be encouraged to invest that amount. And so I'm just reflecting on what the Chair helpfully said at the beginning of this session, thinking about,
So your argument was that was doubled, that would be harder for them to do or whatever it was. I mean, look,
it
still
would
your
afford
family
more
home
protection.
is...
Yeah.
Your family home is what these days? They're saying, what is the family homes in the asset pool? That's relevant here, isn't it?
That's one of the tests.
Yeah, so that's the current individual wealth test, 2.5 million. So that's a different test, yeah.
Yeah.
Mm. So you're not going to express an opinion in relation to this, but your opinion is, and all of you collectively, is about the consultation process with government. When you say, and this is interesting because I mean, ideally in this kind of technical area there will be a proper consultation process. I understand this point about CAMAC. I have a vague recollection of it, but I didn't realise it was abolished. There's a million bodies in government. Yeah. So it's a long time ago now, so I don't think CAMAC will be coming back.
I think I did express a view in one of our oversight committees around it not being necessary, but we do continue to hear from people that they think it should come back.
I agree, but in this, for the purpose of this legislative change, a body like CAMAC would be, as you point out, ideally placed to provide the government with some expert advice in the technical field. But with the consultation process, what I'm trying to get at here is, you say there's a wide range of stakeholders impacted by any changes to the tests. I mean, are you including, these people that are impacted by these in this definition? Is that what you're saying, that the government should be consulting broadly, not just with the experts, but beyond that into people affected by some of the impacts of the low threshold? Is that sort of what you're arguing in your consultation? Because you've really said to government here, and you're saying to us as a committee, there should be a super thorough consultation process with roundtables, 3 months for feedback, and well publicised. So when you're publicising things, I mean, you're trying to reach less sophisticated people, is what you're arguing here. Is that what you're arguing?
I should probably let Pip speak to that, because I think that was the Law Council.
Yeah, well, whoever's relevant. Sorry, I'm looking at you because you're engaged with me.
Miss Bell.
Thank you, Lena. So, yes, that was part of the Law Council's submission. And when we talk about a broad range of stakeholders, I guess we're sort of talking about the investor population in a way, but also just the different parts of the different industries that are affected by it. And Mr. Clements is well placed to talk about the tax consequences in terms of how these concepts from the Corporations Act feed into the tax legislation and impact the eligibility for particular tax treatment based on the characterisation of the investors in the fund as wholesale or retail. So that's just one example, but there are everybody is operating on the basis of the current legislative model. So if there was going to be change, they would want to be consulted about the best way to implement that change in a non-disruptive manner. If there's anything you'd like me to drill down on more, I'm happy to do so. But that's
Just
effectively
briefly,
what we're
maybe
trying
it's
to say.
for Mr. Hodge as well, but it's I mean, I'm just trying to get down to the. I understand. I mean, ideally there'd be exposure drafts for all complex legislation, and people would have the opportunity to feedback. But what we're getting at here is the changes most relevantly, other than your simplification, you change the definitions and terms, which I think all pretty understandable. It's the tax consequences that we're worried about the most. Is that sort of where we're at in terms of what with the changes?
Consumer protection and maybe to echo Ms. Bell's comments, wider consultation, presumably consumer organisations as well would be another area that you would want to consult with.
But the bottom line is the tax consequences of change. That's what we're sort of.
That's Mr. Clements.
That's
If I could speak to that, the tax rules that regulate managed investment schemes and attribution managed investment schemes are incredibly complicated. There's something like 13 or 14 different categories. They're dependent upon whether investors are retail investors, whether product disclosure statements required. All of those matters are not directly related to the tax integrity of the regime. They're incredibly complicated. But it's an unhelpful observation. The more helpful observation is if you alter them, you change the thresholds and you change the taxing thresholds. The part that is counterintuitive is if you raise the retail threshold, include more in the retail scope, you would have thought that would make it easier to pass the tests. Ironically, it does the opposite.
Yeah, I think that's a very relevant
And I guess my observation is it's really important. I mean, that is not something as a tax lawyer. That's not something I'm going to say. Well, that's not a reason not to do something. It's really if we are going to do something, it's really important that we understand and work through the consequences.
It's consequential, obviously.
So yes, absolutely.
So the unintended consequences of this threshold change in tax terms, and I hear your point about the Tax Act being complicated. That's a very good point you've made there. But this part in particular, I agree that your point about the retail, it would actually ironically have unintended consequences, and therefore, if that wasn't addressed at the same time, it would create.
It would be important to work through it. Whatever test two elements to the question. One is if we change the test, what would that mean? What would that look like to the level of membership and compliance that's required in order to get that appropriate tax outcome, firstly? But secondly, what would be the consequence of the transition? Because there are existing funds that will have a particular tax status that could be impacted by an alteration to a change in the retail status.
In truth, that would require a series of rulings from the tax office, and it'd take some time to bed down, wouldn't it?
It would. I think it would be difficult to do that through rulings. There is a provision so there's scope within these provisions to allow for inadvertent acts of non-compliance. I don't know that that's a good threshold for a long-term maintenance of a structure.
Terrible.
So 2 observations there about change, if it were to happen, from you, Ms Medley, and also from you, Mr Clements. There are recommendations from a range of submitters that any change might need to only be prospective, and that grandfathering the current structures would take away the risk of this inadvertent and unanticipated change. And the argument for grandfathering is pretty clear, and your evidence has supported that further. But going forward, there is the question about consumer protection, sophistication, lack of sophistication, suitability of the current tests in 2024, as opposed to the financial literacy environment of 2002. So would grandfathering address those concerns that I think have been well raised by the Deputy Chair?
Grandfathering would be essential in relation to the implementation of the changes of law so that the existing structures are held harmless.
And people would not be in breach of their licensing
Absolutely,
requirements.
because as Andrew identified, there will always be lots of knock-on consequences in relation to duties, tax and other consequences.
Okay.
And then there would need to be an appropriate period for the change to take effect so that the financial services sector can
create product
absorb
for the new
the
environment.
changes and adapt. Correct.
Yeah, great. Ms Hansen?
Oh, thank you, Chair. I just wanted to return to the Deputy Chair's question before about why should we do this, and to note that this conversation had its origins in the MIS review that was initiated by Treasury last year, which a number of us participated in, and this separate inquiry was necessary because it has the test has broader application than in the managed investment sphere. But the central story that kicked off that MIS review was, I think Ms Smedley mentioned the Sterling Income Trust, which was a terribly sad story of Western Australians being asked to transfer their homes.
Some Queenslanders.
Yeah, okay.
I think Senator
Sorry.
Scarr did a huge amount of work on that with Senator Pratt, so we'll come to you for questions.
The story's
No, we'll come
well
to
known.
questions
I
with you.
won't need to retell it, but thank you. Yes, it was an awful thing. And one of the difficulties in these funds, missteps by the people at a certain end of the industry, is that if the people participating pass this wholesale client test, ASIC has no power to help them by engaging the new design and distribution rules. They have no application to a person who's a wholesale client. The person has no rights to any specific form of disclosure, such as a product disclosure statement. They don't have access to the standard form of complaints arrangements, including in most cases to AFCA, the Complaints Authority, and the form of licence that is required to deal with people who are wholesale clients is a lesser licence, and sometimes wholesale client arrangements can be done without financial services licensing altogether. And that means that people will complain and contact the regulator and say, you need to solve this problem, and they can't. They don't have powers. And so coming back to your point about expanding the 2% to the 16%, that's 14% more of the Australian population where the regulator doesn't have those powers to step up and assist them in a case where the financial services provider is doing the wrong thing. So that, I think, comes to the absolute heart of why we need to do this. And I don't think there's a lot of disagreement among the legal profession that changes would be worthwhile in many ways.
Yeah, but so, I mean, just on that point, because I think it's a good point, we've got submissions that suggest about the sophisticated investor test is too subjective, and you could reform that to have objective elements, training, education, and sometimes what do they call best practice framework. Could that address what you're talking about through rather than some of these other proposals? Is that kind of sophisticated investor test going to be a better way of tackling these things?
The objective tests, the numerical tests, are both an efficient way for service providers to know whether a person's in and out of the test, and if they're set at an appropriate level, a very clear line as to who is in and out. The subjectivity, as I say, has difficulties in compliance for large businesses that want to comply with the law, and is not as perhaps robust as a specific numerical test. And I just wanted to add one more thing on the numerical tests. That $500,000 figure actually comes from 1988 when they first changed the prospectus test from requiring it to be an offer to the public was what required a prospectus, and people said that was too vague. And so Parliament instituted at that time $500,000 as the amount over which you would be considered to be someone who could probably look out for themselves if you had that amount to invest in a company in that single investment. And
1988 is not 2024, is it?
Yes, I put that into the RBA inflation calculator and came out with a number in excess of 1.3 million. So there's some logic
about the
to
price
that.
of a house in an average price in Sydney, for example. So,
Yes.
you know,
Like maybe 5 years ago. It's
well,
gone up. This year
maybe
it's-
in the suburbs that I come from rather than where you live, Mr. Hawke, right?
It's going much higher than that now, unfortunately. But on this point, this is an important point. Again, look, we're not going to. I don't want to have it today. We're not going to get to the bottom line of where we should land on this. But I understand your point about the inflation and the 1.3 million. It's an important figure, as the chair points out. A typical house price, let's say, in a broader sense, than just
absolutely. Yeah.
burning hot suburbs in Sydney. The situation is, though, if you said 16%, 2%, I mean, we can get enamoured with these numbers, but again, you know, there are other factors about there is more sophistication. We have a much more complex financial market now. There are other ways of investing in that 20-year horizon. It's not just we should go back to 2%. And I'm sure that's not your argument. Like that's not the goal. You're saying what is the reasonableness of the threshold is what you're to protect a certain particular set of investors that may not be as sophisticated as that might imply. Yes. But again, but still, whatever level we set it at, I just point, even if we increase that, we'll still be subject to things happening, whatever the threshold is. But your argument is not, I mean, has any work been done on 16.2? I mean, where should we really be landing on this? You know,
the Treasury group that was capably led by Andrew Moore was about to present their report, or they were due to present their report at the end of March to the Treasurer, and that has not happened. That, I think, was going to have some numerical recommendations in it. From discussions with them, I think they were trying to devise what they would recommend, but then there was hesitation, and this inquiry was called to look at that specific point.
We stop Treasury from doing their job. Incredible.
Well, it's clearly, I mean, we can take it from the evidence already. It's a considerable matter of interest, and I think, you know, in the context of the transfer of wealth that's coming and the level of, you know, a 29-year-old with no sophistication really in terms of financial literacy, sophisticated in other ways of the world, but they could inherit, you know, if we take the evidence from Wagga Wagga, $30 million, not an uncommon property transaction. Automatically they're going to qualify in terms of numbers, and ultimately that becomes a crop ripe for the picking. So I guess the whole context is why it's emerged, but I think both the party of government and the opposition have stepped back from action in this space, and this continues this inquiry into a complex and important matter for Australians, from access to capital for the market, from a proper legislative action and simplicity of the law from a taxation point of view, but also from an ethics point of view in terms of the policy that is beneficial for the public good. So we've got all of those rivers running into one another. No wonder there's some interest. I might go to Mr. Senator Scarr.
Thank you, Chair, and thank you to all the witnesses for the work that you put into your submissions. I thought they were terrific, and certainly I think this inquiry process is extraordinarily important. I think the Law Council of Australia, in your submission, note the benefit of having an inquiry that's looking at this in a more holistic manner in terms of these thresholds, rather than simply having an inquiry, say, looking at the tests in a managed investment scheme context. So I certainly endorse those views. So I think this is a very, very important inquiry. I just want to read to you all a submission from 1013, and it's submission 103. And 1013 is an active venture capital firm. It's got more than 700 sophisticated investors. It's based in my home state of Queensland, and they've collectively invested Australian $98 million into 49 technology companies, right? An area where I think we want to promote as much activity as we can and stop the drain of our intellectual property, our entrepreneurial talent to other markets. And on page 2 this is what they say in terms of the impact on the startup ecosystem and economy. A recent survey among 1013 investors indicate that should increased thresholds for net assets and net income as noted above be implemented, and they're talking about the calibration to inflation, so taking it up to say 4.5 million. So if the net asset test went up to 4.5 million, still included the principal place of residence presumably, then 42.4% of their sophisticated investors would no longer qualify as sophisticated investors using the I'll call it the bright line tests of net wealth, and an additional 12.1% would be uncertain about their future eligibility. So you're actually looking at 54.5% of their sophisticated investors at this point in time would either A, not meet the net wealth test, which I note is being recommended by ASIC in their submission. I don't know if you've had a chance to have a look at ASIC's submission. They're proposing an increase of the net asset threshold from 2.5 million to 4.61 million. So 54.5% of their sophisticated investor pool who they've been working with to raise capital for emerging companies in the technology space would no longer be designated as wholesale clients or wholesale investors. From your perspective, and I want to give you each an opportunity to respond to this, we talk about the increase in percentages who fell within the test when it was introduced so many years ago and who now fall within the test. But where the rubber hits the road, you're talking about companies that are out there, venture capital funds, angel investors, who are investing in emerging companies who would, if you increase the tests to the extent that ASIC is talking about, there'll be a whole pool of people. There'll be tens of thousands of Australians who would essentially then be excluded potentially from those investment opportunities. Isn't that the case? So I'll just go right to left. Mrs. Smedley.
Sure, thank you. Yes, if you increase the thresholds, then I'm sure for a number of venture capital kind of businesses that will have a significant impact on their client base, because I would imagine that they would often have a client base who are wholesale at the moment, but they're not necessarily going to qualify as wholesale if there were changes to the law. So you're absolutely right that there will be some sectors within the financial services industry who might be disproportionately impacted by a change like this.
And it's true to say, isn't it? It's not just them, the venture capital fund. It's the companies which get the benefit of the capital which they mobilise and which is invested into those companies, correct?
That's right. So the change would affect the ability of the venture capital company to classify the investors with the venture capital company, and that classification is important for the money to flow into the opportunity created by the venture capitalist, which is then to deploy that capital into, in your example, the tech companies.
Yeah. Mr. Hodge?
I might pass it on for from
Ms. Dulhunty?
Yes, no, I agree with what you're saying. That's absolutely right. And I guess it all goes back to the fundamental premise of how you work out when someone is sophisticated, without meaning to use the word in the legislation, enough to look after their own interests. And I guess if you go right back to the beginning, and I'm more a Chapter 60 than a Chapter 7 person, so it's in the investment bucket as opposed to the consumer protection bucket. You know, the tests were originally set because the 500,000 and the 250,000 per annum and the 2.5 million at the time were considered a way of measuring who could look after themselves and who could not. So if you accept that premise, then you've got to take it forward to 2024, and you need to ask yourself, well, in 2024, what is the right measure, hardline measure, of who is able to look after themselves?
It just seems to me, and this is my concern, it goes back to the Deputy Chair's point about what is the mischief, what is the evil that we're seeking to address here. So if all you did was look at, this was the threshold back in 24 years ago, this is what's happened to the CPA, I'll put these thresholds into an inflation calculator, press the number, well, you'll get what ASIC said, which is increase the net asset threshold test from 2.5 to 4.61 million, increased the product test from 500,000 to 922,000, and increased the gross income threshold test from 250,000 a year to 461,000 a year. Job done, right? But the point is, isn't it, that that simple arithmetic exercise will have a whole raft of consequences across the whole investment landscape, which is going to have an impact on the opportunities which I, as an Australian citizen, have to invest my own money, which will have an impact on businesses that have already been established on certain premises with respect to how these thresholds work, and have existing relationships and may have not tripped up in over decades of performance. They're not in Mayfair, they're not in sterling categories. They've actually been legitimate, well-run businesses, and a lot of these businesses haven't been set up, as I think previous testimony has provided, on the basis of providing services to retail investors. You've then got all this raft of transitional issues in terms of poison pill, I think it was referred to. If you've got investors embedded in an investment structure who were wholesale and now are retail, and how do you unwrap all that? And then at the same time, our thresholds would be materially different from those in terms of our international competitors in terms of the UK and the US. So what's someone setting up a company going to do? Are you going to come here, stay here in Australia, when a venture capital fund like 1013 says they're going to lose 55% of their investors? Or hell, I'll go to the UK, where in the UK at the moment, the threshold, albeit it excludes principal place of residence, it's only about 450,000.
Yeah.
Or the US, 1.5 million.
Or Hong Kong.
Or Hong Kong or Singapore. Yeah. Isn't that the issue? It's just looking at the arithmetic is such a banal it's just process driven, as opposed to looking deeply into the impact on the whole investment ecosystem. Isn't that a fair comment? That was a speech, but you can, if you want to add anything.
Agreed with. I'll just give you
No,
that
I think that's a fair comment. I think that's, but I'm saying the same thing. It's what is the appropriate test. I agree with you that putting it in an inflation calculator is probably not the right way to think about what the new number would be, because there are so many other things, as the Deputy Chair alluded to, that have changed since the original test was set. So really it is what is the right test.
But none of these 54.5% of sophisticated investors through 1013, none of them have contacted me saying they no longer want to be classified as a wholesale client or wholesale investor. So what's the mischief we're trying to address here? And maybe that's a rhetorical question.
May I offer a suggestion on that? I think there are many financial services operators and venture capital firms which operate really well, do the right thing by their clients and deliver great performance. And there are also sometimes some smaller businesses who might be cutting corners and might not be delivering for their customers and looking after their customers as well as they should. So when we're looking at these wholesale client tests, we're trying to work out where is the right balance between allowing businesses to thrive and seek out those opportunities that you're talking about in terms of investing in tech companies, etc., right, but also have sufficient protections in place so that the vulnerable and the consumers who do need the protection have that raft of protection available to them. And as Glenda was saying, then it gives ASIC the opportunity to say, well, actually, we can step in now because we can protect you because you're a retail client.
Okay. Mr Smedley, this is the Oversight Committee of ASIC, and we have the benefit of looking very carefully at how ASIC goes about intervening in certain situations and its success in doing so.
It's enforcement regime. Yeah.
Its enforcement regime. And as the Chair indicated, I had the benefit with a very dear colleague, Senator Pratt, from Western Australia, of participating in inquiry looking at the Sterling disaster, catastrophe. I can tell you that, and I'm saying this in terms of context, complaints had been made to ASIC about Sterling, the investors in sterling were all retail investors. They weren't wholesale investors. They were all retail investors. None of them came within a bull's roar of the net asset threshold test that's been proposed by ASIC. And all of them suffered financial disaster. So the mere fact that someone is classified as a retail investor as opposed to a wholesale client or wholesale investor is not going to prevent people from suffering losses at the hands of those who do the wrong thing. Isn't that a fair comment?
I agree with you. There will always be some unscrupulous operators who won't comply with the laws, and the protections won't always be available to retail clients immediately.
And the flip side of that is, and I just think it's important we get this on the record, it's not the case, is it, that if you're classified as a wholesale investor or wholesale client, you have no protections at all. There are still obligations which are imposed upon those who are offering investment opportunities. There are still things they've got to comply with. The most prominent would be misleading and deceptive conduct laws. Is that correct?
That's absolutely right, yeah.
And in fact, ASIC's actually bringing claims against Mayfair, I'm not sure where it's up to, in relation to misleading and deceptive conduct. Isn't that correct?
That's the key protection for wholesale clients.
And those protections are available today, correct?
Yes.
Is that, and any other comments on that? That those protections are there. We're not talking about once you go over those thresholds and become a wholesale client, it's just open slather. Anyone can do whatever we want. We're talking about an extra layer of regulation. If you want to sell a product, if I can put it that way, or offer an investment to someone who's a retail client, we're talking about an extra layer of regulation. But with that regulation, that extra layer of regulation comes extra cost as well. Is that correct?
Yeah, absolutely.
And with that extra cost comes a decision for whoever's offering that product to potentially retail clients or wholesale clients, a decision as to whether or not they want to incur that additional cost, whether or not they want to go through that additional process of being registered, licensed to offering the product to a retail client. And a lot of those entities, one would think, or at least some of them, would make a commercial decision, well, we're not going to go down that path to offer products to retail clients. So the effect will be to exclude that marginal set, if I can put it that way, that increment of investors which has gone up to 16%, the effect will be to exclude them from those investment opportunities. Is that correct?
Yes, I agree with you, Senator. That will be the impact. And that's why we have to be so careful when setting the balance, to make sure that we're not excluding overly people from those opportunities, but still trying to provide the right protections.
Yeah. Anyone else have anything to offer on that?
Yes,
Ms.
thank you,
Hansen.
Senator. The reason why I had as my number one point in my opening statement that the test for active businesses can be different to the test for other kinds of financial products, such as managed investment schemes, is precisely the concern that you have. I was aware of this concern that small business, small-scale fundraising may be impeded if the thresholds are raised too high. And I think that the fact that these sets of tests, one for investing in a company that's an active business and the other for investing in other sorts of financial products, the fact that they are in different parts of the Corporations Act, they can be separately amended. It allows the opportunity for the committee to consider whether this policy can be nuanced. You can say we need some additional consumer protection in the fund space, and yet companies can still raise
Ms. Hansen,
capital.
can I give you the benefit of some background in terms of my thinking when this issue first emerged? One of the things I was concerned about was it wasn't this committee conflating the two. It was actually ASIC. So when ASIC put its submission into the review in relation to managed investment schemes, they actually proposed the thresholds be changed in both categories. They were the ones who actually conflated the two. Wasn't this committee responded to that in a very appropriate manner, I believe, but it was actually ASIC who said, well, if you're changing the thresholds in a managed investment scheme context, you need to look in the other context without, in my view, adequate consideration of the nuances that you refer to. So I just wanted to give you that background because I agree with you that there is this difference which should be recognised. On the flip side, we have received, and this is the question, which I can put to all of you, we have received advice from stakeholders in the financial services industry, stockbrokers, etc., those who are responsible for the compliance with these laws, that there is a simplicity if you keep the tests and the thresholds the same. Once you start to have different tests and thresholds in different contexts, it does add additional layers of complexity. Do you accept that? How would you respond to that concern?
I think a lot of the concern around that is to do with a very small segment of the market, which is stapled securities. That a lot of the listed structures that we act for will have a company and a trust with the securities stapled. The company is obviously regulated under the prospectus laws and the trust is regulated under Chapter 7. And so there's two layers to comply with. And back in 2006-7, I was involved in some submissions that ended up entering the law to align the two tests. They used to be quite different and now they've been brought in to be the same in part because of that lack of logic and also this question of stapled securities. But if it's, if the answer is do nothing about consumer protection in order to ensure that capital raising for business is still facilitated, there's an argument to bifurcate again and look after both parts of the industry.
I understand that's a point well made. But again, that language, if the choice is do nothing about consumer protection, it's not a question of the current law doing nothing about consumer protection, is it? Because you've got those fundamental legal obligations around misleading, deceptive conduct, etc. It's about layers of protection, and with layers of protection comes associated cost. Isn't that correct?
It is inherently, because of the change in the value of money between when the laws were promulgated and now, it's inherently doing slightly less. That is just the fact of what has happened. We are now doing less to protect people than we were when the laws were first promulgated. And I think a very important law that is disabled by moving into the wholesale-only space is the design and distribution and product intervention powers. Design and distribution laws require the product distributor to actually consider whether they're distributing this investment to the right group of people. And that disappears completely. There's no obligation to do that when all the clients are able to qualify as wholesale. And there's lesser licensing and there's lesser disclosure. You're correct that there's a protection from misleading and deceptive conduct, but the entire range of other protections is lessened. And I think if we
which means there's less cost, which is incurred by the offerer of the investment opportunity, which means potentially there are more gains for the investor. So isn't it a question more of the investor actually understanding that when they invest as a wholesale client or wholesale investor, what the difference is between their protections under that regime as opposed to when they invest as a retail investor and retail client. So if they're fully informed on the face of it, they have to actually do something actively to become a wholesale investor, at the very least perhaps get a certificate as to their net asset worth, right? So they've actually got to do something positive to meet that test. If they're then informed as to the differences in terms of the regulation, why shouldn't they be able to make their own decision in that regard as to whether or not they want to take advantage of a less costly and less regulated investment opportunity, which presumably has commensurate benefit for them in terms of potentially higher returns and being exposed to different levels of assets perhaps at an earlier stage as they evolve. The Apple in its first year of existence as opposed to 20 years hence. Why deprive them of that opportunity, Ms Hansen?
Not all of those people who go into those opportunities are going to be genuinely sophisticated. Some will be quite vulnerable. And there's been a lot of behavioural science research into the question of whether people actually read disclosure that's given to them. And the answer is that generally they don't. There's
The thicker the document, the less likely they are to read it.
Yes.
It's a compliance tool to appear that information is being provided. But can I say, as a former teacher, just because you set reading doesn't mean it gets done, right?
It's the same in the Parliament.
And even for the ones who, it's so
I
true.
can assure you.
And then can I say, even for the ones who read it, doing the comprehension test, sometimes there can be a bit of a gap, right? Yeah. So the tool of a performative structure of verification of sophistication suits the system, but it doesn't actually make human behaviour. And it doesn't provide sufficient friction when a malign actor in the financial space, not a visionary venture capital seeking person who's going to make somebody $1 squillion, who's all above board, but somebody else who's going, great, I need to make some extra money. That for whatever reason, might be just greed, might be an addiction themselves. They decide to create a product, engage people who are unsophisticated, who they well know how to target, and they bring them in, right? So that's the risk bit, that everything we're doing in terms of compliance to try and find sophistication is actually not hitting the mark.
Because people sign things without reading them all the time. You've done it yourself.
Absolutely. No, I do it too, Ms Hansen. I mean, absolutely.
Everybody does.
But I go back to Sterling.
So the question is the right line, using your thing, isn't it? Like, exactly. What is the right bright line is really what we're asking.
Which makes it much easier, I think, for everyone. If you've got, and perhaps is one of the reasons why the subjective tests aren't used as much as perhaps people think they would have been. But I go back to Sterling and your comment, Ms Hansen, about the PDS. That PDS in Sterling was like that. I've read it. I've read the non-recourse loan deed with respect to the tenancy for life, and ASIC read it. ASIC proposed amendments to it, but it was still being distributed, and those Sterling investors, who were retail investors, had all the benefits of the protections. So there'd been additional protections, the DDO protections come into effect. They had the benefit of all those protections and lost, not the DDO, but they were retail investors, so they had the benefit of the PDS, the registrations, responsible entities, etc., and they lost all their money. As retail investors, those protections didn't help them.
Arguably, if DDO had been in force at the time of that the Sterling product was distributed, that may not have happened.
Perhaps. Can I ask some questions about the exclusion of the principal place of residence? Where it's excluded, and you might know the answer to this or not, where it's excluded in overseas jurisdictions, do they exclude both the value of the principal place of residence and any associated mortgage which attaches to the principal place of residence?
I think we might have to take that on notice.
Because obviously you could have an unencumbered $4 million house, or it could have a $3 million mortgage. Are you just taking out the... If you're excluding the asset but not the associated liability, that doesn't seem to make much sense, because otherwise, it doesn't seem to make much sense, but you don't know the answer to that?
Senator Carr, the Australian test requires the accountant to make a certification in relation to the investor's net asset position.
No, I know that. So I'm talking about in overseas jurisdictions, the UK and the US, where they exclude the principal place of residence. The question is, if they're excluding the asset value of the principal place of residence, are they also excluding liability which is specifically linked to that principal place of residence, namely a mortgage? Don't know? Okay. One of the concerns that's been raised by the Law Council in relation to excluding the principal place of residence is you get these periods of time when someone sold a house, so for a transitional period, they've got the benefit of the capital
Yep.
that was invested in the home, but it's sitting in a bank account as opposed to in land. So for that period in time, perhaps they're going to meet a wholesale client test threshold even under the 4.6 million, whatever assets proposing, for that point in time. They can go and get a certificate and then invest. How do you respond to, what are your views with respect, how do you address that loophole? If it is I don't necessarily consider it a loophole, but how do you address that practical issue? Or is it just a practical issue if you exclude the principal place of residence?
So, Senator Guy, you've identified that when somebody obtains a qualifying accountant certificate, that is a snapshot certificate as at a particular point in time, and they could be rich in assets at that particular point in time, and they might suffer some life changes, and their circumstances could be materially different a short time after. But that certificate is effective for 2 years. And so once that certificate has been provided to an issuer of financial products, that issuer can rely on that certificate for 2 years. So I think your question is directed to, should it be valid for a shorter period of time so that it has to be renewed or refreshed?
So that's one potential way to address that issue. Are there any other thoughts on that issue in terms of the practicality of the PPR being in or out?
My understanding is that the Financial Services Council has had a view, fairly long-standing, that there should just be a fixed number, and I think they said that it should be 5 million because of this very point that you've raised, Senator.
Yeah. Well, ASIC's proposing 4.6 million, they've just crunched it through their calculator.
But the Financial Services Council representing the issuers of these products,
well, they're representing a particular segment of the market, I guess. Absolutely, I acknowledge that. In terms of the transitional provisions, if you're going to change these thresholds on a periodic basis, and I think the Law Council of Australia talks about if the CPI shifts by, say, 20% over a particular period, there should be perhaps an incremental change. Doesn't that mean you're going to always trigger these transitional issues? Because there's always going to be a cohort who has fallen within the wholesale client, wholesale investor test, which as soon as you change the threshold, that's going to change. Their position's going to change. So they're going to stop being a wholesale client, wholesale investor, and become a retail client, retail investor. So you're going to have those transitional issues on a consistent basis. Isn't that correct?
And there's really two sorts of grandfathering. There's the implementation period after you pass the legislation, which is often set at 2 years. But as Ms Smedley was pointing out, if someone's invested in a wholesale fund, that the difficulty is going to persist until the end of the life of that fund. You don't. So those types of grandfathering provisions will need to apply permanently. So the test would be, if you entered, and there's tests drafted like this in the Corporations Act already, if you enter the fund on a wholesale client basis, for that purpose, you are a wholesale client forever. Yeah. And so every time the threshold moves up, someone who has entered historically within the test will remain wholesale for that investment,
I understand.
not for all investments.
But,
it's not difficult.
When we say that investment, do we include reinvestment of distributions?
Yes.
Do we include, say, future offerings of that investment through that fund? Where do we draw the line in terms of that investment to which has the benefit of grandfathering?
Definitely distribution reinvestment, because otherwise you wouldn't be able to do it pro rata across the whole fund. But it is a policy question whether you would say new investment should come under a different test.
Mrs Medley?
Thank you, Senator Scarr. Under the current $500,000 test, if somebody invests $500,000 in a fund, they are wholesale for the life of that investment in the fund. So, as Ms Hansen was saying, if somebody participates in dividend reinvestment, they're automatically going to be wholesale for the life of that investment. The tricky bit at the moment is in relation to the qualifying accountant certificates, because they last for 2 years. And at the moment, if you have an investor who comes into a wholesale fund using a qualifying accountant certificate, they need to get that refreshed every 2 years. And if they're not able to refresh it, they have a problem under the current law.
Right.
Yeah. And that is an issue that we've been grappling with in a practical sense. That would be a great opportunity to say, here's an opportunity to clarify the law, make it easier to operate and promote business efficiency by saying, once someone has been regarded as wholesale for a particular investment, they are wholesale for the life of that investment.
Absolutely.
But not necessarily transferable to another investment should their financial situation change.
Look at that again.
And
Exactly.
Mr. Smedley and I just want to thank everyone who made submissions. I think we've identified a lot of things that could be improved, could be clarified, could be addressed through this process, which is really good. Mr. Clements, I want to give an opportunity for, we're nearly at the end, but Mr. Clements, in terms of that issue about this creeping change or periodic change to these thresholds, we've looked at it from the investor perspective in a way, but if you set up a structure on a particular understanding and then the thresholds change every 5 years, what complications would that provide from a tax?
I think it would cause me anxiety, Senator.
We wouldn't want to do that, Mr.
No. Being less flippant, the gateways are so prescriptive within the tax rules. They don't have the sophistication of the analysis that sits within the corporations law, so they can produce random results. Right. So, which is the reason that I strongly advocate for a simplification of the rules that apply to the thresholds that apply to taxing managed investment trusts and attribution managed investment trusts. So there's not the same reliance on tax concepts, corporations law concepts. It would worry me greatly under the existing, if we move to an indexation context, how that would operate and whether that would require, as a proper tax due diligence, to undertake a review of the unit holder status. Because whilst they might be still regarded as retail for the purposes of the corporations law, is that the same outcome that they would have for the purpose of the tax law? And we shouldn't leave that ambiguity when there are significant differences on failing to satisfy these rules. There should be great clarity that when investors go into these products, they know that they're going to have a particular tax structure available to them, and it shouldn't be affected by subtle alterations in the status of particular investors.
Can you give us an example, Mr. Clements? I don't quite understand exactly what you're telling me. Do you want to do some numbers for me?
Yeah,
person A, person B?
Yeah, so to give you an example, the way that the rules operate is if a particular fund has 20 or more retail investors, then some particular rules apply. Ironically, they create higher thresholds in order to satisfy the attribution managed investment trust rules. That is, they must have 50 members in the fund. Conversely, if there were less than 20 retail members in the fund, they only need 25 members in the fund. So what that would mean is if the number of retail investors crept up and moved above that 20 threshold, it could alter the threshold number of investors that have to be in the fund as a whole. So that could mean that the fund as a whole does not satisfy because an investor flips from being retail to wholesale.
Okay.
And I find it hard to explain that, Chair, because there's no sense in what I've just said. That's not a rational explanation of it, but it is the way that the rules operate.
And has this matter been raised with the ATO?
In fairness to the ATO, it's not really a governance issue for them. They do have powers to deal with temporary failure to satisfy it. Yes. But that's temporary because something's happened, not when there's been, say, a systemic change in the nature of an investor. More generally, there have been submissions made through the Financial Services Council in particular about the inadequacy of, the complication that exists around this regime and how it should be simplified for an easier, more coordinated gateway that properly protects and does it in a way that has no impact on tax integrity at all. The distinctions that I've given you about the number of retail investors going from 19 to 21, from my perspective, has no integrity issue associated with it. It's just
an arbitrary threshold
that
is historic and...
It's just the application of an
and actually perhaps detrimental.
Yes, Chair.
Okay. Does it affect capital raising as well as the tax treatment?
It doesn't, because it's only around the status of the fund. It's around the tax certainty that I can give to an investor, saying you will be invested into an attribution managed investment trust. The consequences of failing to be an attribution managed investment trust can be significant. So
there's a variation in the deductibilities or the percentage that's paid on the profit? Or
there are the regime is designed to promote managed investment schemes and provide simple and appropriate tax outcomes. If we don't operate under that rule, we lapse back into arcane rules, just the conventional unit trust rules that are then produce random acts of tax violence because they're not appropriate for today's managed investment scheme. And that's why we've got attribution managed investment trusts, because they're designed specifically for the industry and to make sure that the industry has a really effective tax structure. And you don't want to lapse back into the old regime. You want to stay within this regime,
helpful.
and you shouldn't. There should be certainty of outcome, and the certainty of outcome where you fail should be a consequence where there's an integrity risk, not subtle differences in the character of investments or investors under the corporations law.
okay, thank you. Back to you, Senator Scarr.
We're coming to the end. I've got just one final area I want to provide. Actually, a few quick ones. Just give everyone the opportunity. So we're cranking through our thresholds through the inflation calculator, potentially. The question then arises, and it's been raised by Mr Smedley, 7081, in relation to small-scale offerings, this $2 million threshold. When was that introduced in the Corporations Act?
2001 as well.
At the same time.
Yeah.
So the argument is if you're going to change the thresholds in terms of wholesale retail clients, why wouldn't you look at any other thresholds that had been implemented sometime in the past? Is that the argument?
It is, and similar to your experience in relation to the arguments for venture capitalists, we understand that small, medium enterprises use that small-scale exemption quite a lot.
Yep.
And again, we did a little bit of research to see how things operate overseas, and Australia seemed to be quite out of step with the level of regulation that was applied overseas.
Okay, so we're behind the pack in terms of making capital raising as efficient as possible at that lower, for the smaller end of the market.
Right.
Is that correct?
Yeah.
Did anyone else want to offer anything in relation to that question?
Make an observation that it's slightly out of context in terms of what we're talking about today, but that exemption is particularly important in an area that's close to my heart, which is offering employee equity. And it's heavily relied on in the context of employee share schemes, in unlisted schemes, to facilitate those arrangements. We created specific provisions that were to facilitate the offering of equity in unlisted entities, and they're a good example of where the complexity of the regime that's there to protect the employee investor is so complex that it's not used, because the gateway and the complexity to actually use some of those provisions is so high that they're not used. They more or less become a de facto prohibition. So to your point, in the employee equity world, an expansion of that $2 million threshold, it would be really, really helpful, but also it shows the dangers of creating an over-complex exemption or protective mechanism, which is ultimately then not used at all.
Because in an ideal world, from my perspective, and it should be a realisable world, in that area of innovation, growth, you want to see the employees who are at the start of that journey have the opportunity, to participate in the upside, because no doubt they're making sacrifices at that early stage to work at startups, etc., when they could be maybe working in established companies. So to actually have a system which has the effect, the exemptions actually act as a prohibition, is really harming our ability to reward employees in those startup businesses. Is that correct?
Perhaps extend your point, Senator? It's not just in the startup world. It's also as we move into a baby boomer succession process where you've got significant numbers of unlisted ventures who need the facility to make those kind of transitions to their existing employees. And they're restricted because of the narrowness of those gateways.
Okay, so just to tease that, this is a very interesting point. So just to tease that out, Mr. Clement, you're talking about a situation where you've got maybe a family-owned business, they've got a pool of employees, and they would actually like to retire. The existing owners would like to retire from the business, sell down their interest to crystallise some of the value, and they would like to provide an opportunity to their employees, their trusted employees, to actually acquire equity in the business over time, but those noble aspirations are being frustrated by the operation of the exemption. Is that what you're saying?
Yep. Yes, sir.
Okay. Mr. Hodge, sorry. Yes?
Ms. Bill?
Thank you. Sorry, I'm getting a little bit of feedback. Sorry about that.
Sorry for you,
just
but you're very
wanted
clear on
to.
this end.
Okay, very good. Thank you. So just a couple of very short things I wanted to say. We've talked about how the sterling investors had retail protections and so forth. The Mayfair investors did not, because Mayfair really targeted the low-hanging fruit of the wholesale market, and it was people at the very edge of that 16% who probably would never have become wholesale if the thresholds had not been indexed. And while it is not a bad thing that ASIC is taking action against Mayfair for misleading deceptive conduct, a lot of people lost their money a long time ago. And I guess I'd just like to finish on a much lighter note, where one of the Austin Powers movies, when Dr. Evil travels into the future and seeks a ransom payment of $1 million and becomes a laughingstock. And I worry that people will be laughing at Australia if in 20 years' time the thresholds are still the same. Thank you.
We're out of time, so we might have to put anything else on notice, Senator Scarr.
Yes, that was such a
Great movie.
that was such an effective piece of rhetoric that I don't have an immediate response, I must say.
And it's not just the words, it's the visual on everything, Senator Scarr.
Thank you, Chair, and thanks again to all the witnesses. I think this has been an extraordinarily important process, and whatever happens in this space, we've got a lot of really quality information and submissions on the record for policy makers to reflect upon. Thank you, Chair.
Can I ask you, on notice, I've suggested you might look at the Cairns statements at Chartered Accountants Australia New Zealand, their submission. There's also a submission that has vastly different recommendations from you, that's quite specific, from the Alternative Investment Management Association, by a gentleman called Michael Gallagher. We'll have some evidence from him later. But just to indicate the differences, and he does have some international comparisons in that, he talks about, rather than increasing individual wealth tests, AIMA supports either a reduction in the individual wealth test or the introduction of consent requirements. It talks about Gen Z and younger generations, not asset-rich but potentially sophisticated investors. Also with some of the submissions here mentioned the changing nature of degree-qualified young people who might not fit an arbitrary bright line unless that bright line were to allow them to use their brains as an asset, to enable them to engage with the benefits of wholesale investing, mindful of the risk, right? So, and to invest in perhaps their friend who dropped out in year 2 to go and build some amazing cyber platform that they want to support, right? So the reality of our times, I think, is well expressed in this submission. So can I ask you to interact with that and to, if possible, point out any major concerns that you have, because there's some quite persuasive elements in that submission that holds a very different view. So can I echo the comments from my colleagues here? Thank you very much for the quality of submissions and the very interesting evidence we've had this morning. That will bring us up to morning tea. The committee will now suspend until 10:25. Thank you. I now welcome representatives from the Stockbrokers and Investment Advisors Association and Mr Carl Morris from Ord Minnett. I understand that information on parliamentary privilege and the protection of witnesses giving evidence has been provided to you. So for the Hansard record, will you please state your full name and the capacity in which you appear today? We'll start with you, Ms Huckle.
Michelle Huckle, and I'm the Policy Manager of the Stockbrokers and Investment Advisors Association.
Thank you.
Judith Fox, I'm the CEO of the Stockbrokers and Investment Advisors Association.
Thank you.
Carl Morris, CEO of Ord Minnett.
Thank you very much. I now invite you to make a short opening statement, and of course the committee will have questions.
I'm happy to make an opening statement. Thank you.
Thank you. Ms Fox.
And thank you for the invitation to appear today. Our members include full-service and online brokers, as well as execution-only participants and advisory firms that provide wealth advice and portfolio management services. Our members have both retail and wholesale clients. We provided a comprehensive submission to this inquiry, which set out our reasons for why we do not consider changes needed to be made to the current test thresholds. And while there may be stakeholders arguing for changes to the wholesale investor thresholds, the cohort that would be most impacted, the wholesale investors themselves, they have not been asked if they would be happy to lose their wholesale classification. No change should be made without consultation with wholesale investors to understand the impact on them and their investments. While the wholesale thresholds have not changed for some time, a lot has happened over that time as well. Australians are wealthier and have higher levels of financial knowledge. We hear arguments that the test applied to 2% of the population when it was introduced, and now 16% meet the criteria, and therefore the tests now apply to too many Australians. The current net worth of Australian households is 380% higher than it was in 1989, despite the adult population, at 12.25 million, only being 70.5% higher. It is appropriate, therefore, that the test apply to more Australians. Furthermore, the design and distribution obligations regime has been a game changer in the regulation of financial products, with the obligation that each product must have a target market determination that is fit for purpose. That does apply to retail clients, but that has had a tremendous impact. ASIC's been very active in surveillance and enforcement. Any change to the thresholds that move investors from the wholesale to the retail category could result in a very poor outcome for those clients. The current regulatory framework makes it hard and expensive for retail clients to receive financial advice, and there are too few financial advisors to provide financial advice to all who need it. Indeed, many retail clients have been orphaned over the past few years given the lack of financial advisors. Therefore, clients who are recategorised from wholesale to retail will find it very challenging to find a retail client advisor who can give them the advice they want. They would also become orphaned clients, vulnerable to social media as their source of advice. Since we provided our submission to this committee, the number of financial advisors in Australia who are authorised to provide personal advice to retail clients has dropped again from 15,597 to 15,511. In 2018, there were 28,353 advisors. We're currently in the middle of the Delivering Better Financial Outcomes package of reforms that the government has underway to seek to reduce red tape to make it easier and cheaper for consumers to receive advice. However, we don't yet know if those reforms will have that result. We're also involved in discussion with Treasury about introducing greater flexibility in the education standard that we hope will increase the number of new entrants to the financial advice profession, as currently it's so prescriptive and narrow that only 381 new advisors commenced in 2023. So until we've fixed the process of providing advice to retail clients and created a pathway for more new entrants to the profession, making a fundamental change to the wholesale client tests that may result in wholesale clients being recategorised as retail will have a substantial impact on them. As the Minister for Financial Services has noted many times, there are over 5 million Australians at or approaching retirement age. There has never been a time when access to financial advice is important to so many Australians, and it is so difficult to obtain. A change to the wholesale investor test would compound this difficulty. We've also provided details in our submission about the impact that any change in the wholesale client threshold would have on capital raising, as it would shrink the pool of investors able to participate in offerings both listed and unlisted. Any change to the wholesale client thresholds would particularly impact smaller entities listing on the ASX and the ability of early-stage startups to attract capital through private equity, venture capital and angel investors. Limiting the capacity of Australian businesses to access capital has a concomitant impact on the Australian economy, and we're happy to take questions.
Thank you very much, Ms Fox. Mr Morris.
Oh, thank you very much, Senator. While I was chairman of the association for 5 years and I'm still a member, my views today are my own, and I admit it's after 35 years of being an advisor to both retail and wholesale investors. I'm still an advisor. I'm registered with ASIC and I've completed both the educational and professional requirements. Over the last sort of 23 years, there's no doubt that investors have become more sophisticated and educated. Compulsory superannuation has assisted in the education of clients across many asset classes. My simple view, which I'll flesh out later in the questioning, is that the family home should be taken out of the maths. It's not a financial asset, derives no income, it's tax-free, and provides little sophistication, provides no real understanding of re-loss or additional risk. Most Australians obviously desire to own their own home. However, what the new professional standards has done, combined with the new ASIC authorised register, has created a two-advice market, one for the wealthy and one for retail. It's had the exact impact the government didn't want, that there is not more retail investors being able to gain investment advice. And I could talk a little bit about, I was chairman of Q Super for 6 years as well, about the advice regime that we had there. I can't think of another profession which has the bulk of its members being regulated and educated, and others not. We now have advisors and whole firms that can't or won't advise retail clients. They specialise in wholesale only, and why wouldn't they? As one of my augmented advisors emailed me just recently, on a recent IPO, dealing with wholesale is a piece of cake. We talk, we educate, we get paid. Retail, a debacle. Zero incentive, 100% risk-free advice, don't get paid. But as soon as that stock gets listed, they can obviously buy on the market for retail. Additionally, we now have APRA phasing out additional Tier 1, what's known as bank hybrids, as they are too complicated for retail, but risky for who? It has been a $44 billion investment class that, as stroke of the pen, APRA says that now can't be used by retail, wholesale, professional, or even charities. What we all want is to get the best advice we can for personal investors under any circumstances. But what we also wish is stable and efficient markets. Thank you, Senators.
Thank you very much. I'm just going to commence with a question to each of the witnesses, which refers to another piece of work that this committee is undertaking, which is the inquiry into financial abuse. In the context of domestic family abuse that we've seen, people have raised awareness and horror at the physical impact of people being killed by their intimate partners, but it's led to awareness about what happens post-separation in many of these circumstances, with an escalation of other forms of coercive behaviour, significantly involving financial abuse. The weaponising of product, both product in the private marketplace, but also the rules and regulations of insurance companies, and indeed government entities such as the Family Law Court, its intersection with Services Australia and the Department of Social Services, and also the Taxation Department. So it's everywhere that this problem exists. So I just want to give you that context of the information we've received. And I would ask you, in addition to the excellent submissions that you've provided to us, to think about applying or considering principles that have been espoused by Catherine Fitzpatrick with regard to safety by design principles. Where does safety by design in terms of financial abuse, not just between intimate partners, but perhaps in family trust structures as well, fit into the product offerings that, you know, you're here talking about the sector that's offering an incredible range of products? What risk can you see there, and what opportunities for any reform by your own choice rather than by government edict to improve financial abuse? And is there a dimension of that we need to be aware of as a committee looking at this particular issue, but with that lens also applied? So that's a quan, really, and there's the context for it. You've indicated a number of problems. One of the solutions that's proffered in a number of these submissions is that there should be a grandfathering of the current structures, because you're arguing basically for no change at all. Mr Morris, you've got one significant change, withdrawing the family home as an asset to be considered in any shape or form for eligibility for wholesale status. Would grandfathering resolve a number of the concerns that you've raised about any potential change, Ms Fox?
And I just want to say, first of all, we've had Catherine Fitzpatrick write articles for our journal for our members because we are really wanting to bring that issue to awareness and really sort of do what we can. On the issue of grandfathering, we see two challenges attached to it. One is that the certificate expires after 2 years and therefore everyone needs to be repapered again. So grandfathering has limits, quite significant limits. The other issue is intergenerational inequity. It's already, we see that the younger generation is challenged in terms of getting into the housing market. But we have seen, if we look at the ASX investor study, that more and more Australians are very interested in investing in the equity market. So what we're basically saying is that older Australians who have benefited from the current threshold tests and have generated wealth over that time, they continue to be able to benefit from access to a whole range of investment products. Meanwhile, the younger generation, the Gen Zs, who are really wanting to generate wealth as well, they're going to be cut out of access to those products because the grandfathering means one group of current investors who tend to be people who obviously just through going through the life cycle as you generate wealth, as you sort of get a bit older, they're going to be sort of okay, but we are denying the opportunity to the next generation. And so we're moving the goalposts, and that really, I think, is challenging for considerations around whether we want to facilitate or hinder intergenerational inequity.
Okay. But can I just critique that a little? That the grandfathering that was proposed, and we've discussed this, if people were already in a product, that it would be for the lifetime of the product, so it wouldn't require a, what is it, a...
Repapering.
Yeah,
Accountant's certificate.
CAC, yes. Is it CAC? Accountancy, CAC. Yeah, so it wouldn't require a CAC. So that would deal with that issue. We did have some concerns raised about, being eligible at the moment of the CAC arriving, and then 2 days later perhaps it not having currency. So that's another issue that the committee's become aware of this morning. So if that grandfathering, if you're in a product, were to be in place, that would solve one of the problems that you've just articulated, correct?
It would. If it was for the life of the product, then you wouldn't have the concern of actually how do you judge whether someone is remaining wholesale or whether they've suddenly gone into the retail bucket.
Yep.
And that would be a compliance nightmare for
Yes.
licensees trying to sort of manage that process.
Yep.
So that would address that part of it. It would still mean that the next generation coming through who would have completely different sort of thresholds. It really doesn't address the second part.
So is it your view, Ms Fox, like Mr Morris, that a family home, so if you're a young investor and you got to 250, you're eligible, and you're a young investor, they can get there without having a family home, that you would recommend no change there?
We think it's a challenge to set the thresholds according to what you choose to invest in. And so if you choose to have your assets in your home, that's a choice if you can get into the housing market. But there are others also who might have assets outside of the family home, and they would be advantaged in a way that those who have assets in their family home would be disadvantaged if we excluded the family home.
Okay, so and if you owned your own home outright, then you would have a certain degree of, say 2.5 million, just for the sake of the argument today, but you owed 2.3. What happens currently in terms of eligibility?
If I could jump in here, Senator, the qualified accountant certificate, when it comes to there's the two limbs, as you're aware, there's the income, there's the assets. The assets are net asset test. So therefore you would jot up obviously your assets and your liabilities and net those out.
Yep.
So in relation to your
So the eligibility would be, if you had that level of debt, you would absolutely be ineligible.
Depending upon what other assets you had, it would because
if that was your only asset. Yeah,
that's right.
Yeah. And this is the question. Yeah, go Paul.
Yeah. So
overseas.
So the question is, if as Mr Morris submits, you were to exclude the principal place of residence, would you exclude any loan that's also connected with the principal place of residence. So
Even
under the
business
Chair's
license.
example, $2.5 million home with $2.3 million mortgage, if you exclude the principal place of residence, would you, from the net assets test, would you exclude both the asset and also the associated liability, or would you just is that how it would work in practice? Is that how it works in overseas jurisdictions where they exclude the principal place of residence?
We'd have to take that on notice, Senator. We haven't. I'm not.
I know that's
aware
not your policy position.
Yeah, that's not our policy position,
Yeah.
so we haven't
looked at what
gone
happens
into the
overseas.
detail. And
So-
so on that particular point, I'd have to take that on notice.
Can I ask Mr Morris, in terms of your policy prescription, in terms of excluding the family home, are you suggesting that you exclude both the family home and any associated mortgage with the family home from the net asset test?
Well, I think that'd be the process, Senator, because every widow in Toorak and Mossman it would be a sophisticated investor, so which just obviously isn't the case. So they don't have a lot of those would not have a mortgage. So I don't think a mortgage has really got anything to do with the calculation at all. It's whether you have a family home or not. So the next question that would be an interesting one is if they had a family home and they wish to borrow $3 million against it and use that as an investment, which is probably, is that where you're going?
Exactly. So if say I've got a margin loan or something and I leverage my asset, namely my house, so I've got $3 million in shares. I've also got a mortgage securing that against my home. How does that? How do you look at that? How do you put a circle around that in terms of applying a net asset test where you're excluding the principal place of residence?
Well, I think you'd be a sophisticated investor because the first thing the bank would, you wouldn't be able to get a loan unless you'd had extremely high income because the bank won't lend you the money, obviously, because you've got to have other earnings to be able to pay off the loan. So you'd obviously qualify under that rule.
Mr. Hawke.
Can I just take a different take for a second?
We're digging in here now.
Well, I think we're kind of getting two arguments conflated. I think we're talking about two different types of people. I just want to ask you about the intergenerational aspect first, about the future of these changes, because I think this is a different discussion, like I do. I think we're at a different level there. I just think it's a very important point you're making about this intergenerational aspect. But what I don't understand is you're saying, I mean, by volume, there couldn't be a lot of Gen Zs or whatever generation we're up to now investing in what angel investing, venture capital. I mean, that they just simply don't have the money, do they? I mean, what are you talking about? Very small scale investments, or what are you referring to?
It's not venture capital. I think you've got people coming from that sector this afternoon. They're much more able to add to that. We can talk about the equity markets, and it's individual investors who support the small entities that come onto the ASX. Institutional investors don't support them. It's individuals.
Yep.
And
you mentioned about young people. So you're not making were they separate points you were making about angel investing and venture capital?
I wasn't talking about angel investing. I was really talking about the fact that if we grandfather current wholesale investors, which has been put forward as an argument as to how to sort of deal with the challenge of changing the threshold tests, you've then got a whole other group of people who would want to be wholesale investors, but suddenly the thresholds
so we're saying, they've got to work
higher
and longer.
And the goalposts have moved for them, and that means the current people who have benefited and generated wealth continue to be able to do so, but the next generation coming through, they don't get that opportunity.
And so inherent in that argument is the threshold is not the best way to protect young investors or Gen Z investors who want to...
If we look at where, and I think the issue, and I heard this morning it was raised as well, like where is the harm? Where's the evidence of harm? Where's the mischief that we're trying to address? And the cases that keep getting mentioned are Sterling, and they were retail investors, not wholesale. The other case is Mayfair, and that was misleading and deceptive conduct. And so really we should be looking at products and we should be looking at marketing, and we keep coming back to the threshold tests when actually all of the issues have been around products and around the marketing of those products.
Yeah, great. Okay, so let's talk about that, because I agree. We were there this morning. So the threshold is really not... It was designed as a policy instrument in 2002. It's not so relevant, is what you're saying, in terms of how the market actually operates at the moment. It obviously is a threshold, but it's... What is it designed to do now? What does it do now?
Well, what it is the bright line, and I think that's helpful because
500,000.
No, a bright line in as much as we don't just have full service advisory firms who've got online brokers, and so they need a very objective bright line test. They don't have advisors, so they can't go asking people or doing sort of tests or exams with their investors. But it's more that we keep concentrating, coming back to the idea of the tests as being the issue, when in fact, when we step back and go, well, where have the problems been? It's been with a failure of product, it has been with the marketing of a product. And
But
yet
you
we
still
keep
want
coming
the
back
test
to the
because
test
of the
as
shape
it's-
of the market.
Sorry?
But you still want the test because the current shape of the market,
Yes.
particularly the online brokers, will be excluded if you change those rules.
They wouldn't be excluded, but their investors would be.
Yes. Yes. Sorry. Yes.
And I think your valid point. Most venture capitals, most employees get free shares or options, or because they're getting a reduced salary for the risk of hopefully being in the next Google. So they're not actually putting in. If you think of the early stages of those sorts of businesses, it's family, friends, and idiots normally that are putting in the money.
Yeah.
So. That really is such a small, group.
It's too small for us to
Yes,
really
you can't cover that.
worry about. But so to your point here, so you've made this argument about the family home. So coming back to this one, I think it's a really important question, right? And you're making that as a serious policy proposal. Why? I mean, do you understand why the family home is included in this? I mean, was it originally? Are you versed in the way this regime came together?
I wasn't, but if you think that,
we're all too young. Is that what you're saying?
Things have changed so much over the period. So
Yeah, I agree.
When I first started as a young stockbroker, every client that opened an account opened a margin lending account.
Yeah.
I haven't heard in years anyone opening up a margin lending account. Pre-GFC, Ordinary had about $1 billion in margin lending. I think it's about $300 million today.
Yeah.
Because superannuation has just taken off. That's 80% of our clients really now.
But so you're both of the view, in just to paraphrase you both, that this threshold thing is really a minor. It's really not. It's only going to impact things harmfully, changes to the threshold, and not really provide any benefit to anybody observably.
Well, that's why we say ask the investors, because they're not the ones calling for the change. And we haven't. You said you haven't had any investors knock on your door and say, Senator, there's a problem. And so we've got a lot of people pontificating about why the test should change, but no one has actually asked the people who would be impacted.
Yeah. Okay. Good. Well, so we should move on to something else, because that's your view. Otherwise, we'll talk about that all day.
Could I go to the independence of accountants evidence in your submission? And you recommend that any concerns about accountants' certification focus on ensuring independence from financial services providers rather than changing the threshold of the test. Do you want to speak more to that?
There's again in the commentary often this idea that somehow the certificate just is automatic and then the advisor just sort of pushes the client into being a wholesale investor. And in our submission we talked about the risk practices that are in place in the licensees that we represent, which is fundamentally different. That doesn't happen. However, we do understand that we believe the regulator has concerns that sometimes there is a sort of an automatic process between some accounting firms and some firms, in which case ASIC should be looking at that. That's an independence issue where you make sure that there's no sort of automatic sort of push through in that way. That was what we were trying to raise, that again, instead of looking at the tests, if there is a concern from ASIC that there is some sort of automatic process going on that needs to be more considered, then ASIC should be looking at that, not the tests.
What about the chartered accountants? IPA, CPA, how much responsibility do you think they should have for this? Because they're the quasi-regulators, right? There's ASIC and the TPB, they look after particular groups. ASIC constantly talk about the edges of their remit. I fear that if we ask them that, they would say, oh no, we can't supervise to that level.
Well, it would be difficult for them to,
right,
because they don't have powers in the sense of being able to actually look at how business models are set up, whereas the regulator can look at that. So it would be challenging, but to me it's more if the regulator has concern there. That's really where the focus should be.
I can hear ASIC saying this is beyond our remit, yet everybody tells us this should go to ASIC. Right? The question really is, at a time of intergenerational wealth transfer coming, that there is a honeypot for those who would not act professionally but absolutely act for their own personal interest to exploit those who are not sophisticated, even though they might pass a bright line test. And I think the harm is that there isn't sufficient disincentive for those people who want to cause harm, and that there needs to be some consideration of what's coming down the line rather than everything's in here, it's working for everybody who's in. That's a moment in time now. But not too far down the track, we're talking about this intergenerational transfer. Once upon a time, superannuation was going to ruin the country. Now we're hearing that's what your business is because it has transformed people's access to wealth, right? So given our moment, rather than just maintaining the status quo because it doesn't seem to be causing problems for people who you're representing, I'm asking you guests to consider the common good. What is the challenge with the emerging reality of a different kind of investor? And your argument so far is that young people who are coming in shouldn't be excluded and they're more sophisticated. But that is not the case for everybody.
But it's also the reverse about what the market looks like from the advice point of view, where it wasn't that long ago you had multiple financial planners, multiple groups out there pretending to be advisors. Now we've gone from 28,000 to 15,000.
Hayne had something to say about
that,
right?
Absolutely.
There were a lot of judgy ones in there who weren't really advisors. 12 hours training, online, forget about it. They were not advisors; they were shonks.
Correct. They were selling product, not giving advice.
Exactly.
And that has changed dramatically
let's just sort of take the numbers out of it. I mean, the quality is there, but access to, I understand your point, access to financial advice is difficult for people, right? Knowing the vulnerability of young people who we don't want to exclude, right? We want to give people who have the sophistication opportunities to get there. We've got a bright line test for people who are going online. We've got other tests. One of the things has been education. Do you have thoughts about an education qualification for people to prove their sophistication, which isn't currently the case?
We did look at that. We actually developed a test and we tested it with our members, and they came back and said their clients would be unhappy to have to sit an exam to be able to take advantage of being a wholesale client. So again, my view is I think you need to ask the investors because they're the ones who'd be impacted. We understand that a wealth test, it's not a good proxy for financial literacy. I mean, everyone, I think, has recognised that. But
I guess in your example, your sample is the ones who are already in. And your argument is that it's about how do we get the ones who aren't in. So who's sampling them? Who's saying to young people, Gen Z, for example, who are mentioned in other submissions, would you like to do a course and an exam to give you eligibility to invest in products like this? Who's examining, who's asking?
Well, no one's talking to either the current or future investors about this issue. But also I think who's going to run it? What's the consistency? Again, we would not support ASIC running it. They currently run the financial advisory exam. It's $1,500 per exam. They outsource it. They don't do education. ASIC's very clear that education is not their remit. $1,500 per exam. So again, if we're talking about getting younger people in to be able to invest, asking them to sit in a very expensive exam. So no, I don't know of any survey of potential future investors that has asked them about how they would like to have their financial literacy acknowledged.
You could do it. I mean, you could have a standardised basic test. I mean, they do it for teachers. They do English and maths. It's a couple $100. It shouldn't be $1,500. I mean, that's. I mean, I'd like to run that company. That sounds like you're making a lot of money off that. If you've got an online test for $1,500, I wonder what their cost structure is.
It's called ASA.
Yeah, is it government? I mean, if it's private sector, I'd be very surprised. But I mean, look, I understand the argument that investors don't want to take a test to be able to invest. I mean, look, it's counterintuitive on the human side. But what about a financial literacy, not a program, not a study course, but just a benchmark test? It might help people offering services that they've passed could be part of the structure. I don't know. I know you're not going to be super enthused about it, but
Well, as I said, we looked at it and we explored it. And the chair is correct. It was only tested with those who are already in the system. And how you would get to those who potentially might be investors is another question. But it is something that we looked at. But that was the response we got with those who are already in the system.
Yeah, which is kind of like, I'm already getting this service. You want me to do a test now? Give me a break. Like, I can hear it. You know, there's no way people are going to respond to that unless they go, oh, yes, I like the ones who like the quiz shows and want to push the buttons. You know, like there might be a certain sample in there.
Can I just make a comment? So, you know, the other problem with it is it's such a broad asset class we're dealing with now. Is it a test on what do you know about VC, or is it a test what do you know about hedge funds? Is it a test? And when you open up a new account with virtually any financial advice firm now, you actually have to go through a whole range of things, saying whether you're, you know, an amateur to an expert, you know, what your knowledge base is. And I think, as I said, with the advisor that sent me the email the other day, you know, he said to me, dealing with wholesale clients, a piece of cake, talk, educate, and get paid. That's the job of the advisor.
Yeah, I understand.
Compared to the retail?
Well, the retail, he's saying it's too hard.
It's just too hard to
Too hard.
Yeah.
And you also said, you know, another, you know, valid point with this is that a lot of clients now, including retail clients, actually just want to say, you know what, you manage my money.
Yep.
Right? Here's the rules. Here's, you know, we sit down, risk-adjusted returns. This is how we want you to invest it. We trust you. We're going to pay you a fee to do it. We're going to get a quarterly report or a monthly report, daily report if you wish. You can go online. We trust you to do it. The greatest advantage of that, from our point of view, from an advisor's point of view, is that when a new product comes in, or a new investment comes in, and I'll give you a great example. JP Morgan Transport Fund came in to us, fantastic fund. Our advisors have the managed can say, you know what, straight away they look at their portfolios and say, oh, we're going to put a 3 or 4% allocation to that because we think it's fantastic. Bang, it's done. Imagine ringing up every retail advisor and saying, every retail client saying, would you like to go and educate them along the way? So they miss out. And that's also one of the changes that, you know, unfortunately that's taken place throughout this whole process.
And just back to my earlier point, because I think that's relevant, that, you know, the Minister for Financial Services is on the record as saying many times that in the process of protecting people from bad advice, we've actually protected them from good advice. And so we know how hard it is now for retail investors to get access to advice. And so the idea of taking a broken system and applying it to even more people, that is really what we are concerned about. We think you need to have a retail framework that works, that actually ensures good consumer protections, but doesn't actually make it almost too difficult to actually allow advice to be given to retail clients before you actually think about pulling more people into that category.
And Ms Fox, the other thing that concerns me on this is I just made a list of the companies I've lost a heap of money on. Right, so public disclosure here.
You need a new broker,
investing, and I should say I didn't use Mr Morris to give me advice, but Mr Morris referred to the fact that ASIC now considers hybrid securities to be a certain type of asset class which is too complicated, if I can put it that way, for retail investors, right? APRA, I should say APRA. I should say I wish I had invested in, say, CBA hybrid securities instead of the investment I made in River City Motorway, ABC Learning Centres, Mirabella Nickel. I don't have shares in Star, but if I'd invested in hybrid securities issued by the CBA or one of the top 4 banks, that is in fact less risky than investing on an ASX listed security, which I can just go on through an online broker and invest without talking to anyone, getting any advice, because I think it's a good thing. And that just seems, there seems an illogic there in terms of how we've set up the system, that if you're listed, you have this opportunity to raise money from retail investors, and this view that other investments are perhaps too risky, too complicated, etc., when there's huge risk on the stock market, and that distinction doesn't make a lot of sense to me. I'd just give you an opportunity to. I'm not sure how that impacts on this analysis, but I think it sort of says, as a wholesale investor, there may well be opportunities which are safer and less risky that I could invest in as a wholesale investor than what I can invest in today as a retail investor on market. I guess that's the disparity in terms of the regulation.
Talking about diversification, which is actually really good for any portfolio. If retail only has access to one asset class, is that the point you're sort of thinking?
Well, I think it is that we seem to be, and this comes back to the point about what are we trying to fix here? Because as soon as you become a retail investor, you're cutting down the number of opportunities. You're decreasing the number of investment opportunities. That seems clear, right?
Yes.
And so you're taking away the benefits of being able to invest in other opportunities. And if APRA's taking that view with respect to hybrid securities, there's another investment opportunity which you're potentially losing, which I really don't understand.
I'll give a shout out to my mother. My mother's got 80% of her funds in hybrids. So that's how risky I think it's for my 80-year-old mother. It's 44 billion. What I can't understand is APRA is taking away a whole wedge of investors that is supposed to help with the stability of the market, but it actually increases the risk of the market by taking out a whole range of capital that they now can't go and access. So I thought ASIC was protecting individual retail investors, not APRA.
And Sir Morris, if I can just ask you, in terms of this disparity between the education, the qualification requirements of advisors to wholesale clients as opposed to retail clients, what does that mean for you as the Managing Director Chair of Ord Minnett in terms of, do I hire someone as a retail investor or a wholesale advisor or a retail advisor? Yep. Presumably there's discrepancy in costs then, because of the obligations on retail investors to have qualifications, etc.
Yeah, there's a whole range of things, Senator, in relation to that. And I wish to say that I was one of the first in Ord Minnett to do the national exam. And I also passed the first time too. I wish to say that as
Did I actually give you a mark? Can you disclose your mark?
No, it's just pass or fail. Just pass or fail. Right. I made sure no one knew I was doing the exam just in case I did fail. But thankfully, I passed the first time.
I'm sure it wasn't a close run thing.
Well, no, I'm sure. I'm hoping it's not. But so for a retail advisor has to do the financial advisor exam. They have to have the relevant qualifications, the experience pathway. They have to do 40 hours minimum CDV points a year. And they've also got to comply with the Financial Advisor Code of Ethics. And so Ord Minnett has 270 odd advisors. We have about 5 or 6 that are wholesale advisors. They're so much easier for me to employ. They're so much easier for me to have. And the reason for that is there's no minimum education or qualifications. They don't have to comply with the Code of Ethics. And I don't have to pay ASIC, the ASIC costs, which it's about $2,878 per advisor per year. And I also don't have to pay the compensation scheme of last resort. Or AFCA. So my firm, it's a bit well over $1 million a year that I have to pay for retail advisors. And also they have obviously the greater risk coming under AFCA. Other firms who only deal with wholesale clients don't have to have any of those issues that I have with my retail clients. And so they also...
There is risk though then, isn't there? If you've got somebody in there and you don't know what their qualifications are, you're not sure about their ethics, there's risk there.
Correct. But and those firms, as you can imagine, don't deal with retail, or are not allowed to deal with retail. And so it becomes, when I was a young stockbroker, I had a wealthy client to a poor client, they got exactly the same advice. I had the same education, I had the same research, I had the same everything. So I treated, and we do as a firm, treat every client exactly the same. If you're just working for a wholesale only firm, you cannot deal with retail clients. So that the burden of dealing with those retail clients then comes across to us. And we recently had, I'm trying to think exactly how many, well over $1 billion worth of assets transferred from a major investment bank to us because they no longer wanted to advise those retail clients. They just transferred it to Ord Minnett.
But it does go to our point of don't just transfer that retail regulatory framework onto wholesale advisors because it's a broken framework. The government's trying to fix it through the Delivering Better Financial Outcomes package. which came from the Quality of Advice Review, but we don't know yet whether it is going to make it cheaper and easier for consumers to access advice. And so really we need to fix that framework. I would strongly say we should not just be transferring it across to wholesale advisors.
Which is what you see this would be.
Well, I think that, the argument would be that there should be equality across both sets of advisors, but at the moment one side it's a broken framework.
Senator, at the moment, you have think of another profession: accountants, lawyers, engineers. Doctors. There is no other profession that says, you know what, you're going to build a really flash building here. The architect, the engineers, whoever, you don't need any qualifications. It's really expensive, but you've got to build a little house. You've got to be fully qualified. It's just having two regulatory frameworks. And this is Judith. I know where Judith's going with her argument. My argument is you've actually got two sets of advisors at the moment. One that deal with the rich that don't have to have anything, any education, any of the professionals, not even the code of ethics. Where if you're dealing with retail, it costs you more. It's harder to deal with. It's just a pain. And
the risk embedded in that, does that give you any cause for concern at all, Mr. Morris?
Oh, of course, because the risk is, as Judith said, is AFCA. So we've had a client, a very wealthy client, said, I don't want to be a sophisticated client because I want to be able to see you as a retail client. And we say, well, you're not going to get any participation in any of our placements, sophisticated deals, and you sign the form in about 10 seconds. So
he wants to be sued as a retail client.
Yeah. So his advice from his accountant was, whatever you do, don't sign that sophisticated. We're not going to do that because you should remain a retail client. Because if something goes wrong, you can sue the firm as a retail client rather than being.
He wants to sue.
Correct.
Yeah. So he wants to be sued.
And the thing that we're all missing from this whole argument is, as the Senator's lost a bit of money, he lost it. This is a bit of the other argument. Is we're protecting people that make decisions themselves.
Yeah.
People have got to take a little bit more accountability for their own money, and that's what we say to all our clients. Whatever you do, ring your advisor all the time. The advisor should be ringing you all the time. Don't sort of just hand over the money and just hope for the best. That's the other argument that doesn't get spoken about terribly much about people's it is their own money.
And this is part of the reason why you seek very clearly in your opening statement to have the family home out of that. Is that the security blanket that people really, really need? And then with the rest of their assets, you're responsible for your own and you don't need protection. Is that kind of the argument for that?
It's a very good point. And while I didn't think of it in that way, I'm a chairman of a football team.
Yeah.
And with my 30 players...
I've run across a few of those in recent years.
With the 30 players, the only thing I say to them all, when they ask me for financial advice, just buy a home and pay it off, please. If you can leave this club owning your own home, we've been successful in terms of your financial. But you can imagine, everyone's hitting them up for flash sort of, stock, flash things, and we try and keep it as simple. Get a decent mortgage, pay off your own home, please. Yeah. So that's the first principle.
Go to your, young person, male or female, successful in a football club. Mm-hmm. They have an awful lot of money in a hurry. Yep. They are going to absolutely pass a wholesale investor test. They might take your advice and get the house. Then they are subject to exploitation, really, by somebody who could be selling them anything.
Yep, and I've seen it. But normally not financial advisors, to be honest.
What about accountants?
Accountants, not so much. Maybe managers.
So it comes back down to the scheme, the product, and the marketing of the product.
Yeah, my favourite.
Yeah. That's where the issues have always sat, with the product and the marketing of the product.
And the DDO changes are referenced in some of our evidence. How do you see that impacting the market currently? And does that provide the sort of protections that you think are worthy are appropriate?
Well, thanks, Senator. The DDO, our members refer to the DDO as a game changer. So essentially it's a regime which focuses on whether or not the product is appropriate and how that product is distributed. Now, it is true to say that DDO only applies to products to retail clients.
Yes.
But of course, a lot of products, if you're going to make any money out of a product, most products are focused at retail and wholesale. So if a product is focused at wholesale and retail, they're still captured by DDO. So ASIC has been very, very active in this DDO regime.
Yes.
And if someone issues a product and they have to create what's called a target market determination, which sets out these are the sort of customers or consumers to whom this product is to be targeted. And we're also going to set and play distribution obligations as well. So I think one of the issues with some products that ASIC had issues with was you go and buy a car, for example, and they try and sell you rim insurance. They try and sell you some junk insurance. So that sort of product, that sort of junk product, you buy something at the store and people used to remember, they used to try and sell you extended warranty insurance. You know, and say, oh, look, you know, let's sell you this. So that's the sort of harmful products that they're trying to, get rid of, and they have been very successful in doing that. So Sterling is, which has been referred to, and I think the Senator is correct. If Sterling had been promoted at the time of DDO, ASIC would have been all over it like a rash, because obviously it wasn't a product that was appropriate for someone who only had their own home, was transferring their own home into this scheme and could lose their home. So it's actually been a very effective tool that ASIC has been able to use. And in that regard, look, there are some parts of DDO we don't agree with, and the Senator has raised the issue of hybrid securities. So ASIC has said, under the DDO regime, if you're going to distribute hybrids, it can only be to advised retail or to wholesale. So that means that all these people out here who've signed up to their hybrids in the past through ComSec or NabTrade, and then they want to go and they want to sign up again, they can't do that unless they're wholesale, or they have to go to AudmiNet and sign up and get a client advisor and do it that way. Right. So that's perhaps an area of the DDO regime where we don't necessarily see eye to eye with ASIC on the risks of that particular product. Yeah. But otherwise, DDO, as we say, has really made a lot of changes to the market.
And as Michelle has said, most products, not all, but most actually are sort of for wholesale and retail, which means they're captured by DDO.
Okay. Mr. Morris, did you have anything to add?
No.
Okay. I've got more questions, but I'm sure Senator Scarr has some. Off you go.
I've got, and I'll try and touch on a few matters we haven't touched on before. So, Ms. Fox, you referred to in your submission to the recommendation that was contained in the Quality of Advice Review. That's recommendation 11. Can you just walk through that, what that recommendation was, and how do you think potentially the implementation of that recommendation could address some of the issues we're talking about?
I'm going to get Michelle to answer that,
okay.
Only because I know that she will probably give you more detail than I could even. Excellent.
Oh, thanks, Senator. So essentially this was a recommendation of the Quality of Advice Review, which we agreed with. We thought it was a really good idea. So essentially it was a recommendation whereby if you were going to be a high net worth wholesale client, for example, you had to sign up and say, I will be I agree to be a high net worth client. I know that I can't go to AFCA. I know that I'm not going to get a statement of advice or a PDS. And that attestation we thought was going to be a really, really useful add-on to the wholesale regime. Some of our members actually already do something similar to this. When they onboard a wholesale client, they get a wholesale client to sign up and to attest that they understand that they are a wholesale client and they're going to be giving up these various rights. They can't go to AFCA, for example. So we thought that was a good idea. We supported the recommendation. And we did think that the recommendation was going to be implemented, but then I don't know, in fact, what's happened now to that recommendation, Senator. It doesn't seem to have turned up in the Delivering Better Financial Outcomes package, but we would certainly encourage this committee to have a look at that, because we thought that would work actually really quite well. I think it's more than disclosure, and I understand the Senator's point about disclosure. Disclosure is send people a whole ream of information and hope they read it, will they or won't they. This was really more active. It was an active attestation that you actually sign and say, yeah, I get it, I'm a wholesale investor. I don't get a PDS or an SOA. I can't go and complain to AFCA. I'm wholesale, I'm not retail.
And it goes to Mr Morris's point about accountability, that there is also a level of responsibility then. The investor is actually saying, I am saying that I am capable of being a wholesale investor.
Okay. Isn't there a gap though? I mean, because I understand what you're talking about. Where does that kick in? Like, are you saying anyone could sign that? Or
no, it would only be if they if they meet the wholesale investor test.
So if they met the net assets test currently, they would also then have to sign this. Is that correct?
Have to, or had the option of? Or
well, the recommendation of the Quality of Advice Review was to make it mandatory, and we supported that.
You supported a mandatory thing.
Yes. So in addition to having their awful word, is it, their qualified accountant certificate, in addition to having that certificate, they would also have to sign a separate certificate.
So waving away their rights sort of thing.
But
isn't the argument we're getting from other places, if I'm testing that, I understand that will work for a lot of people, but the reason, well, we don't quite know what the thresholds are being raised, other than it's, it needs an indexation, we need to do it, there's some sort of mathematical thing. But if we're raising the thresholds, the argument being put to us is there's a range of people that are in the sophisticated bracket that are not that sophisticated, that need extra protections, not of retail, because we've had that conversation, but just need more. But isn't that where we come back to the testing kind of idea? Isn't there kind of a layer where, rather than lift the threshold, wouldn't you up to a certain amount or some other threshold say you should pass a basic financial literacy test to become a wholesale investor? And then you'd have a grade where, then you have a mandatory accepting of, that you're waving away your rights. But a lot of people are saying and I think there probably is some validity to the fact that there's more susceptible people captured inside this wholesale framework now. You could say they should know what they're supposed to know, they're supposed to read what they're supposed to read. But look, we test people for all sorts of things. We test, if you don't pass your maths and English, you can't teach. They can be given
if you don't what?
If you don't pass your maths and English, you don't teach. You're not allowed to teach.
That was the case. Oh.
No. You have to now today. You do a maths test and you do an English test. Okay. And if you don't do either, you cannot go into a classroom.
Excellent.
So we do all sorts of things for all sorts of people. So we don't do a financial literacy test. I'm not worried about people, way up this end who are, and they have access to a lot of different advice. But, certainly rather than a threshold increase, is there a role? You've ruled out testing on or education on cost grounds, but let's we can overcome that. If moving this issue of cost, why wouldn't it be valid to have an education-based or a testing-based? I'm not talking. I understand your point about how could you understand everything. You don't have to understand everything. It's kind of like a basic financial literacy test. It's a gate, and so therefore, at least there's another protection for there's a protection here to waive away your rights. Great protection for the people giving the advice. But here it would be another form of protection is the investor has passed a basic financial literacy test. So they couldn't, to your suing point, they couldn't really go to court and say, well, I knew nothing. I was a patsy because I went and passed the test.
Can I just ask? Just as a question, there should be a test for greed. Because for example, if someone invests, more than say 5, 10, 15% into a particular product.
Yes. No, I get your point.
So
I understand your point.
So if it was under 5% and they lose that, who cares?
But Mr. Morris, that could be in the test. Like there could be some parts which said, "Do you understand that blah blah is like not normal financial behaviour?"
So what we're trying to cover is someone that puts in way too much money into a particular thing because they get carried away because it looks like it's
the new big thing.
The new big thing.
Look, but the design, I'm agnostic. It have to be designed by experts. It could be designed. It doesn't have to be. It could be made fit for purpose. There's plenty of. They test all sorts of things these days, and all sorts of things. Everybody in all professions. So people would go into invest. There could be a basic financial literacy test that could be kept up to date that did actually weed out a lot of people. We test in citizenship. We test for all sorts of things about Australia. We test for English competency. We could test for financial literacy in a basic way. Greed could be a subject inside the test. I'm not being funny.
Good echo course.
You could put the examples in. If people can't assimilate what is an outrageously greedy investment and what is a normal one, they may not pass. I think that's a valid point. There could be a few questions on that.
The too good to be true test. I think it's interesting because our member firms actually already, and Carl alluded to this earlier when he talked about that the onboarding process has a whole lot of questions involved, which actually helps to arrive at the understanding of the client. Other member firms have investor panels where they actually sort of look at the capacity of the investor in terms of financial literacy and understanding. They often have a sort of, or others have a matrix sort of that they apply. So in many ways, certainly our member firms are already actually, it's never just a certificate and on you go. There are a whole lot of risk processes that are in place to make sure that the client actually does have the understanding.
And they're competing on the quality of that because the outcomes end up getting spoken about, right? One test might be better than another. But I'm thinking of a young Gen Z, worked at KFC from an outer suburb of Sydney, saved up their $25,000. They've got the university medal. They've got $25,000. You're going to tell them to get into housing. They go, yeah, I want to get into housing, but I want to get I don't want to live at Campbelltown anymore because my work is going to be with a stockbroking company in Sydney, and that's a big travel for me. I want to take my chances banking my brain now, and I want to invest. How can I put my $25,000 into the sorts of products that a wholesale investor gets? At the moment, that person can't get any access at all, which is that kind of investor that we've just been talking about. And that's a form of exclusion. Well, it's also a form of protection, right? So this is the debate, the debate, like how much is an appropriate degree of protection? What are the things that you need to do before you get in, which is why housing, I'm sure, is part of, the asset itself is one of the things we know that it's a very important part of your life. So what's the argument against that? Not that I'm supporting it one way or another. I just, as a for the sake of argument, what's the argument against that?
I don't have an argument against it, which is why we explored it with our members. But as you pointed out, that was only with current investors.
I don't think many of them would be 27, have $25,000
No, I'm just saying. So
invest.
obviously, I don't therefore have an argument against the idea because we were looking at it. So again, it comes back to me. I do think you should be asking the people who would be the potential investors themselves. Part of what we've seen with the current retail regulatory framework is, again, to quote Stephen Jones, in the process of protecting people against bad advice, we've protected them against good advice. Let's not do that again. So let's sort of actually ask people what it is that they think would be fair and relevant for them. As to who would do that, I'm sorry, I don't have a suggestion.
And for those people of the same kind, young with 25,000 rather than, university medal and wants to invest in wholesale investment products, but says, okay, I'm going to back in my mate who's in engineering, who's got the new next best thing. At the moment, they can put their 25,000 in there without anything, and that's the venture capital space that is looking for that kind of investment. But there's risk there, isn't there?
Absolutely, but he can do that. He's not being advised. There's not getting a fee. That's just a risky investment.
My plasterer, 30 years of age, invested in crypto and made enough money to buy a 3-bedroom apartment. So there you go.
That doesn't constitute advice, though, does it?
No, there was no advice involved. It was purely of his own
there
back.
was.
We're aware of many losses on crypto too, aren't we? Lots of different...
I'm just making the point that he made a decision.
Right.
It worked for him, and it doesn't always.
So there is an ecosystem outside of this in which people can already invest, whether that's on the stock market, with things that are supposed to be sort of a bit vetted and a bit more people think are safer, or whether it's in venture capital. Like there is no impediment to people investing without the status of being a wholesale investor.
People can go online and invest.
Do whatever they want.
Do whatever they want. So they can do that anytime.
Yeah.
And they do.
And they do. So what is the purpose of this and the change that we're talking about? What are the ills and the good of maintaining the current status.
Well, Senator, in that particular instance, and I think Mr Morris would probably have a better view on this, but if that person came to you, wouldn't you sort of say, well, why don't you put that into a ETF?
Oh, depending on the person, but it could be a whole range of things. So, the younger you are, the more risk you want to take.
Yes.
Because you've got a lot longer to make the money back. And of course, you don't want to be in making, having a hybrid or something like that at a young age. So it would depend on the person, and of course, we might be, a very risky ETF. It might be, a technology one from the US. It could be a whole range of things. And while I'm just thinking about it, I just want to go back to your point about the house. If you can borrow against your house and have that part of your asset case, you should knock yourself out. That actually shouldn't be that shouldn't be part of the wholesale. It should be part of the wholesale test if you can actually borrow. But a lot of people will not be able to borrow against their own home as they get older anyway, because they don't have any other income, because they've got to be able to show that they can pay that loan off.
So you're saying if I've got a $4 million house in Sydney, and I go out and borrow $2 million against it,
and use that as part of my test, knock yourself out.
Okay.
And the other issue that I do think, well, we haven't mentioned it here today, we obviously referenced it in our submission. We do need to be very careful not to have an East Coast-centric view of the world, because house prices might have gone up in Sydney and Melbourne, but we do need to think about the whole country. We need to think about people in regional and rural areas, and their house prices have not necessarily kept pace with Sydney and Melbourne. So again, if we are thinking, of some sort of, mathematical calculator, just lift the amounts, what is the impact going to be across the whole country?
And Ms Fox, I think, and you might have mentioned it in your submission, I think it's been mentioned in a few submissions, when the US moved to exclude the principal place of residence from the test, there was research undertaken that showed that had a greater impact in terms of capital raisings in regional areas than the big cities. Is that correct?
Was it the UK, I think, rather than the US?
Well, I remember seeing references to the US, but also...
Yes, but it did have an impact on capital raisings.
Yeah, and in the UK, they were moving the tests or changing the thresholds, and then they actually reversed that decision. Is that correct? Can you give us some of the... Are you aware of some of the background to that?
I don't have the detail, but I do know that they reversed it because the consequences were not what were intended.
Okay.
Yeah.
Okay, all right.
I've got a couple of submissions. Thank you very much. So if I can go to you, Ms Fox, I think this might be you. Address concerns about accountant certifications by ensuring their independence rather than altering the test thresholds. How do you suggest that would be done, their independence?
We didn't put any detail in the submission because we actually have not turned our minds to that. It was a question of, again, our concern was that all of the commentary, all of the focus is actually on the threshold test, and there was no consideration being given to the broader context. And we've talked about a lot of those contextual issues today. Yeah. And that for us was another one, that if that was a concern that the regulator had, that there was no independence between the accountant and the firm that was then sort of allocating the wholesale client classification, that should be something that should be looked at. Yeah. So it was really more about trying to raise that there are so many issues here, and we keep focusing on the tests. That actually,
but the quack is an important part of that ecosystem. Okay, that's great. You mentioned dispute resolution, and you encourage wholesale providers to adopt voluntary internal dispute resolution mechanisms to treat complaints seriously. What's the problem there that you're observing?
No, it wasn't a problem. What we were trying to say is this idea that wholesale clients have no protection is not the case, that they are also, our member firms make sure that their dispute resolution processes apply to their wholesale clients as well as to their retail clients. And that's not mandated, but they do it anyway. They actually make sure that they have access to an internal dispute resolution process.
Can you give me a sense of the non-member firms that are emerging?
As in?
Well, you said our member firms apply that standard.
So I'm happy to send you a list of our member firms.
Yeah, but how much of the market is outside your membership?
I don't know. I really don't know. I mean,
Well, we represent, Senator, we represent stockbrokers.
Yep.
Retail stockbrokers.
Retail stockbrokers.
Yeah.
But of course, you've got, outside of that, you've got financial planning firms. And there are thousands of those. So we don't represent financial planning firms. And also there's a lot of investment advice firms, for example. So we represent the great proportion of retail stockbrokers. But of course there's a universe out there with financial planners.
Exactly. And I just wonder how many there are and what the standards are.
The FAAA would be able to, I think, tell you about the number of financial planning firms because they represent financial planners.
And often that's the retail sector rather than the wholesale sector, right? So, but are there wholesale people in there, and are there accountants, chartered or non-chartered, who are effectively providing financial advice, and how significant are they in this ecosystem?
Well, it's been very, very difficult for accountants to provide financial advice, so I think there's probably not that many. That number has decreased dramatically, and again, I think the accounting associations would be able to fill you in on that.
Or the Self-Managed Super Fund Association.
Or the Self-Managed Super Fund Association.
You're seeing them tomorrow.
A little bit like the banks, the accounting firms have sort of pulled out of that advice business. The only ones that we see are ones that are giving advice to accident litigation issues.
Yeah. Given the low cost reality that you described of having a wholesale investment team, I just wonder if there are businesses who set up that you don't have to have any qualification yourself. You can just set it up and off you go.
I'm sure there are. There are probably 3 or 4 firms that I can think of that were prior to those educational standards coming in already specialising in wealthier clients, and it's just made their business models a lot more attractive.
Yes, but I also think of, because we do have a member firm that is purely wholesale, and I know that the advisors there will have a Bachelor of Commerce, a Master of Finance, and they're also CFA. CFA is considered the most rigorous qualification around, so they're not unqualified people at all.
Yeah. I guess the observation and being part of the ecosystem with you, though, that's quite a different sort of ecosystem that they're operating in.
No, not necessarily. We do obviously wholesale clients, but we also do retail. They just do wholesale.
Okay. If I can go to your suggestions in your submission, Mr. Morris, update the monetary limits. It says thresholds for classifying wholesale investors should be revised to reflect changes in property values and financial markets since they've not been adjusted for 20 years.
Yeah, and that's just, I think, what was it, 1.7% of the population, 23 years ago or so, and now it's, I thought I heard a statistic just recently, 11.7 or 16 it is now. Yeah. It just can't be plausible that something 22 years ago would be the same today.
Which is a different view from what was by Ms. Fox.
Correct.
Okay, and why do you hold that view?
Just due to the fact of the increase of the wealth and the number of people that now count themselves as sophisticated, which they aren't. My mother-in-law,
so in your experience,
yes,
having the money doesn't make you sophisticated.
Well, I'll give you an example, Senator. My mother-in-law changed properties recently, and when I went
be careful, Mr. Mott.
Yes, well, I haven't been my mother-in-law in Wordle this morning, so I'll be careful. So when I ran, she moved homes recently, and she asked me to go into her office to help her move some things. And when I noticed the 1 foot pile of ordinate envelopes of her portfolio sitting on the floor, and when I said they're not even open, she said, "Of course I trust you." So and she is a sophisticated widow that lives in Brisbane. So she qualifies on every basis. She's a discretionary client, has done relatively well, obviously, but she just doesn't.
We won't tell her anything different, Mr. Morris.
But she just does not,
doesn't pay attention, not interested.
Not
Set
interested,
and forget.
but she is well and truly qualified to be a sophisticated investor.
Yeah, okay, so there's some arbitrary problems there.
And that's why I said earlier, every widow in Toorak and Mosman is a sophisticated investor under the current rules.
Yeah, So that needs some adjustment because the financial literacy is not adequate. You make that point. You also make a suggestion that we need to combat the gaming of the system, and you mention concerns about financial service providers gaming the system by this classification of wholesales to avoid regulatory requirements.
Yeah, I think we've already discussed that in relation to the extra cost burden and also the extra educational standards. So I know the association has a number of their clients that are wholesale only. You've got a position where our advisors have to do the 40 hours a year, CDP points. They have to have the educational requirements, have to have the professional requirements. So if I was sitting here, if you had a choice between a retail advisor that's registered by ASIC or one that's not, I know which one I'd pick, even though it was said that they might have degrees, they might have a whole range of things. Well, so ours have to. Theirs might, but ours have to have all the educational and professional requirements.
Do you think there needs to be some further harmonisation?
Absolutely.
Yeah.
As I said earlier.
So it's great to have these two very friendly people sitting beside one another with
I
diametrically opposed
was the chair for 5 years, and what we've got at the moment, as I said earlier, we have one set of advisors that have to have nothing, and we've got another set of advisors that have to have everything. There is no other professional services group anywhere that I can think of that has that.
But my point was just that I don't disagree in principle, but the retail one, which is the have to have
don't
everything,
copy something that's not working,
is broken.
Correct.
Don't copy something that's broken.
Okay.
So is your argument, Mr. Morris, premise that the whole regulatory system in terms of the retail investors needs to be fixed first before you do that?
I'll defer to Ms. Fox here, but I just think wholesale investors should be exactly the same as retail. That wholesale advisors should be the same as retail. You've got that system there already. It's working. We've gone from 28,000 advisors to 15,000 advisors. If we're all going to be covered under one, you're never going to get rid of that. That's never going to go.
But it's not working.
Well, it's working I'm in the industry. It's working for me. So, because what it's done is it's actually got rid of all the people, a lot of the people that you think you wanted to.
Yeah.
For us, it's working.
And now it needs to build, but it could be improved.
It could be improved.
So we've already talked about Gordon Gekko. We've had a few movie references. We've had Austin Powers. I'm just going to bring in that wonderful set of sorting hat issues. Gryffindor, Hufflepuff, Ravenclaw, Slytherin and Harry Potter. Is there some room for potential differentiation rather than just this arbitrary, retail, wholesale? Is there some sort of gradation that's might be appropriate to help manage the risk over the course of a lifetime and for people with different levels of education and different life experiences, like suddenly becoming a very wealthy widower, for example? Do we need to bring in Harry Potter and have like the sort of something of a sorting hat that is a graduated level of risk management?
I think it will add further to
complications.
It's a very complex framework already, and that's going to add much more complexity.
We had a client in yesterday that sold a property, made $100 million, and he's never had a dollar before in his life. We're taking him on a 6-month education process. So, he's gone from nothing to extraordinary wealth. Giving money to his children, all those sorts of things. He's already sort of covered within our view. We're treating him like a retail client.
Are you getting him to be an advisor? Sounds like he could.
No, he's 81. He's 81. No, he's definitely not going to be. He's definitely not going to be an advisor. So, but we're educating. We're taking him on the process because we're treating him like a retail advisor.
Right, retail client.
Yeah, retail client. Sorry.
Yeah, and ultimately, would you hope to get him to a point where he's comfortable and you're comfortable with him signing a document to attest to being a wholesale, or is he always going to be a retail client?
He's always going to be a retail client.
Okay, very interesting.
Yeah. Because he admitted to us yesterday he has no sophistication because he's owned one property.
And it's just made.
It's
in the right spot.
Correct.
Yeah, and held on to it for long enough. So your emphasis is that qualified advisors who meet professional standards should be able to classify clients as wholesale investors, ensuring the clients are genuinely understanding the risks involved, and you've just given us a perfect example of that. Now, that involves an ethical disposition, Mr Morris, that might be at odds with financial gain. I do have some concerns about, the contest between an ethical disposition and pure profit making at the expense of anybody, and the concept of the common good. How do we ensure that what you're proposing there isn't unnecessary stickiness in the market, and how do we engender that proper, I think for the common good disposition towards who should qualify for wholesale versus retail status?
I sort of understand the premise of the question, but I can't understand what the downside of having everyone with, lawyers have to have the same, accountants have the same. I can't see the downside of all this.
The argument's going to be cost and unnecessary. That's what it's going to be. It's like, no, this is over-regulating. It's not required.
Oh, okay.
It's going to add cost.
Yeah, no,
and we've got Ms Fox constantly, putting a point of view which is across a range of different submissions that, look, we don't need what retail have got. It's too much already.
Yeah, but retail's bearing all the costs now. So our people are bearing all the educational standards, all the CDB points, all the things that I went through. They're bearing that now, but the wholesale isn't.
But what about the argument?
So the very market that we're protecting are the people that can afford it.
But what about the argument, Mr Morris, that those advisors who fit in that category, they've established relationships with clients over many years, they're trusted advisors, and if you all of a sudden impose those requirements on those wholesale advisors, they might be towards the end of their careers. They're just going to say, I'm not interested, I'm going, right? So we go from a situation where we've gone from 28,000 advisors in 2001 to 15,597, which has fallen to 15,511. So you've got another cohort of advisors who are specialists dealing with the wholesale clients. They might have had long-term relationships with them. They have this imposition put onto them, and they say, well, I'm not doing all that stuff, I'm just going. So you end up with less advisors in the market again. How do you respond?
Orphaned clients.
And orphaned. And when you say, Ms Fox, orphan clients, you mean clients who had a relationship with, say, a wholesale client advisor, and then they're deprived the opportunity of continuing that relationship because their wholesale client advisor no longer can advise them because of this qualification issue.
Because they decide to retire.
Or they decide to retire.
And they can't find another advisor because retail advisor numbers have gone down so greatly that already there have been hundreds of thousands of retail clients who are orphaned, and now more clients would be orphaned because there are not enough retail advisors to pick up whatever would happen if wholesale advisors left the market.
Understood. No, I understand the argument, which is why I'm putting the question. You made the argument very well. How do you respond to that, Mr Morris?
We've just been through that whole process where, only 5-6 years ago, everyone was the same. And our firm went from 280 advisors. I think we lost 10 that retired early, if I can put it that way. We had one lady that retired at 80. She said, I'm not doing those exams. So, we had a few of those. If anything, from our point of view, it actually created a greater basis for us to put on an associate program, a professional program, to have more people coming through, because we were finding it really hard to actually employ new people within the industry, due to the fact that in the old days, when I first started, there's a phone book called luck. Let's how we go. Now that has become a real profession. We can have people going through a real associate program, professional program, to become an advisor over a medium period of time. It's become extremely expensive for us to do it, because this is something that we haven't done in the past. When you go to those other firms, where are they going to pinch their advisors from? They're going to pinch them from me, because they're not going to grow people through, because they can't. They don't have a professional year. They don't have education. They don't have anything. All they're dealing with sophisticated clients. So my business is being rated by them due to the fact that they want my top advisors to go across to them, because life is simpler, because you don't have to have the education. You don't have all the things that I said. So we're creating two different markets. If I was setting up again, I'd only have a sophisticated wholesale client business.
In the current structure.
In the current structure. But 5 minutes ago, we were all the same. Things changed, and their business, well, I said gaming, they've gone to that due to the fact that it's so attractive.
A lower cost option.
Lower cost option, absolutely.
Yeah. And that's the question then is the assessment tool is a critical part of this ecosystem where there might be some challenges. Because if you are good enough to hold a job as an advisor for a sophisticated investment option, you have to have a degree of skills that you should be able to demonstrate. And maybe there's a mismatch between the sort of assessment tool that's being required to be engaged with and what's actually really happening on the ground. I mean, I can understand people going, I don't do the test if I don't want to do the test. You know, that could happen.
Well, that's what advisors
But if your knowledge is already there, clearly in the field, like you're absolutely in a marketplace doing that, it shouldn't be that big a deal for you to actually have some professional compliance.
But it does depend again on, therefore, what that assessment is, because
Yes.
the current one in retail is the exam and the education requirements are purely around financial planning. And so our members who are in the investment side were being asked questions about Centrelink and aged care and insurance, and they don't touch that. They don't have anything to do with it. And they were being asked questions on things that they do not do. So again, we would say the current assessment process is deeply flawed, and the idea of just applying it,
Yes. So I think we've kind of got to a pretty important point there, because the standard is not what is questioned here. It's the methodology to establish the standard that currently seems to be absolutely failing for whoever's in the system.
Because the wholesale advisors are already highly qualified. They often have bachelor and master's degrees, and as I said, CFA qualifications, highly rigorous.
How do you know that, Jim?
Because I've asked them. I've asked our members.
Yeah.
So, because we were doing a lot of research because of the FASEA qualifications. But under the current regime on the retail side, they're considered unqualified.
So there might be a bit more
research. The one thing I know is mine are qualified.
Yes.
Mine do have degrees. Mine do have education. There, I don't know.
Yes.
You could ask them, but I know a lot of these people individually. I know they wouldn't pass the exam.
Yeah.
You know,
And
I
is
grew up with
the
these
exam
things.
measuring the right things, Mr. Morris?
Oh, I agree with Judith in that regard. You know, it was the exam was a shocker. It was terrible.
Right. So that's a pretty interesting little bit of evidence there.
Yep.
Okay. So it's measuring something. Is it measuring what's easy to measure? Is it a curriculum designed to measure particular things of value to a particular cohort that is inappropriate? It's not an appropriate test for the current requirements. So.
But that can easily be changed.
Market.
But it is what it is, and if you've got to have a baseline, and if that's what it is, you know,
everybody should have it.
It doesn't quite come with the textbook. It's a lot more complicated than that.
Yeah.
But if that is the test, that's the test.
Yeah.
Doesn't mean,
And it should
doesn't
be
need
for
to
everybody,
fair.
and it
Exactly.
should lead to less poaching and corruption of the system, as you've
Correct.
described, Mr. Morris. Well, can I thank you all for being here, and hopefully you found that not too painful, but certainly I think informative for the public debate around this, about the issues, and it once again reveals a very wide and disparate range of views about what a good solution for the country might look like. Thanks for being here.
Thank you.
And I call forward our next group of representatives. Miss Horden from the Insurance Council and Mr. Humphrey Jenner from New South Wales Business School.
You did ask me whether or not we could do interviews.
Oh, it's fantastic. Yeah, because I didn't do all my reading until yesterday, really.
It's good, isn't it?
Yeah, it's very interesting. And I'm just thinking from a curriculum theory view, often what gets measured is what matters. Right? That's the curriculum design and the testing design are really important. Okay, so welcome. Nice to see you. Thank you. I understand, I now welcome Miss Alexandra Horden from the Insurance Council of Australia and Mr. Mark Humphrey Jenner, who's appearing in a private capacity today. I understand that the information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full name and capacity in which you appear today? I'll start with you, Ms Horden.
Thank you. Alexandra Horden, General Manager of Regulatory and Consumer Policy at the Insurance Council.
Thank you for joining us.
Thank you. Mark Humphrey Jenner, appearing in my private capacity. I'm an Associate Professor of Finance at UNSW.
Thank you very much. Now I invite you to make a short opening statement. We'll start with you, Ms Horden.
Thank you, Chair. Thank you very much for the opportunity to appear before the committee today. I refer the committee to the Insurance Council submission in response to your inquiry made on the 22nd of May this year. By way of background, the Insurance Council is the national body for the general insurance industry in Australia, representing around 90% of private sector general insurers. Australia's general insurance sector provides protection to some 41 million homes, buildings and vehicles against unexpected events. We generate gross written premium of approximately $66 billion per year and on average pay out $159 million in claims each working day. We understand the importance of all Australians having access to insurance to protect their hard-earned assets and strengthen their resilience as risks from extreme weather worsens. The focus of this inquiry is the wholesale investor and wholesale client test. Our submission to this inquiry focused on the related question of whether the provision of strata insurance to an owner's corporation is treated as a provision of a financial product or service to a person as either a retail client or a wholesale client. Unlike other insurance products, such as car or home insurance, which is usually purchased directly from an insurer by a consumer, strata insurance usually involves multiple parties. Our submission highlighted the complex nature of the provision of strata insurance to an owner's corporation and, as you'll be aware, made a recommendation that government undertake a further review, ideally through the Treasury process, of understanding to develop the most appropriate treatment of strata insurance within the context of the Corporations Act. In terms of the reasons for this complexity, I would just like to highlight three areas. Firstly, there is significant complexity within strata insurance policies and packages. The issue of whether strata insurance can be provided to a retail client is influenced by a range of factors and the underlying use of the strata scheme. In particular, an owner's corporation is a not-for-profit legal entity created by statute and doesn't fit neatly into the retail client definition of being either an individual or a small business. Additionally, the definition of home building under the retail client definition is complex in how this applies to different categories of strata insurance. Secondly, strata insurance products are provided to owners' corporations for different types of strata schemes, such as residential, commercial or mixed-use buildings increasingly. For example, strata insurance provided to a commercial-only building would be unlikely to meet the definition of a retail client. Also, strata insurance can be provided as part of a bundled business insurance contract, which raises further questions as to whether they should sit in the retail or wholesale client bucket. Thirdly and finally, further complexity arises from the interaction between the corporations law and state-based regulation governing strata and owners' corporations. Section 5F of the Corporations Act enables a state or territory to exclude matters from the Corporations Act. Apart from strata corporations in South Australia and the Australian Capital Territory, all other states and territories have applied Section 5F to exclude owners' corporations from the operation of corporations legislation. We welcome the Committee's consideration of the laws and regulations on the wholesale investor test for offers of securities and the wholesale client test for financial products. Given the provision of strata insurance to an owner's corporation raises a variety of complicated issues, we would welcome further engagement on this topic going forward.
Thank you very much, Ms Horden. A very unique and very specific interaction with the terms of reference. Dr. Humphrey Jenner.
Well, firstly, thank you for the invitation to appear today. My background is I'm an Associate Professor of Finance at UNSW and have been for about a decade now. I'm also an angel investor. I'm on the management committee of Sydney Angels, and I've recently been in the process of setting up a nascent wholesale investor fund targeting equity and derivative investments. So I have some experience in this field. So my submission focused on venture capital primarily and focused on the thresholds at which people would be qualified to be able to invest in early stage investments. And in my submission, I outlined two overarching problems with raising the threshold. The first one is really that it would deprive startups of funding. The second issue is we deprive investors of the ability to invest in many good quality investments, whether they're wholesale funds that can't or don't want to pay all of the fees and regulatory burden of being retail focused, or startups. And that's important because at the moment in Australia, investing is really one of the best ways, in particular for young individuals, to get ahead. Good quality investments enable people, particularly with the capital gains tax concessions, to actually make a dent on their future earning potential and their future wealth, especially compared to working for an organisation. As a result, if we're depriving young individuals of the ability to invest, we ultimately are going to exacerbate inequality. So that's an overarching problem. So let's have a look at the thresholds that have been proposed. If they're going to be $4 million or $5 million or more, we'll look at what percentage of people would actually satisfy that. If it's going to be increased to $4 million, 2.4% of individuals would satisfy that threshold. If we're increasing it to $5 million, it goes under 2%. That is going to exacerbate inequality because if we're talking about the top 1% being wealthier than everyone else, then you only allow the top 1% to have access to those investments that are good quality or potentially generating higher returns. That makes the situation worse. So in my submission, it's worth considering the thresholds, but we should actually consider lowering the monetary thresholds and increasing the educational thresholds. And that might be a more calibrated test. So thanks again for letting me appear today.
Thank you, Mr. Jenner. You were here for evidence from the previous participants where there was clearly a very different set of views. Can I come to you first to talk about, because you appear, unless you've had incredible surgery, you appear to be quite a young person, Mr. Jenner, so Humphrey Jenner. So we are struggling with this whole intergenerational divide, and I'm pretty interested in your view that there should be lower income and asset tests and how that intersects with education.
It's certainly interesting. So I'm 39, I guess, for the record. So I'm at that golden older millennial stage, which is probably the one that has managed to coast through avoiding the cost of living pressures without too much of the hurdle. But having younger siblings, I can certainly feel for the issues here. Now, part of the problem that arises, and I teach quite a lot of students, of course, Masters of Finance subjects, undergraduate subjects, you see students who have the ability intellectually to be able to evaluate these investments, but don't necessarily have the ability to financially do so to satisfy these thresholds. The other issue that I've often seen arising, and this to some extent is an observation, is the treatment of assets as either investments or non-investments. So say, for example, we're looking at the housing sector. It's often talked about an owner-occupier versus an investor. In reality, it's all investment. If you're buying your own house, that is your biggest asset. So say we're circling back around to the wholesale investor test. There have been proposals to remove your own house from that test. However, many individuals will invest in their own house, and that is their biggest asset. Alternatively, some individuals might buy a whole lot of studios. Whatever the case might be, there's an investment approach to it, regardless of the asset. And we can see with some of the younger generations, there being a real struggle to be able to access either good quality financial advice, good quality financial literacy, because it simply isn't available. There's been an issue with people being able to provide financial advice or information, and also the ability to get runs on the board. So it's a matter of not necessarily buying a $2 million house. It's a matter of buying a $400,000 studio plus some other investments to really get runs on the board to build wealth. It's a concern that I've definitely seen.
What is the educational threshold that you think is necessary for people to meet in order to be a wholesale investor? And what is your view about the providers of wholesale investment advice not being required to have any qualifications or ethics requirements or professional engagements that would essentially make them licensed?
I probably will start with your second one first, but you might need to remind me of the first question when I circle back to it. So in relation to the second one, the real issue with the retail space is the costs. So I can give you an anecdotal example. I'm looking at setting up my own fund at the moment. I've been doing the signing of an AFSL form to be able to do so. The costs of going retail are exponentially higher than the cost of being sophisticated or wholesale only. What that means is that if you require wholesale to satisfy the same burden or the same bar as retail, a whole lot of newer funds or newer financial advisors simply won't enter the space. And therefore, you'll end up with less financial advice and less access to products. And you can see myriad wholesale funds. Almost literally every venture capital fund is wholesale. If you're looking at many of the other funds, private credit, wholesale. A lot of the derivatives and hedge funds, wholesale. A lot of those funds didn't begin as billion-dollar funds. They began as a couple of people setting it up, needing to bootstrap it from the beginning. And if we increase those thresholds, the ability to bootstrap, i.e. to fund it yourself, perhaps as a second job or a side hustle, that simply goes away because you can't satisfy those requirements without exorbitant cost. Now, in terms of the qualification requirements, I'd also take some issue with this because in some areas, so particularly raising a wholesale fund, you need to get an AFSL. An AFSL isn't magic. The AFSL is given out by ASIC. ASIC considers your level of quality and ability to run that fund. If you're going to rent an AFSL, then the AFSL provider considers your ability to run the fund because they bear the liability of you messing up and expropriating people. So it's not as if there's no threshold. It's just the threshold is a little bit more flexible in that space. In the financial advice space as well, if we're looking at exams, we'd have to consider what is the appropriate type of exam. And you've got a range, right? So you've currently got the RG 146 exams, which are super easy. You can do those in like a day, through to, for someone with a finance background anyway, like they're not challenging, through to CFA, which is a 3-year excursion, if not more, to get the qualification, right? And then you've got the other sector, which is sort of PhD qualifications. One could debate about whether those are useful. So we have to actually calibrate what the real threshold is going to be, and that becomes an issue. And that circles me back around to, I think, the first question, which was about knowledge and experience for being able to invest in these. So currently, if the AFSL provider believes on a reasonable basis that you have the knowledge, experience, etc., to be able to fully evaluate the investment, they could flag you as being an experienced investor. The problem is that then shifts the liability to the AFSL provider, right? Because if the what would otherwise be a retail investor is dissatisfied with their returns, even if they knew what they were doing, it basically creates an issue for the provider. An issue because if that retail investor starts creating noise, or that wholesale investor, sorry, starts creating noise, then it's bad publicity and it's costly. So that means that from a practical perspective, the current situation where a provider needs to evaluate the individual isn't as effective as it needs to be. That means that we need a different way of assessing individuals. Examples that I've seen for this include UNSW has a founders course or an angel investor course. That would only be for angel investors, however, right? It doesn't teach you how to invest in derivatives. UQ, I believe, has a similar type of course. Sydney Angels doesn't have an RTO, so a registered trading organization certification, but has more of an apprenticeship model where people will invest smaller amounts alongside and learn through that process. And they'll also do various different, courses or seminars, like mini seminars on valuation, negotiating contracts and the like. StartMate has something similar where their StartMate First Believers program will take people through the process of investing in startups. Now, in the startup space, the amount of education has increased quite a lot. The examples I've just mentioned. In the wholesale fund space, there is less of that, and you're more reliant at the moment on things like the RG 146 type exams or professional exams like CFA or CAIA, so CAIA, for example, or the university degrees. The appropriate threshold might actually depend on the investment. So, for example, you could satisfy the ability to invest in startups if you've done that startup course. That might be an appropriate way of doing it. So it's almost like asset class stratified.
Okay. So you're talking about micro-credentialing, which could then adjust as different products emerged.
Correct. Yeah.
And a micro-credential provided by?
I would put that it could be a RTO. So well, that actually could end up both of being very broad, because there's a lot of RTOs you maybe wouldn't want doing this.
Absolutely.
But
if that involves paper, they get very cheap very quick, right?
that is correct. So RTO might be not the best threshold. It could be an accredited organisation, maybe one that holds an AFSL, that I would think would be an appropriate threshold. It could also be a university. That would probably be a threshold that might be too high. I.e., if a university provides the course, it probably is going to be satisfactory, but there might be many courses not provided by a university that are also satisfactory. So it's a challenging one. I'd probably not necessarily say RTO by itself, but it would need to be some other form of qualification or certification.
So an AFSL would have some risk, so there would be some benefit in them making sure the standards are met, but perhaps not the AFSL that is seeking to engage the person, so there's not a conflict of interest. So an AFSL that doesn't provide product to that person could provide the education, or maybe a peak body
that could be
for
one
the
way.
sector.
Maybe another way that I've seen sometimes arise is if ASIC certifies that that particular training program is sufficient, in which case the regulator will have given some scrutiny to the training program. And now, of course, it depends on exactly how burdensome getting that approval is, but relying on ASIC in that case might be one path forward.
So Ordminet have just spoken about their internal training program. They offer that internally. They could then offer it as a public offering, as a micro-credential, and ASIC would say, yes, that's a quality program if you've done that. So it's just an additional business for that entity.
Correct, yeah.
Okay, so micro-credentialing is your response to access for younger people or older people who come to decide that they want to learn this knowledge at a particular point of their life, and then they would become thereby qualified as a wholesale investor in a particular class of product.
That's right. So micro-credentialing is also one that can reduce the costs of this, because while I'm aware that I'm sort of wearing the university hat and generating more revenue from this is always nice for universities.
Yes.
You don't want people to have to pay many, many thousands of dollars just to be able to invest. So you want micro-credentials that can be accessed at an affordable price point. And
at a just-in-time moment for the learning curve of that individual as an investor.
Exactly. So you don't want someone to necessarily have to do a full Masters of Finance.
Yes.
That probably is unnecessary for what they'd need for this. But something smaller and more affordable.
Okay, very, very helpful. Thank you very much. Can I go to you, Ms. Horden, now? There's been quite a lot of talk in recent weeks about, you know, the value for money that people get out of Strata. And in your evidence there, you were speaking about the complexity of discernment about whether something's whether it's wholesale or retail, and also interjurisdictional challenges. So just want to give you the opportunity to particularly explore for me building use and bundled products. I really didn't quite understand that part of your submission.
Yeah, so with strata complexes, they have become increasingly complicated buildings over the years. Many years ago, most strata buildings would have been either residential buildings, you know, you see those sort of 3-storey apartment,
walk-ups,
often brown brick, walk-ups around cities, and then you would have commercial strata complexes, often in like commercial areas, suburbs that were primarily for commercial. As we've moved to more inner city living and higher density, more frequently now you see the multi-unit developments, usually with residential on top and commercial at the bottom. So you might have a couple of levels of commercial and a few levels of residential. So those buildings don't fit neatly into the homeowner retail side of things, and they don't fit neatly into the commercial side of things. What you often have with those complexes, so when you've got a strata complex, you'll have an owner's corporation, the not-for-profit entity that owns the common property and the building as a whole. The individual lot owners, in purchasing a lot in that complex, purchase unit entitlements, which gives them a right to a particular lot in that complex. So the owner's corporation is made up of all of the lot owners, and then you'll usually have an executive committee, which is a group of owners that operate and manage the complex on behalf of the broader owners corporation. Now, those executive committees are made up of volunteers by and large, and they're often people with day jobs, busy lives that may not have expertise in running a very complicated building. They may not understand how the building's been put together, the kind of maintenance that you need to do in buildings, particularly in strata buildings, and we're seeing a broad societal shift to much more complicated homes as well. So we have a range of new products and things that we like in our homes. We see problems with things like flexi hoses. I'm not sure if you're aware of flexi hoses, but they enable a lot of the more, I'd say, jazzy plumbing that we have in our homes these days. So rather than the hard pipes, if you have to get around a corner to plumb in your wine fridge in the kitchen, you'll often have the flexi hoses. Now, they're great, but they have about a 5 to 7 year lifespan.
Yeah, and they have a fail rate. Yeah.
And then they have a really high failure rate. So we do see in these buildings a need for owners corporations and executive committees to have a deeper level of understanding of how to manage these buildings. Then you've got the strata managers who often assist owners corporations in managing the buildings. And strata managers, it's a tough job for strata managers. So they need to have a really good understanding of how the building operates, building maintenance. They need to have a good understanding of the legal framework that they're operating in, the advice that they're providing to owners corporations. They need to understand insurance, so they need to have an understanding of whether there's adequate insurance being done. They'll often outsource a proportion of building management to building managers, so they'll be off on the side and they might manage a lot of the maintenance stuff. But the strata managers also have to have really high stakeholder engagement capability, because if they're working with an executive committee that's made up of some investors in the building, some live-in owners, people of differing levels of understanding of their obligations, who may not want to do maintenance, so it may be a cost that they're not prepared to bear if there's a lot of investors in the building, they really have to have the capacity to influence and advise that owners corporation of what they need to do to make sure that the building's being well maintained. So that's another level of complexity there. And then in terms of the insurance that we need for these buildings, given often they are very large buildings, the insurance can be a very complicated undertaking. So we may find that some insurers are willing to insure the building as a whole. Sometimes insurers will only insure part of a building, and so the brokers will need to go out and put together a book of insurance for a particular building if it's a very large one. And they will need to work very closely with either the owners corporation or the strata manager to understand the risks of the building, understand the maintenance history on the building, and then translate that back
into a financial plan to manage it going forward. Yeah, right.
It can be really complicated, and they'll translate that back to the underwriting agency or the insurer if they're dealing directly with an insurer as opposed to via an underwriting agency. So of the Insurance Council members that write strata insurance, some of them do write direct strata insurance, so they go direct to owners corporations, and that's usually, not always, but usually in the smaller complexes, so if you've got a duplex or three homes on a block. But when you get into that much more complicated area of strata, traditionally they're written through, or increasingly they're written through brokers because of the complexity, and it's a big job to get that underway.
So classifications of retail, wholesale, it's not so much an investor issue as a sophistication issue and education issue for the responsibilities that they've got there.
Yeah, absolutely. And whether or not a strata can be treated as a purely retail client or a wholesale client, given that there's levels of advice that they're being provided throughout the chain, would it be appropriate for a very significant complex with a broker involved and an underwriting agency and a strata manager to be considered a retail client? We don't think that there's a clear distinction.
Okay.
And we do have concerns that trying to see this as a binary will end up with unintended consequences either way.
Okay, fantastic. Thank you. Questions? Senator Scarr.
Thank you to the Insurance Council of Australia for its submission. I had no idea there was this application of the use of the distinction between wholesale and retail in the context of provision of strata insurance to owners' corporations. No idea. So that's
niche, so.
it just shows the complexity of this area we're dealing with. I just want to walk through your recommendations so I clearly understand what your recommendations are. So financial product and financial service providers operating in the strata insurance market need to navigate the intersection between federal and state territory legislation and the different obligations that arise depending on their categorisation. So the other layer of complexity is the overlay of state and territory legislation. So that makes it even more complicated. Then you say the current complexities can have ramifications for both the financial product issuer in meeting their obligations, the financial service provider in meeting, for example, remuneration disclosure obligations, and the client, which is presumably the owner corporation. Is that correct?
Yes.
Who's the financial service provider in that scenario?
So the financial service provider will usually be the broker.
The broker. Okay, got it.
Yeah.
Got it. You then say a fit-for-purpose legislative framework pertaining to the classification of owners' corporations as a wholesale or retail client, particularly for mixed-use strata complexes, will ensure the end consumer will receive the appropriate level of transparency, service and protections under the Corporations Act. So the Council's submission is effectively the current legislative framework is not fit for purpose in terms of drawing that distinction or making that classification of an owner's corporation as wholesale or retail. Is that the evidence?
So I think wherever there's complexity in grey areas, clarity would be helpful for those consumers that need it. Yeah.
Okay, so there's an opportunity to improve.
To provide that clarity.
Okay, to provide that clarity. How do you provide that clarity in a practical practical sense, right? So I'm trying to better understand what the fix is, the legislative fix, because it all comes back to legislation, right, ultimately for us. So you all get together, stakeholders get together with ASIC, Treasury. Is this an easy fix, or is it just going to become hugely complicated, especially in terms of these mixed-use developments? How easy is this to achieve?
Yeah, unfortunately, I think it will become hugely complicated, and to an extent that's why our submission may be a bit unsatisfying, frankly, Senator, in that we don't have a clear this is what you need to do to get to the outcome we need to get to recommendation for you. And we have been grappling with this for some time. I know that the Insurance Council's members and others have been grappling with this for some time, which is why we think that a formal consultation process run by the Treasury would be sensible, so that we can really hash out these complexities and have a very sensible conversation about all of the different elements that might need to be considered. So I suppose I wish I had it's this simple answer for you, but unfortunately we don't.
So from our perspective, or at least I'll speak for myself, I'm sitting here thinking, right, Treasury's only got so much bandwidth. The Parliament only has so much time to try and deal with some of these issues. At the end of this whole process of consultation, etc., it still may be complicated, which begs the question, is it better just to leave the existing complication and grey area and recognise that people are making decisions, reasonable decisions, and given the complexity, given the grey area, and just leave it be, rather than go down this consultation process to try and fix what's a wicked problem, if I can use that phrase. And I guess in terms of assisting me to come to a view in relation to that, what are the practical everyday consequences today of the existing system in terms of how your members are conducting business. So is it a concern that they're breaching laws at the moment, but that those laws aren't enforced? So there's sort of a recognition of these grey areas and we're not going to enforce the law in this area? Or is it a question of cost, your members incurring additional costs which really has no practical benefit, but that's what they're forced to do because that's what the law says they have to do? How would you convey to us the magnitude of this issue on a practical day-to-day level?
Yeah, so I suppose there's a couple of points in there that are worth considering. Whether or not you get to the end of this process and decide that clarity on the retail wholesale client test for the purposes of Strata is significant enough a priority to task Treasury with it, I wouldn't preempt that for the committee. But it may be that you get to the end of this and decide that's not the priority this time. So we'll kick it off, and
understood. And I'm just trying to tease it out in my own mind because I'm trying to work out where we are now. What are the downsides of where we are now from a practical point of view in terms of your members, owners, corporations, and if we engage in that consultation process, put all that effort and energy into it, is there an endpoint which is going to be better? Materially better to where we are now?
So there's always a risk where, so the regime as it currently stands, our members are confident that they are doing the right thing by their clients under the current regime. There is always a risk in changing any regime that there will be an unintended consequence of a change that members will then have to change their operations. Changes in operations add friction costs into the system. We're acutely conscious that insurance affordability is an issue for a number of consumers at the moment. So we would not want to add any additional friction into the system that may make the provision of insurance more complicated or more costly for consumers. We're also acutely conscious of the current commentary around strata insurance and the commissions and fees and charges that are occurring throughout the supply chain. And again, we would just urge caution that a knee-jerk reaction or a reaction that's not thoroughly thought out about all of the potential unintended consequences to try to deal with a problem that is occurring doesn't have flow-on effects throughout that supply chain. So again, in perhaps an unsatisfying answer, we're urging caution rather than providing a specific recommendation one way or the other at this stage.
Okay. I'm going to press you on this point because I'm just and feel free to just tell me you don't know or whatever, or you want to take it on notice. What's the economic cost of the existing system compared to a system where we clarified all these issues and went through the process, in your view?
So that would be hard to tell you what an existing system would cost unless we know exactly what that looks like, obviously. I don't have the numbers to hand.
What's the potential benefit? Is this material? Are we talking millions of dollars of benefit, or...?
I would need to speak to our members.
Could you take that on notice? I mean, I think it would be helpful, Chair, if we've got an appreciation of... so if we can save people living in these strata complexes $50 a year on their insurance or $100 a year on their insurance, well, that's a
money.
Good thing, right?
Yeah, absolutely.
So, but it'd be good to get that feedback as to the magnitude or the prize, if you like, at the end of going through a consultation and a legislation process. So, would very much appreciate that. Thank you. Dr. Humphrey-Jenner, I'm very impressed with the fact you engaging in that crossover between academia and actually setting up a wholesale fund. That is really, really impressive. So send me the details. But congratulations. That's a really inspiring thing for you to do. And I think your testimony's also put another context or perspective in relation to the issues we've been considering. One of the points you raised, and we haven't teased this out so far, is, and I quote from page 4 of your submission, the income and assets test can also penalise people who are returning from work, who work part-time, or who have assumed caring responsibilities. So you might well have a professional woman who has served at senior levels in various financial services firms, professional services firms, who was earning a salary north of $250,000, and because they're on maternity leave or choose to take parental leave or just be out of the workforce for a particular point in time, they're penalised because they're not actually earning that income, whereas engaging in this sort of investments may well be an extraordinarily fruitful time for them to do it when they don't necessarily have the obligations of employment. So there's that disconnect between the realities of modern life, especially for women, as opposed to the application of the blunt instrument of this income level test. So I'm wondering if you could expand on that.
Before you do, can I just add that it's not just people who have skills in the financial services.
Correct.
I was literally on maternity leave where I started to investing in property.
Yep, absolutely.
As a teacher, but because I had a little bit of headspace to actually do the thinking. And of course, if you teach, you can read, think, etc. So there are multiple professions. There would be nurses. There would be people who are running their own business, kids who left school in year 10 who are running their local auto electric business, who have grown their skills in terms of financial management powerfully since they left school. So it's all of those people at a moment in time with not a necessary financial or law who could be interested. So I want to sort of add that in to
No, it's a very good point.
Senator Scarr's excellent observations.
It's a very good point, well made, Chair. So over to you, Dr. Humphrey, Jenna.
Yeah, that's absolutely right. As an aside, one of our most promising startups was actually founded by someone who didn't go to university, came out of Hunter Valley, started up a mining safety company called SafeGauge, and he would have developed a lot of skills over that time. So it's not that one necessarily needs the university education or even that traditional background to be able to invest. In relation to, I guess, people who are part-time, I mean, statistically, it's more likely to be women who are part-time, who have taken time off for caring statistically. But it could affect either men or women, but whoever is affected, it creates an issue because of two underlying things, I think. Firstly, it's worsening that type of inequality. So, for example, say we're concerned that women have less superannuation on average, for example, or maybe not building up as much assets on average. Well, then if they're further deprived the ability to invest, it makes that worse. The second issue is many of those women will have skills, expertise, or the ability to contribute to startups. So specifically in the startup space, it's often the case that angel investors or venture capitalists will attempt to contribute to the startup, whether it's through a lot of additional input or through slightly more hands-off, but meeting every quarter, every month, whatever the case might be. Maybe there might be a board position or a board observer position. So if you've got a highly skilled woman in this scenario who maybe went part-time, well, those startups are now not going to have access to her expertise because she won't be able to invest, because she won't qualify as a wholesale investor or a sophisticated investor. So it creates problems on both ends of the spectrum, I think. And it's something that could be addressed in a few ways. One that I've seen proposed, my preferred way is to lower the income and assets test, to lower the thresholds. But another way that the United States does is they allow effectively family pooling. So, for example, you would have both the husband and the wife, or the man and the woman in this case, or the partners who are in de facto relationship, or whatever the case might be. They would be pooling their assets together. And in that case, in the US, I think I have it here, it's, for example, joint income is $300,000 US in the US, and individual income is $200,000. So there's a slightly higher income threshold, but if it's a partnership, two people in a partnership filing together or agreeing together, then it's only a slightly higher threshold. So that'd be one way of doing it. Similarly with assets, that could get around it and help to reduce that type of inequality.
Right. So, and this point you made, which I think comes strongly through your submission, that it's in terms of the angel investor space, it's not just the opportunity for the investor, it's also the opportunity for the company or business that's raising capital. They're deprived of establishing a relationship with an angel investor where through they can get the benefit of that angel investor's experience, of any of the categories the chair referred to, catching up once a week for a cup of coffee. How do I deal with this? I've got this dispute. I'm dealing with this supplier. How should I structure this arrangement? How can I protect myself in this way? How do I resolve this issue? I mean, I can think of just the huge multitude of issues a really good angel investor can help a startup business with, including a startup business by young entrepreneurs or entrepreneurs from culturally and linguistically diverse backgrounds as well, who are looking for that guidance. So when we look at this ecosystem, investment ecosystem, your evidence is that we need to consider more than just the capital that's invested financially, but also the assistance which is provided practically to startups. Is that correct?
That's correct. And I think one thing I do want to add as well is that, say we're taking our scenario where, on average, women are perhaps more likely to go part-time for caring responsibilities, at least historically. One other slightly less direct downside of excluding those from sophisticated investor tests is you'll have fewer female investors. That has additional downsides for the ecosystem, because it's been observed in the literature that when you've got more female co-investors, it helps to de-bias male investors, so that the male investors are then going to invest in a more, I guess, equal way, a more de-biased way, by working with more female investors. It would also help to increase access to funding for female entrepreneurs. Now, the mechanism of action there is through de-biasing and ensuring a de-biasing of male investors. Not necessarily that they are going out and finding female investors per se, but ensuring they are given an equal opportunity to raise funding. So we need to be careful about exacerbating gender inequality in the investor space as well.
Because that's an interesting point you make about the way and I think Sydney Angels talks about this, that you have this sort of club or syndicate that's set up comprising particular angel investors, and there's an ecosystem, if you like. There's a culture, presumably that's established by each of those groups, and if you're excluding women from that opportunity, then you're necessarily also changing the way in which that club may operate in terms of identifying opportunities, in terms of making decisions as to which startups to support. So that's an additional layer of potential unintended consequence that might flow. Is that correct?
That's right. And you want to ensure that as many different types of perspectives both can invest, but also contribute those perspectives to the other co-investors, which helps to increase the productivity of both the group and therefore the startup.
Yeah, 360 degrees vision is better than everybody pointing in the same direction.
Exactly.
I'd have to chair in my investment club if I ever set one up.
Well, the post-retirement semester, let's have the conversation.
Well.
Sounds risky to me.
We'll make you do the micro-credentials.
I'd rather Mr. Morris like it. My last question to you, Dr. Humphrey-Jenner. Are you aware of what happened in the UK in terms of, and I've asked this question to a few witnesses, they went through this long consultation process over 2 or 3 years, I think, looking at these thresholds. They changed the thresholds, and then all of a sudden the angel investment community, startup community, basically said, goodness me, you've just destroyed this whole investment market. You've got to reverse it. Do you have anything you can tell us in terms of what happened in the UK?
And on the US, because there's a regional bit that you put in there that we haven't got on the record yet as well.
Yeah, so in the US, as I understand it, when they excluded the principal place of residence, that had a disproportionate impact on the regions where, again, the pools of available funds are less than in the big financial centres. So again, it comes back to these issues of unintended consequences.
True. I think the US one is the one I'm probably more familiar with than the UK. And in the US, there was a raising of the threshold, for example, excluding the family home from the net assets test. And the issue is that reduces the number of people who can invest, which has an effect across the board, across all of the states in the US. But the area that's going to be particularly felt is the regions. And it's felt particularly there because you've got fewer investors who are looking at regional locations. And that means you're less likely to get a critical mass of investors to invest in a startup. Because to invest in a startup, you don't want it to just be one person, ideally. You want it to be a group of people, if it's angels, or a group of investors, if it's VC funds. Because then you can pool together knowledge and expertise. It helps to de-risk it rather than just having one person there. So if, for example, your angel pool goes down from 10 people to, even if it's 8, that's not a big reduction, but say it's 5 to 4, in percentage terms that's the same. But you end up with the critical mass not necessarily being there, depriving the startup of funding just in numerical terms, but also potentially not even meeting the threshold to get invested, because investors won't be able to pool that type of expertise. So in the US, there was a disproportionate effect, particularly in the regions, particularly in areas that were already having difficulty raising financing. Now, in Australia, one could probably expect a similar outcome, possibly worse in some cases, because it can be more difficult to get to the regions here because of the geographic distances. So Newcastle's not that far away, but some of the other regions, so Mudgee, for example, that's a 5-hour drive from Sydney. It can be difficult to even sort of do physical due diligence, even just once as part of that investment. It can be difficult to get the people to do that. So that's the downside there.
So I was thinking about endangered species, right? Just as you were talking, if you go from 10,000 of a particular species to 9,000, well, that's a worry. But if you go from 1,200 to 200, that can be cataclysmic. Yeah. That's the sort of phenomenon you're talking about, yeah?
Precisely, particularly in more regional areas which already had difficulty accessing funding.
Yeah. Okay. And sorry, I interrupted. Your next point?
So I can't remember what my next point was.
Sorry.
I believe I might have already addressed it. The UK I'm less familiar with, but the UK has a slightly different structure where it's easier to satisfy the experience test than in Australia. Yeah, okay. So if you've made, I believe it's 2 unlisted investments, then you can satisfy it. If you're a member of an angel network, you can satisfy it. If you're a director of a fund with more than £1 million in turnover, you can satisfy it. And also it's self-certification, which has pluses and minuses. The plus is it reduces the regulatory hurdle, and the liability cost for the financial services provider. The obvious minus is, and I guess let's just be blunt, people could easily just tick, yeah, I'm a sophisticated investor, and they're not, because it's self-certification. And there's nothing to necessarily stop them doing that.
Okay, right. I might leave it there, Chair.
Thank you. Can I just ask one final question? What's the failure rate of, these innovative businesses where they've got angel investors or where venture capital happens?
I would probably need to take that on notice. In terms of precise numbers, I couldn't tell you. But what I would remark is there are differences between investments made just kind of randomly, for example, on a crowdfunding platform or done almost willy-nilly versus those done as part of an organized group with actual due diligence. So, for example, the failure rate at a Sydney Angels or a Startmate or an Airtree Explorer type group is going to be much lower because you've got a group of people, all of whom are doing due diligence. So in Sydney Angels, often you'll have IP lawyers, you'll have medical professionals as part of the group, financial services people are actually in the minority. In Sydney Angels, it's often people with other operational experience. And that due diligence piece reduces the failure rate. I've had some failures, but the goal is to try to offset those with companies that do well. So there's quite a lot of skewness.
So in that context, with and venture capital then is another area. And I don't know that we're clear on the failure rates, but we can ask further witnesses. right now in Australia we are in a housing crisis, with the government trying to pull every lever it can to increase supply and get things going. We've got very significant concerns amongst cohorts of all ages. Women over 55 can't get, we've got young people trying to get in. Is Wholesale Investor an opportunity for them to grow some money, perhaps to get in? All of these questions are swirling around. But one thing's for sure is people don't want people to lose their houses because they are easily able to be guided by somebody of malign intent or even good intent who just hasn't got the skills into a high-risk product. And this is why we have this differentiation of retail and wholesale investors, because for some Australians, it's like, no, we don't want to see our son, daughter, grandma, auntie, mother, brother get caught in this and lose their house. So is there something about housing, because you've mentioned it, taking the cost of the house out change the dynamic? Well, it did, obviously it would, but is it still something that's worth doing, keeping the house out of it, because there is a profound intergenerational social good of somebody keeping their house, even if they lose everything else, because it's stability for them, it's a roof over their head, it's security for their family.
So I guess that's a normative question to some extent. I can remark on the US situation. So in the US, their threshold is $1 million US, excluding the family home. Now, the US has different property prices, so maybe we're comparing apples and oranges to some extent. But that's approximately 1.5 million Australian. So in that case, exclude the family home and reduce the threshold, you might end up in the same position as we are at the moment almost. But in any case, if one were to invest in startups, one way that one would be, how will I phrase this? It's difficult to enforce the way of doing this, but people would be well advised to diversify. I.e., say, for example, they had $25,000 that is their life savings and they could save that toward a deposit, or they could put that into a risky startup, then I guess it is a decision for them what they do with their money. And I can't provide financial advice per se, but they should definitely diversify that $25,000, so not all in one startup. That's where, to some extent, angel groups can come in. Now, again, it sounds like I'm plugging angel groups here, but with angel groups, you can invest like $5,000 into a startup, meaning that by virtue of being in a syndicate with other people, the check sizes are much smaller, which means your risk of losing all of your money is much lower, which helps to offset that problem where someone's spent all of their life savings on a risky startup that didn't go anywhere. The due diligence piece and the diversification piece really helps that. So in that case, circling back around to the inquiry, one would wonder, well, if an ASIC regulator or ASIC agreed or ASIC certified angel investor group is part of it, maybe the requirements are slightly lower or different, like is the case in the United Kingdom, where the assumption there is there's a greater level of due diligence and a lesser need to invest large checks. That can help to mitigate it. In terms of the housing issue, that's again a tricky one. So it depends on how one is approaching it. Often individuals should consider, as an aside, getting runs on the board. So whether it's buying and rent vesting a studio at $400,000 in King's Cross, which gives them a yield, gives them an asset, and then they could potentially sell that asset for a house later on, or they could build up a portfolio. That will help people get runs on the board without having to save up for like $1.5 million property. It's not necessarily a perfect outcome, but it's one way of getting some movement there. Slightly tangential, that would then lead to the housing inquiry, which would imply that you should not touch things that are going on as have been circulated in the media. Because if one regards house prices as so high at the moment, it's very difficult, then the best approach is rent vesting, which means we would get more people investing, which would mean you wouldn't want to reduce capital gains tax discounts because then you're penalizing people who are trying to get ahead. So ironically, you probably actually would want to not change those levers. But that's a slightly different tangent and probably a different inquiry.
Yes, but that's all very interesting, and you can see the level of sophistication that's involved in every part of that scenario. So thank you very much for your evidence today, Dr. Humphrey Jenner and Ms. Horden. We very much appreciated you bringing those insights to the committee. The committee will now suspend for a lunch break until 1:45. Thank you. Thank you very much. The committee will resume, and I now welcome Ms Cheryl Mack from Aussie Angels, Mr Adrian Bunter from Sydney Angels Incorporated and Mr Rob Davis, who's appearing in a private capacity today via teleconference. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full name and the capacity in which you appear today?
Sure. Cheryl Mack, and CEO of Aussie Angels.
Adrian Bunter, committee member of Sydney Angels.
And Mr Davis?
Okay. Rob Davis. I'm here in my personal capacity, but I'm also a chair of the Southwest Angels in Western Australia.
Thank you very much for being here with us today. I now invite you to make a short opening statement, and of course the senators and members will have questions.
Great. Sure.
Ms Mack.
Awesome. Thank you so much for having me. So we, Aussie Angels, represent over 2,700 individual investors, 1,700 of which are wholesale, and over 85 early-stage technology companies that we have invested in. Aussie Angels supports angel syndicates and small venture capital funds to operate. We provide a platform that manages the admin and compliance involved with running a syndicate or VC fund. To date, we have supported the deployment of over $20 million into Australian startups. We are dedicated to democratizing access to early-stage venture investing. Earlier today, Senator Scar, I believe, raised the question of what mischief are we looking to protect against? None of the 1,700 plus wholesale investors in our community have told us that they need or want further protections. On the flip side, over hundreds of the retail investors in our network have persistently reached out to us asking how they can qualify. Not because they think they can get rich quickly by investing in startups, but because they have educated themselves on building personal wealth and venture capital investing. They have made determinations of their financial goals and understand risk versus reward and want to utilize a broader range of investment products to meet their long-term goals. Earlier today, I believe Michelle or Judith said that no one was talking to or surveying the current retail investors and young people who want access to wholesale products. I want to say that I am. We have surveyed them. They reach out to us and we talk to them. I have countless examples of retail people reaching out to me, emailing me with long emails detailing their experience, knowledge, and well thought out investment strategies that include venture capital. They are trying to convince me to accept them into our wholesale products. And so the wholesale thresholds are a topic that is particularly close to my heart because I routinely have to tell those people why I cannot give them access. Today, you've already heard strong arguments against the key points proponents for increasing the thresholds have raised. The historical reasons for the thresholds do not apply in the same way that they did 22 years ago. The economic environment has changed. Australians are more educated, more financially literate, and there is more access to information than ever before. Simply trying to limit access to certain products will not be an effective strategy for protecting consumers. The evidence, in fact, suggests that only a few investors need further protections, while the vast majority need better access to more choices in investments. Australia is already out of line compared to overseas markets in this regard, and I've seen firsthand the impacts of foreign investment. And Senator, yes, in the U.S., the liability of the home is excluded, as well as the value of the home. To answer your question from earlier today.
Right. I'm so glad to know some people listen to us.
I did.
Listen or agree.
Even better, Ms Mack.
A blunt instrument, such as simply increasing the investor test thresholds, would have detrimental effects on the technology and small business sector, reducing investing by an estimated 50% or more. Increasing the thresholds are also likely to increase the wealth gap and have disproportionately negative impact on regional areas, women, minority demographic groups who have all traditionally already struggled to build wealth. The current tests are already discriminatory to certain groups, such as parents and in particular women. We need to be looking at ways to remove barriers to building wealth and increasing international competitiveness, rather than additional protections for a group of people who have enjoyed a wide range of investment opportunities to date and have not asked for further protections. Thank you for having me today.
Thank you very much, Ms Mack. Mr Bunter, did you want to add anything?
Yes, thanks.
Thank you.
I'd like to thank the committee for the opportunity to attend and participate today. I'm an angel investor and have been doing so for about 14 years. To date, I've invested in almost 60 startups and advised numerous more. Professionally, I'm a corporate advisor and I work with high-growth companies for M&A and capital raising. I'm also an advisor to and a non-executive director on a number of high-growth startup companies. My involvement in the early-stage ecosystem in Australia commenced in the mid to late 90s as part of the dot-com 1.0 era. There's been a massive amount of change over the last 25 years, very much driven by the ubiquity of the internet, which has accelerated technology innovation, knowledge and information flows. Due to the significant investment opportunities and the ability to contribute skills and expertise to the startups, there's been a large increase in early stage investors. I'm also on the Management Committee of Sydney Angels, one of Australia's leading angel investment associations, and the reason why I'm here today. Sydney Angels is a not-for-profit association of investors established in 2008. Its objective is to provide a network to collaborate and share knowledge, experiences and insights, and to learn from and co-invest with other experienced and active angels. We have around 100 members who are angel investors. They work together as teams to invest their own money in early-stage startups. I'm actively involved in angel investor and capital raising education, both within Sydney Angels and to the wider ecosystem. It's important to realise that angel investors provide more than just money. By having a financial interest in the success of a startup, they also provide their expertise and experience to startups, which often increase the potential for their success. Angel investors are absolutely critical to the early stage ecosystem. Sydney Angels members are often the first external non-family and friend investors to support a new startup, and they act as a catalyst for the startup to develop and raise subsequent rounds of capital. Sydney Angels also has a passive sidecar fund that co-invests alongside active angel members. The members and sidecar funds have provided approximately $38 million in angel investment to 88 startups. And this has been catalysed by those startups who have gone on to raise over $730 million in other investment capital and to receive over $18 million in grants. These startups also employ and support thousands of employees. My and Sydney Angels' view is that any material increase in the financial threshold tests for the definition of sophisticated investors without the introduction of an appropriate alternative test would substantially reduce the number of early-stage investors in the ecosystem. This has been estimated by many to be a reduction of between 50 and 80% in wholesale investors. This would decimate the provision of investment capital at the earliest stages for startup companies. This in turn would have a devastating long-term impact on the wider venture capital ecosystem, innovation and long-term employment creation. We submit that there may be some adjustments that would be suitable to the thresholds to improve their application and reduce discrimination, mainly against female investors. It may be appropriate to remove the principal residence from the test and adjust the threshold accordingly. I think the family home issue is a far smaller issue than many people make it out to be. Some other submissions imply that crowdfunding regime or the 2012 2 exemption is an appropriate alternative, but in reality they provide no effective relief for startups and therefore angel investors. There's also the matter of the removal from April 2025 of the class order for business introductory services to be replaced by a substantially more restrictive and costly regime. It would potentially make it impossible for the majority of angel investor groups to operate in Australia. We would strongly recommend that the class order be continued. Rather than reducing the potential number of investors in startups, we need to be working towards increasing them and ensuring people have the necessary expertise, experience and ability to diversify their investments. Thank you.
Thank you very much, Mr. Bunter. That's a very heavily laden, information-laden introductory statement. I don't know if you could provide copies to the Secretariat. It'd be handy for us to have those with us now, if possible, for us to interrogate. And we've got Mr. Davis.
Yes, I'll try to be brief because I think both Cheryl and Adrian have covered a lot of the background points around the need for angel investors and the extent that they fund the startup and early stage community. Probably two things from my perspective. I have been an active angel investor and early stage investor for almost 40 years now. Over that time, I've been quite cognizant of the Section 708 categories in which you can invest in, businesses that do not have a prospectus and have worked through navigating that. It has been quite complicated, and I think one of the suggestions that is quite common amongst people like Cheryl, myself, and even some of the earlier speakers is that there should be an education and experience test categories for sophisticated investors. I won't get into the thresholds around the actual current sophisticated investor sort of assessments. There's been quite a lot of dialogue around that. But certainly the education and experience categories are ones that are not well addressed or not addressed well, yes, in the current legislation. And so probably two things for the committee in general is be clear on the problem you're trying to solve, because I'm not sure in terms of all the briefing material, it's not clear what the actual problem is. And the other one is make sure that there are good end user perspectives, and that's where we as angel investors fit in. We do tend to be a category of investors that are important, but are not well dealt with under the legislation.
Thank you.
Thank you.
Thanks, Mr. Davis. So you may have heard evidence from Dr. Just get his name correct, Humphrey Jenner. So to shortcut to that, we were talking about the education angle, and is micro-credentialing perhaps part of what needs to occur, given the sort of nature of the test and the negative feedback that we've received about the testing for current financial planner status for retail investors, and the impact on the ecosystem of advisors in the wholesale sector and the poaching of skilled and qualified and certified people from the retail to the... So given all of that, what does your version of education experience categories look like, Mr. Davis? And then I'll invite Ms. Mack and Mr. Bunter to give their perspectives on the education and or experience dimensions. Start with Mr. Davis.
Okay. Yeah, look, I can give, I guess, just a general perspective. I know there are far more prescriptive perspectives on this. The education perspective, just from my point of view, I have a graduate certificate in finance and investment. I've done it used to be the AVCAL, the Australian Venture Capital Association's foundations in private equity and venture capital investment. I've got a graduate diploma in business management. All of those would, from a technical perspective, give me the sufficient insight to be able to make investment decisions. There's nothing within the legislation that currently allows me to be credited for that. I do have a sophisticated investor certificate from my accountant, but it took quite a while to get to the wealth level and income level to suit that. At the moment, as far as I understand, the only certification you can get from a financial planner in relation to experience is actually in relation to specific products or services that they are providing to you, and it's not more general. So I guess the experience side of it is something where someone needs to assess, and that could be the accountants or it could be financial planners, I'll call that in general, so people with an AFSL, and it may be up to their judgment. And the other category would be looking at the engagement with things like angel investor groups. So I think most of the angel investor groups have a very strong education process. We certainly do here at Southwest Angels, and I know Perth Angels does, and most of the others do. Having micro certifications could be applicable, but it may, I think, looking at some of the overseas situations, even having a period of engagement with those groups, like a 6-month period or a 12-month period of engagement with those groups, may be a means of having them certify a certain level of education and experience. But I guess it comes back to identifying the problem we're trying to solve. That I think whilst there could be flaws in those sort of processes, at the moment, I don't see the wrong people getting through those sort of processes. People tend to be cautious enough. So, yeah, I can't get too much into the specifics. I know a lot of other people have looked at it, but I think there are mechanisms where you can add on to the current frameworks to allow people who do have adequate experience and education to be either self-certified, which I think is in the UK, or certified by people who are already in independent positions suitable for that sort of certification. Does that help?
Yes, it does, but it raises a few questions about certification and potential conflict of interest. If it was an AFSL that was going to be providing you with product, there might be some incentive for them to tick you off. And this is one of the concerns that we have about the CAC, is it? The Qualified Advisor Certificate from the Qualified Accountant Certificate, to allow people to be certified that's actually increasing in use, and that there's some pressure on people to provide that.
Fully understand that.
And I guess
the interesting thing is, the interesting thing is that probably a lot of angel investors do not necessarily use financial advisors. They're often. I run my own self-managed super fund. I don't have a financial advisor that I work with. I make all my own decisions. So in a lot of cases, we don't even have anyone to go to. We know people we could go to, but we don't have anyone we work closely with who could sign that off. And yes, I can imagine there was one of the submissions that I read from earlier today talked about a lot of the financial, well, there is gaming within the financial advice system to get around this. And if anything, that's probably where more of the problem is as opposed to in the angel investment community itself. And I don't have a solution for that, unfortunately.
Yes. The Deputy Chair's got a question for you, Mr Davis. Mr Hawke.
Yeah, I mean, a little bit on that, Mr Davis. I think to Mr Bunter as well, just about you mentioned an alternate test. I mean, I think I understand your point very well about the wholesale, the thresholds for wholesale investing, and we sort of explored that in our evidence this morning. I'm glad you're listening about what's going on. But if Treasury or government is going to adjust these thresholds, what you're arguing for is a separate regime or a carve-out or a alternate test for angel investing, primarily. And venture capital is a whole different bucket, and venture capital is governed by other incentives and things in the system. But we're talking here, you would like to actually see and this has come through with the other evidence, a lowering of the threshold for angel investing is what you're essentially arguing for. And then what kind of alternate test could really form good policy in this space? I mean, you've explored a couple of things that can't work, but I mean, if it's generational, are we saying people under 30 could have a lower threshold? I don't know. I'm just, what are you actually thinking about?
Yeah. Okay. Well, to some extent, I've got mixed views on the threshold side of things. There have been other submissions I've read where they're looking at suggesting reducing the thresholds. My focus is probably more on the alternatives to that, which is that the education and the experience criteria, and not specifically a carve-out for angel investors as such. It would potentially include those, but it is the education side and experience can apply to any early stage investment in general. Does that answer your question? So I've got mixed views on the threshold.
I'm looking for policy ideas because I think education's obvious. It's a common thing in government, and I get your point. I think it's a well-made point, but it isn't going to solve what the settings are going to be and the way the regime that is in place will handle questions like angel investing.
So I think part of the issue is having a single test can't apply to all different areas, because a wholesale or sophisticated investor is very different if you're investing in angel investments versus derivatives versus property. So I think any other education component needs to be very narrowly focused on the asset class that you're looking to invest in. So I think if I use angel groups as an example, angel groups quite often have a collaborative evaluation and process and ongoing regular training and education to get people up to speed with what does it mean to be an angel investor, how do you actually set up an appropriate investment strategy and portfolio, how do you actually do due diligence, how do you actually understand and mitigate the risks around that. So that environment with that education and training provides somebody with a certain level of skills to be able to assess and understand the risks that they're taking on.
And thank you for that, but your evidence is important, but that's like a self-governance regime. You're doing your own work.
That's one alternative for it. I think there are other ones.
But you're already doing that.
Yes, we are already doing that, correct.
Fine. So then, in relation to what we're doing here, what is it you're saying? Because you are saying some particular things about this. You're saying there is a need to have treat things differently, and then what are we saying?
So I think what I'm saying is that if you were to increase the threshold, as been suggested by a number of submissions,
it could happen.
Right? It could happen. That, as a result, would probably reduce the number of angel investors by 50 to 80%.
Which is not the intended outcome of lifting the threshold. So then, what could we do to?
So I think then potentially an exemption for officially recognised angel groups who have an education and training process, which could be assessed by an independent party. So ASIC could come in and actually look at and understand what is the training that you're doing, what are you actually delivering. You want people to continue to remain active in it, because it's all good and well to do training, but actually practical application is important as well. So I think maintaining that ongoing active involvement is important. And I think you could also look at other third-party accreditations. There are universities that offer some courses. There are other parties who also do an education function. So that's not the way you can.
And what kind of limit would you? I mean, what are we talking about in angel investing?
So I think there's probably other misconception in a lot of cases. So a lot of people think angel investors is doing large checks, $100,000 plus. Right. The reality is the vast majority of angel investors invest between $10,000 and $20,000.
Yeah, we're talking about small amounts.
So relatively small amounts.
And you're saying young people and modern people in the economy are uptaking angel investing?
Absolutely, they are and they want to.
The desire is there. And it also makes sense from an investing strategy perspective. It makes more sense as a young person to take higher risks and invest in long-term illiquid asset classes that have the potential for high returns than it does when you're say 70, right? So they understand that this new generation, Gen Z and millennials, are more educated in this space than ever. So it makes sense that they understand the concept of how they want to build wealth, and they recognize that this is a piece that is really important for building that wealth in the long run, but they don't have access to it. So in actually making it more accessible to that generation makes a lot of sense. On that point, in terms of specific recommendations, I actually did outline in my submission specific what we could do to change things from a policy perspective to allow for carve-outs around this that doesn't just necessarily just apply on the angel investing side, but could be more broadly applied. So if you do take a look at that submission, one of the recommendations was add the term. So there already, as you know, in the tests, there is a subjective test. The fifth test is subjective. Unfortunately, that test is not used by the vast majority of those in the ecosystem because it is too vague. And it does roughly translate to some of the things that have been done overseas. For example, in the UK, they have something that says if you've made 2 or more investments in an unlisted company in the last 2 years, you can be considered a sophisticated investor. Or if you've worked in the past 2 years in a professional capacity in the private equity sector and the provision of finance for small and medium businesses, which would account for some of that experience. The one in Australia is very vague. It says if they're satisfied on reasonable grounds that the client has previous experience using financial services and investing in financial products. What we could do, and I think the intention of what that was, where that was going, is designed for people who actually have that knowledge. So one recommendation is to include the term "or professional training" in that line, and then provide clear examples as to what counts as previous experience in using and investing in financial products, and clear examples of what professional training can be included. For example, completing tertiary education in finance or investing, such as a bachelor's degree in finance, completing a course that covers the fundamentals of investing in an asset that is substantially similar to the product under which the client wishes to be considered wholesale for, or a 6-month membership to an investing membership group such as an angel network like Sydney Angels.
Yeah, I have no objection to that. So that sounds fine, but the point is that really going to increase your pool of people? I mean, in Australia,
Yes.
Even that definition you gave from the UK, how many people work in private equity or the provision of finance for small business in Australia? They're already your likely customers anyway. I mean,
it would absolutely increase. And it's not so much just about the raw number.
Not by much, I wouldn't have thought.
Well, look, so we're talking, like, for example, retail investors that are that invest in equity crowdfunding they have like 200,000.
Yeah, but if they've worked with private equity or the provision of finance for small business, they're people that are more than likely to get over 500 fairly quickly. I mean,
Get out.
Over 500. Get over the 500.
No, the $500,000 is $500,000 as a single investment in one investment.
Yeah.
So,
I understand.
So no angel investor would
understand, but
super
people like you are able to, work it out. I just can't see that being a big pool. You think that'll make a big difference?
Yes, and it's not so much about the absolute number of people; it's about the impact that those people have. So even if it is, let's call it.
Explain that for a minute. The impact financially, or you mean?
The impact of their dollars going into startups that are growing businesses.
Yeah, so you do see a big pool of people with their small amounts making a difference just on the changes you've suggested there.
Absolutely.
That simple.
Yes.
And you'd be happy with that?
I would be happy with that.
You think that'd be development of our angel market?
Absolutely.
Okay.
If you think about all of the large tech companies and high growth companies, they've got all a significant range of employees, thousands and thousands of employees who've all actually experienced and have knowledge about what it takes to be working in a high growth company. Almost none of them earn $250,000 a year.
No.
Every
certainly
single
don't earn
Atlassian employee,
$400,000.
every single Canva employee, that's $4,000. Every single Culture Amp, Airtasker, Airwallex, Safety Culture, Employment Hero, all of our unicorns. These are people that have grown up in that ecosystem and know what good looks like and then want to deploy, but none of them are making are making $250,000 a year each year. God forbid one of them had a family and took time off for maternity leave. Like these are all people that are materially valuable to the next generation of startups.
Yeah, no, that's reasonable. That's very modest. So that's something that's workable inside the system, I think. So that's how you would address that. And then, but the certification by ASIC doesn't really sound. Knowing ASIC, it's not really. Can't really
any more work.
give them more jobs to do.
I don't think they necessarily need to do that. It's one. I mean, if you're looking, if you want a method that actually says you have to have some kind of certification, you need to work out somebody to do it.
That's
right?
not going to have a personal interest in certification.
Yeah, I agree, an independent body.
Correct. You need to have some independent.
But we don't want a new body.
No, I don't think we need necessarily more regulations.
New bodies. There's so many bodies.
I think certification, though, of courses is going to be like more regulation in place where if we look at other jurisdictions, there simply isn't that requirement.
Just definitions.
It's just definitions.
Possible. But so I think the attractive part of your argument is the equity, the access for the future and smaller, I think the intention of a lot of this regulation is well intentioned, but it does end up, limiting people's access to opportunity and the ability to take some risk and get ahead. So, but if you're saying, so your preferred model is changing definitions and rather than thresholds. Thresholds, there's a bit of ambivalence in the evidence about, don't change them, do change them smaller, higher. Everyone seems to be ambivalent, to be fair to you guys, throughout this whole day. Nobody can really tell us why we're doing it. Is it a good idea and should we do it or not do it? So
I don't know. I've listened to some. I'm not sure that it would be ambivalent to the number. I think most people are saying, and a lot of the submissions are, don't increase it because that's actually detrimental to it. I think there are a handful of people saying we should reduce it, but I think the vast majority of people saying is there doesn't seem to be a justification for increasing the thresholds to actually reduce the pool of people who take advantage of it.
Definitely people saying increase it as well.
Yeah. There are definitely some people saying increasing it. I noticed like the ASIC submission talked about a solution that equity crowdfunding and the 2012 exemption is an appropriate ability for people to do it. And the reality is they're not at all. When people are raising money from angel investors, they're not going out and publicly showing all their information and doing that.
But
so equity crowdfunding is not appropriate.
We see this quite a lot in especially our fiscal laws as well. We're just not keeping pace with the reality of the laws are just not keeping pace with the reality of what's going on.
Yeah.
So that's why it's important you're here.
That investors who do take advantage of the 2012 rule, they're actually, like those retail investors are actually often forced into more riskier investments because of the regulations that a startup cannot have more than 50 people in their cap table at any given time. They tend to set minimum thresholds. And so they say, okay, well, in order to invest directly, you have to invest a minimum of $25,000. And so if you're an angel investor, then you now have to invest $25,000 into one company. And let's say you only allocated $50,000 to that period. That's only 2 investments that you could potentially do. So that is a much riskier investment portfolio, for lack of a better word, than if they were to spread that over across 5 investments that year.
No, I understand. I think that's well made. This is just a perverse outcome of ongoing regulation. But so you propose, there's a couple of models you're proposing. Is there anything else in relation to this in terms of an alternate thing that would benefit small scale angel investing?
There's one other additional recommendation is if we were to utilize the current subjective test and modify it slightly to make it more usable.
Using those definitions you gave, that's what I meant.
Exactly. And I think that's on page 12 of my submission. But the last one is to provide provisions for what happens when a challenge to the test is made. So most AFSL holders don't want to accept that subjective test because they're concerned because there's never really been any precedent about, well, what happens if someone comes back and says, oh, I wasn't actually supposed to be wholesale and you tricked me into being wholesale and so now I want my money back or I'm suing you for one reason. So there needs to be some level of confidence in the market to understand what happens if what happens when a client does say that. And for example, you could say like, well, if a client challenges that, then the regulator would look at that sophisticated investor test and what they had declared in terms of their experience and professional training and their written acknowledgements and make a determination whether the FSL licensee was acting in good faith by accepting that person.
There has to be a declaration moment and a declaration document of some kind for such a system to work that's available where? Like, is it lodged anywhere? Or is it just held by the individual?
Ultimately, I think it would be held by the AFSL provider because that's their protection in that scenario.
Correct, yes.
Okay, but this is all a little unclear?
Yeah, it is.
Yeah, that's the point. That's the
problem.
concern. That's the problem.
Yeah.
It's
So,
unclear.
so is the AFSL licence holder the appropriate place for that to be held, given they have an interest in the outcome?
I think, again, if we are trying to regulate against the small proportion of bad actors, then we're going to go down a route that ultimately costs a lot more and does more harm than good. There are always going to be a small number of bad actors. At the end of the day, though, like as an AFSL holder myself, we have a lot of compliance regulations that we need to adhere to, and those protections are in place to ensure that we're communicating the right way, that we're not misleading investors. Like one of the things that was mentioned earlier was like, oh, well, there's no, wholesale investors get nothing. That's not accurate. The AFSL holders actually do have a lot of compliance regimes that they have to adhere to, and that does mean a quality of investment provisions in terms of the products that they're providing to their wholesale clients. So I don't see this as a huge issue in terms of a potential conflict of interest. If anything, those people are much better placed to assess the own risk that they are taking on.
So as an AFSL holder, what sort of document do you generate to provide you with a sufficient comfort that this person is an authentic and genuine wholesale investor, and has that ever been tested?
Under the by providing experience or
yeah,
so it would be a declaration of their previous experience, for example, education that they have undertaken, like a degree in finance.
And you make them prove this to you, or do they just make a statement of fact?
I think it could go either way, but at the end of the day, I think if an investor is going to the point of outlining their experience, their knowledge, their education, courses they've done, and then making a bunch of declarations to say, I'm, waiving my rights so that I can access this product, then it's probably more likely that they actually have done the research and want to access this product and understand how that product fits into their larger investment portfolio. And I think if we're in the position of empowering Australians to make their own financial destinies and acknowledging that the financial literacy in Australia has increased tenfold over the last 20 years, then we're in a much better place to empower them to make those decisions.
That must be off a low boat.
Yeah, I guess
the Australian government has put into a lot of initiatives over the last 10 years, specifically focusing on financial literacy, and I'm telling you, it has worked.
I've said to ASIC before, I was at a pub on the Central Coast where I saw two guys having a discussion about some financial matter, and they pulled out the Smart app from ASIC to settle it. At the bar to have the conversation.
I routinely hear, I go into schools and talk about starting businesses, and we routinely hear them talking about how they're going to build wealth, how they're going to build business. They understand financial business plans now. They're pitching me numbers that I didn't understand until I was 20, at 14.
Yeah. So that's the ones who are into it and that are good. I guess the concern is always that there are unsophisticated people who can be exploited. And I've asked others today to think about all the recommendations that you're making to this committee through the lens of what financial abuse looks like. We have people, particularly in intimate partner relationships, where there's a separation and financial abuse can then quickly overtake other forms of coercive control that were applicable in a situation where you're cohabiting. But as soon as the cohabiting finishes, financial products seem to be a very, very used way to perpetrate further coercive control and violence and abuse. So have you applied that kind of a lens to the way you create your products and that you engage with people to try and minimise that sort of risk?
Yeah, absolutely.
It's an interesting question because I probably don't think about it in the context of financial abuse the way you've described it in that kind of
I don't think many
right?
of us have been doing that at all for a long time, right? We're just beginning.
One of the things we do look at, and what's interesting about the Australian market versus some other markets, is that the Australian market has individual tests as opposed to couple tests. So in other markets, there are quite often couple tests. And so long as the family unit satisfies the requirement, then both parties actually meet the requirement around it. So you would have a scenario where you had one high income earning person and another one who's not high income earning, and one will qualify and the other won't. But they still make decisions as a family unit in a lot of cases, but that means one person can access and the other person can't, which means the investments go into one person's name and not the other person's name, which just continues to exacerbate that situation. You also get the scenario where you might have a high income and it mainly affects women because they go on maternity leave or take extended leave, so they might be high income earning, but the current test requires you to pass the test for 2 consecutive years. And if you miss 1 year, that means you're automatically out for 2 years because you need to actually get 2 years of actual passing the test. So you can have people who
change the test so it doesn't account for when you leave the workforce to bear
So
children.
we made a recommendation that effectively it should be a test that effectively a 4-year test. You need to satisfy it in any 2 years.
Of a 4-year
and one
period.
of those 2 years must have been in the last 2 years.
Yep.
So you can do things like that, or you should also do a family unit test, and other markets have a family unit test.
Yes,
so it
that
might
was
be
mentioned here
250K for
today.
an individual,
Yep.
or 350K for a family unit.
Yeah, so the US is individual income of 300,000 or a joint income with a spouse of 450,000 in AUD.
Yeah, this is out of date, these things as well.
They also have under the assets test as well. So it's actually 1.5 million in Aussie dollars, either jointly or with a spouse. And so
Without the family home.
that is without the family home. Yep. One other thing to consider on that point is that if we were to look at that assets test, if we were to look at excluding the family home, that would have a disproportionate effect on women because women tend to get the family home in a divorce. And so if they are then, if that is the only way that they are able to qualify, whereas men tend to get the boat and the cash and the other things, then that could still exclude them from investing in financial products for wholesale investors. And so that could have an impact there when we talk about financial abuse. If they get the family home, then they're have the potential to be set back already.
In the evidence we've received, often they don't get the family home. That was one of the big problems that actually has emerged in the evidence because that is weaponised as part of the settlement and it's just wear it down until there's nothing left. So it doesn't always cleanly go that way. I think when it's amicable, that might be the case, but when it's not, it seems to be very, very problematic. So I just wanted to clarify, going back to, I used to be a teacher, so I know some of these I learned so much from my students. It was just a wonderful thing to be working with young people all the time. And I'm thinking about one particular kid that I taught, Year 7 Green, I can remember. He'd be 14 and I'd say would have got easy to get hands on 5,000 from his grandma or somebody like that. Contact you, fake being, 22, tell you all about his qualifications because we would have researched everything that he needed to know about being eligible.
I saw the movie with
and deliver you
DiCaprio.
and deliver you the $5,000 and do all sorts of illegal things with great intent, vigour, energy and innovation, but be at risk. How are you preventing that from happening? Because this kid would get around any system.
What's he doing now?
So one, I would hire him.
He's not doing what we're doing, Senator.
He's got a job.
So one, I would hire him. However, it's important to note that the vast majority of AFSL holders are required to do KYC, which means that we need to do Know Your Customer. So we would immediately determine that that person is not who they say they are, and that we need to have a birth date and a driver's license.
So
ID,
he gets
right?
his older brother's mate to be him.
Right.
And there's some arrangement. Because these, I've just seen them get around everything.
So my argument there is that what a fantastic mistake to make at such a young age. Wouldn't you prefer them to make that mistake when they're 14 and not when they're 75?
The problem is, what about if he uses it in a way that gets money from other people to do that? And that's, I guess that's the question here. What checks and balances do we need to have in place so that people aren't becoming a wholesale investor in their own interest when they're using somebody else's money without them knowing that in an abusive situation? If they're declaring that they have qualifications, who's checking that to make sure that they have that? Where are some of the checks and balances for those who would be naive and exploited by others, at the same time as we prevent creating such stickiness in the system that the innovation that it offers and the opportunity for growing wealth is not stymied. So this is a very sweet spot that we need to think about, and that's why I'm asking for your ideas about, where is that sweet spot? Because clearly there's some impelling us to act.
It's absolutely a balance, 100%, that we need to look at, like, what is the balance here that protects the very few individuals that this has a disproportionate outcome for, while not preventing the vast majority of individuals who are doing the right thing, who are operating within the right guidelines.
Yep.
You know, there are not people who are coming to us and faking things. There are a lot of checks and balances in place already in terms of having to do KYC, having to verify every beneficial owner in a trust. Like, when we go through these things, that we would discover where they're coming from. But at the end of the day, there are always going to be bad actors. And if someone wants to go and defraud their friends, there's very little that you or I or any regulation can do about that. I think the best protection against that is early financial literacy education. And again, Australia has done a fantastic job of moving in the right direction. We need to continue to do so. And I think all of the financial operators in this space can play a role in doing so, from early education in high schools, ensuring that financial literacy is one of the curriculum topics that is included, all the way up to when people start angel investing and they join a group and they get education regularly through that group. Every step of the cycle should be about providing people with the education they need in order to empower themselves on their own financial journey, rather than trying to protect against the few fraudulent individuals. If we educate that person that when their 14-year-old cousin comes to them and says, hey, I've got this great money-making scheme, and they go, actually, you know, I know how portfolios work and what risk and return looks like, and this risk outweighs the potential return. Even though the potential return looks really good, it's probably too good to be true.
Mr. Davis, we've kept you quiet for a time. I'm just going to let you make a contribution now on anything that we've discussed.
Okay, well, thank you. Look, I'm very happy with Cheryl and Adrian's contribution. Yeah, they're far more across the intricacies of this than myself, so I'm very happy with their contributions. Just one comment in relation to the subjective test that Cheryl and Adrian have talked about. I think we're specifically talking about Section 708(10) in the Corporations Act, and it is even more specific than I think has been talked about today. It's not. It is actually only suited to offers that are made through the financial services licensee, and it's only in relation to those specific shares or securities that are offered at the time. If we were to look at some sort of certification by a financial services licensee, it needs to be broader than that. So the suggestion Cheryl made about adding some extra words in around experience or education, there still needs to be further broadening of that section of the Act or something similar to allow that certification to be more general than just the particular offer made particularly by that financial services licensee. Because a lot of early stage investments just do not go through that channel. But if those people have the experience to assess an investor's capabilities, then that may be one of the mechanisms to assess that, but it needs to be a more general certification.
Okay, Ms. Mack.
I would also agree that the criteria that I've listed out wouldn't necessarily just apply on the financial services holder, but could apply more broadly to allow startups to accept people as wholesale investors and therefore not be limited to the $50,000 limit on ESIC or under the 2012 rule.
Okay.
Yeah.
Mr. Bunter?
Nothing further about it. So that's
Mr. Davis, yeah.
And the other one, I just look wholly supporting the current comments by Cheryl and Adrian around we need to be very careful to not be jumping at concerns about gaming the system and I'll call it fraudulent use of these certifications, and not, at the risk of that, not allowing this market to be more open and effective. As I said, I've spent a lot of time navigating my position as an individual investor through it and making sure that I was clear on whether I was a 12-20 investor or whether I was over certain thresholds. We need to be very careful that we're not so much jumping at shadows, but we're not trying to solve a problem with rogue certifiers by restricting legitimate angel investors to the market.
Thank you. Just if I can, one final question. I've got more, but I'll go straight to Senator Scarr after this. Ms Mack, you make some recommendations around the grandfathering of investments. Just want to give you the chance to speak to that.
Yes. So currently, the way that the financial system operates with regards in particular to investments for wholesale investors, the vast majority are effectively practically grandfathered in. No one ever, for example, I've invested in a number of funds. None of those funds have ever come back to me 2 years later and asked, hey, are you still wholesale? And then done something about that. So everyone at this stage is already being grandfathered in. The trouble is that if we go to change these thresholds, there needs to be... Yeah, that could be a trigger. And so there would need to be a thoughtful process around how to handle that. And if we were to do something, for example, is just, well, let's just grandfather everyone who is currently above the current threshold and grandfather them all in. And then, like, the next generation, anyone who doesn't have a certificate right now, then has to meet the higher thresholds. You're looking at a much bigger impact on the widening the wealth gap, because all of these people who now have access to these particular products, then the next generation doesn't. And so we're going to see a huge gap in that wealth creation there. There's a number of other things that we probably should, if we're going to look at making changes. As I said, the market already operates under the assumption that you are a wholesale at the time investment, and that investment is then grandfathered in. But if we're going to look at changes, then we should look at, well, how does that affect long term? For example, if you have the opportunity to reinvest on a pro rata basis into an asset, but you no longer qualify, does that still come under the same initial investment that you made where you were considered wholesale, but you aren't now, but that investment was, so should you be able to be allowed to continue to invest in that particular asset? I would argue yes, if you've made that asset while you were, well, I would argue that if you already have the experience investing, then you should be considered wholesale. But looking at this from a perspective of, well, if you were a wholesale at that stage under the thresholds, but now not, but you've made that decision to invest, part of your investment strategy might have been the ability to follow on in different vintages or...
to crack open the case and keep it that way forever. Yeah.
For that particular investment, correct.
Yeah.
I do think that just the concept of them being considered wholesale in respect of the financial services provided to them in that asset class at that time being considered wholesale should remain in place.
Okay. Mr. Bunter.
There's probably a couple of aspects of grandfathering that I think are important. There's when you've made an investment into something, quite often those early stage companies will go and do further subsequent rounds of investment. So if you qualified at the start and then when they come up to do the second round, you don't qualify and you're prohibited from investing in that can be highly detrimental. So you can think about an investor who was in the very first round of Canva, who put it in and then wasn't allowed to then continue to invest in those subsequent rounds in Canva. They've probably given up, thousands of times return on those subsequent round investments. The other thing that's important with angel investing is that you have to have a highly diversified portfolio to lower your risk overall. So not just doing one or two investments, but 5, 10, 15, 20, 30 investments. And you don't want them to be all done at one time. You want them to be done over multiple years so you get a spread of risk around that. So if somebody was a wholesale investor for a couple of years and they've actually gone in with a desire to build up an angel portfolio and you stop them at the start of that journey, that actually has substantially increased the risk of their existing portfolio investments. They now no longer get to make up the high risk ones with the future positive ones that come in. So I think there can be some negative impacts if there's no grandfathering done appropriately of both longevity but also existing portfolio companies.
Okay. Mr. Davis?
Look, yes, on the grandfathering, very happy with Cheryl's concept there of grandfathering investments and also grandfathering people who have already been certified as meeting these sophisticated investor criteria. So I think grandfathering is a sensible position to take. Okay. And agree with Adrian's limits there that if you do have fluctuating income, then you can be in and out of the sophisticated or investor certificate and may not be able to follow on investments.
Great. In terms of the quacks, the accounting SMSF submissions state that the current requirements for accountant's certificate to verify individual compliance with world tests is viewed as outdated. Practice has led to an over-reliance on these certificates, shifting risk to accountants rather than ensuring appropriate investor safeguards. The joint associations argued that the responsibility for determining suitability should lie with the financial advisor or the product issuer. This sort of goes back to something you were saying a little earlier, but what are your views about the use of that instrument, the accountant's certificate?
In the context of from startup and angel investing, I don't think you should be asking the startup who's trying to raise the capital to assess the risk profile for an individual investor. The accountant's not been asked to assess the risk profile from that. They're actually asking to do a factual statement about whether or not the individual has had gross income of over $250,000 each year for the last 2 years, or they have net assets or controlled net assets of more than $2.5 million. So
Black and white
it's a black and white test. And in fact, what you'll find is most accountants will skew towards trying to satisfy the income test requirement, because if they need to do an asset test, they basically need to opine on the value of the assets or the liabilities and actually do a full balance sheet effective for that individual around it. So it's quite often a very, very black and white test around it. Most accountants charge their customers to actually sign the certificates around it. I actually don't think that's a big issue. It's actually the only practical way for those investors to access wholesale investments.
I think it should also be noted that the requirement to have a certificate signed by an accountant is not required in the US or the UK, our closest overseas jurisdictions in this regard. Investors are allowed to self-declare and are trusted to do so in that particular regard. So, if it is absolutely necessary to have a verifiable piece of paper that says that you meet that requirement, then I do think somebody who is versed in determining net assets or gross income is probably best placed. And again, I don't think that there are the accountants that are saying this is putting the risk on us. They are not making a determination as to whether that financial product is relevant or appropriate for that person. They are providing a factual statement as to whether that investor or that person has the income or assets.
How I think it goes is somebody has a conversation and they're told that this is a really good investment, but you can't get into it unless you're a wholesale. Then they go back to their accountant.
Yes.
Yep.
And they apply a bit of pressure.
Well, no, they say, am I a wholesale investor or not? And the accountant will normally say, yes, you are.
Or no, you're not.
Or no, you're not.
So there's been apparently a proliferation of these certifications.
I know what you mean. So
when did it become trendy, and how did suddenly all these people who weren't eligible suddenly become eligible? What's going on in the ecosystem that there's a proliferation of these quacks?
So this comes back to the newest generation, particularly my generation of millennials, who have identified and taken an active role in their financial futures and have identified the type of portfolio that they want to build, which includes some really low risk stuff, possibly a house if that ever becomes an option, and some high risk asset class because long-term wealth building, right? And so in order to then go and build this portfolio, cool, I can just go and buy some ETFs. Awesome. Don't need anything for that. Okay, now I need to put some high risk stuff in. Great. How do I get access to that? They're approaching people like Sydney Angels or Aussie Angels and saying, okay, how do I get access? And then that financial product is saying, we can totally give you access as long as you meet this requirement. And then they go to their accountant and say, hey, I need this certificate. So I think that is actually a positive outcome and result of this newest generation becoming more educated on their financial futures and what they want in their investing portfolio.
So it's a natural growth in the market.
Correct.
That's education inspired.
Correct.
Well, that'll be interesting to put to the accountants and see what they have to say about the age profile of the people who are seeking this. Over to you, Senator Scarr.
Thank you, Chair. And can I thank all of the witnesses, Mr Davis, Ms Mack and Mr Bunter on your submissions, and also for your advocacy, including in the public sphere, in relation to these issues. I know, Ms Mack, you've been at the forefront in terms of women, the interests of women in particular, having opportunities. So thank you very much for the advocacy of everyone. First issue I want to run to ground is what happened in the UK. So it's quite extraordinary, actually. When the Australian government released its consultation paper on managed investment schemes, I actually looked at what was happening in the UK, and they'd released a consultation paper which I think had a bit of a different flavour, but I'll park that. But what's happened is the UK, and this is on page 4, I think, Ms Mack, of your submission, UK went down this path of increasing the thresholds. A letter was sent to the Chancellor of the Exchequer, which was written by, as I understand it, 2,900 signatories of people in this space of capital raising, angel investors. The open letter, which I've managed to find, and raises the issue with, quote, this work is being put at risk by the changes to the high net worth individual investor rules planned to come into force at the end of January. They are anathema to the trailblazing startup ecosystem that has been built today. And then a number of points, end quote. And then there's a number of points made which mirror to some extent the points made in your submissions. And then we go to the budget brought down in spring 2024. And I'm just getting this down for the Hansard record, Chair, because I've done a bit of research whilst we've been here. Paragraph 5.102 of the UK budget, which I know it's only 98 pages compared to our massive tome, actually...
Make estimates a whole different experience.
Yeah, it would. Actually says this under SMEs, financial promotion exemptions, the government will legislate to reinstate the previous eligibility criteria. To qualify as a high net worth or sophisticated investor, the government will carry out further work to review the scope of the exemptions. So they actually went through down the pathway over 2-3 years of consultation on this, decided to lift the thresholds,
and now they're
then saw the consequences and have reversed it within only a few months.
Yeah,
Is that
amazing
what
it's amazing how fast they actually reverted back to the old.
Sorry, I'll go to you, Mr. Bunda, first. So
it's amazing how fast they reverted back to the old rules because it completely decimated the early stage investment ecosystem.
So quickly.
So it's quite extraordinary, isn't it, to see a reversal of that type? I mean,
Pretty instructive for this.
Well, exactly. Hats off to them for acting so quickly. But I guess that does. Do you have any figures in terms of take it on notice, but in terms of the impact on the startup sphere of the economy in the UK?
Only anecdotal.
Okay, that's okay. There are some figures quoted in this letter.
There are some figures quoted in that open letter to the Chancellor.
Yeah, so I've got that, and I'll. Can I table a letter I've got on my phone?
It's a public document?
Yeah, Ivan's looking at me. So I'll table that because it talks about, I quote, the changes were first proposed in 2021 when angel investing and VC investment spiked. Since then, first check, CHEQUE, investing figures have fallen off a cliff, with the number of first-round seed stage deals in 2023 down 28% year on year and at a 10-year low of 1,025. This is down from 1,973 in 2021 when this measure was consulted on. So it went from 1,973 down to 1,025, which is quite a cataclysmic fall.
It's also worth noting that Australia has experienced a similar decline in venture capital investing over the last 3 years. In 2021, it was 10 billion. In 2022, it was 7.4 billion, and last year in 2023, it was 3.5 billion.
Do you think that's got anything to do with COVID changes to practice and people engaging?
It's entirely the interest rate. We've come out of the ZERP era, which is entirely expected, and economies around the globe are seeing a decline in venture capital. But we are in a particularly vulnerable state that we are at a pivotal moment in our country where we are trying to move away from digging things out of the ground to investing in more sustainable things like tech, and to go and put more barriers in place for innovation to be invested in at this crucial time, I think is very scary.
So, Paige, I want to take you to ASIC's submission. So, Mr. Bunda, I think you've certainly read ASIC submission because you touched on one of the paragraphs I'd flagged here to put to you. Ms Mack, have you had an opportunity to read ASIC submission?
I did read ASIC submission.
Okay, so they've noted your concerns. stakeholder concerns, and on page 30 of their submission, this is what they say. Paragraph 125. There is a range of existing avenues available in the Corporations Act for those seeking to raise capital for limited offerings to clients with reduced compliance obligations. These avenues would not be impacted by our recommended reforms to the wholesale tests and would remain available for fundraising as explained below. And then they refer to two options. Mr Bunter, you referred to the first one, and an answer you've already given, and Ms Mack, I think you referred to the second one. So the first one, Mr Bunter, I just want to give you a chance to respond. ASIC refers to the CSF framework, may be available to companies seeking to raise and contribute capital. The CSF framework enables eligible small unlisted companies to raise up to Australian $5 million from retail clients via a platform. The concern you raised, Mr Bunter, as I understand it, is a lot of these companies or businesses, they don't want to go through this process because they don't want to make public information which is currently private. They'd much prefer to deal with, say, angel investors on a private basis, which isn't public. Is that, have I correctly summarised your view?
That's one component of it. So I do actually have a printout of that page here with me as well.
Oh, there you go.
So it is difficult because it's a concerning submission from my perspective on both those paragraphs. So yes, the CSF issue is, yes, becomes public. What a lot of people don't realise is that in order to undertake a successful CSS offering, it actually normally costs the company somewhere between $80,000 and $150,000 in order to do that. And that's sales, marketing, providing videos, and all those kinds of things to get it. And that company might raise 100, 150, 200, if they're really, really lucky, $700,000 or $800,000. So it can be quite a significant cost. Their information is out in the public. They are also prohibited from putting information into those documents, like any form of forecast or aspirational type things about what the future might look like, which is actually the most critical thing for early stage investors. The document you put together is highly legalese. It's very long. The vast majority of people don't read it and don't look at it, and all they do is look at the marketing type material. So I don't think that's an adequate answer to it. You'll also find a large number of VCs will not subsequently invest in companies that have undertaken a CSS.
Sorry, they will not subsequently invest.
So if you've done a CSF, they will not then look at investing. There's a handful of companies that have been successful in doing it, but the vast majority won't.
Is that from a risk perspective, just by definition, if you've had to go out and do a CSF, we're not interested, or is it more that they've got a cluttered share register?
More it's the cluttered share register. Okay. You want to have a shareholders agreement that enables the VC investor to have a certain level of controls around it. If you then want to go and sell the company,
got it. Yep.
It's hard to deal with.
Ms Mack, just on that first limb we're talking about, the CSF, do you have anything to add? You agree with Mr Bunter?
I absolutely agree with Mr Bunter. There are also a number of perspectives from the angel perspective why it doesn't make sense to invest in a company on a CSF. One is the fact that you know how much they have spent to do that, and that a large chunk of the money they raise is going to essentially cover that. But the other is that on equity crowdfunding platforms, the vast majority of these companies are self-pricing. So they are setting their share price, and that is typically not how it is done. The market isn't setting the price. The company is saying, this is what I want to be priced, and then going out to investors. And while retail investors may not know the difference, the vast majority of angels who actually provide strong help know that that may not be the right price for that company.
So they're actually, the way it works, they actually set the issue price.
Correct.
For the shares.
So they can't change it once they've gone public with the offer. So if they want to, if they don't get, let's say you go out at $1 a share, and actually you've worked out you can't raise the money you want at $1 a share, but you could do it at 80 cents a share, they need to withdraw the entire offer at $1 a share, and then redo the whole thing again and start again and put it out at 80 cents a share. Whereas angel investors, there's a negotiation that happens. So the starting ask that a company will come to is almost never the outcome that you actually get to, or the sum raised is not the sum that's actually raised at the end of it. So there's that backwards and forwards negotiation piece.
Oh, well, never fear. ASIC's got the second alternative, paragraph B. Quote, in some cases, a startup or small-scale capital raising can raise funds from retail investors without requiring a prospectus or PDS to be issued generally, no prospectus or PDS is required to be given for fundraisings up to Australian 2 million, where offers of securities or financial products are made to up to 20 retail investors over a rolling 12-month period. Ms Mack, you refer to this as the 2012 rule, and the concern you raised was one of the concerns is 20 into 2 million is
100 grand.
100
100
grand?
grand, yeah, 100 grand. And
Exactly.
if you're looking at, 2
million.
The angel investor typically will want to invest in a diverse portfolio. So if someone's, say, raising $1 million, and even if the 100 grand it becomes 50,000 per investor, that's still, from an angel investor point of view, that could mean they can only participate in, say, 2 offerings as opposed to 10 offerings, and thereby diversify their risk. So is that the main issue you see in that respect?
There's a couple of issues there, but that is absolutely the main one. So
Okay.
as an angel investor, our desire is to create a diversified portfolio because that is how we achieve the long-term assets or long-term returns that are enjoyed by angel investors. And that is essentially the power law. So you invest in a lot of companies and 1 or 2 do really well and the rest don't, but the 1 or 2 that do really well make up for everything else. You need to have a portfolio approach in order to access those returns. And so if you can't build a portfolio approach because the startup says, well, in order to invest directly as a retail investor, you have to invest a minimum of 25,000 or 50,000, then you're actually forced into a more risky investing profile because you're forced to invest more than you might have liked to invest in that particular company.
And the reason for that is it's a 2012 rule, so you can only offer
people.
securities to 20 retail investors, up to 20 retail investors over a 12-month period. Therefore,
So you have to ask for bigger checks.
Correct.
If you want to raise a large amount of money, but if you go to the angels who are doing $10,000 checks and you go to 20, the maximum a company could raise under that exemption is $200,000, which is far less than what most first rounds or pre-seed rounds or seed rounds are actually angels are investing in.
Okay. Ms Mack, you said there are other issues?
Yes. So another issue is that as angels, there is something in Australia called ESIC, which is the Early Stage Innovation Company Tax Break. If you want to take advantage of that as a retail investor.
Sorry, what is the early stage?
Early Stage Innovation Company. If you, as an investor, invest in an early stage innovation company, you are entitled to some tax breaks, which are great. Not quite as great as the UK's one. Put that one on notice as well. But they are good if you can get access to them. The trouble is that for some reason they separated them in 2 buckets and said, if you are a retail investor, you get this set of tax breaks up to a limit. And if you are a wholesale investor, you get this set of tax breaks. The problem is that you can only, as a retail investor, in order to access those tax breaks, you can only invest up to $50,000 in a 12-month period. So if you are limited to a $50,000 investment and the startup is telling you, oh, I need to have a minimum check size of $25,000, that means 2 investments. And it's not just that you only get the tax breaks up to $50,000 and nothing else. It's if you invest more than $50,000 in any tech companies, then you get none of it.
Right,
So
got it.
it's determining pretty much the exact amount that you can put in, which is not responding to the market. It's
Correct.
arbitrary for no good reason.
I think it's trying to protect retail investors from making more investments, but
bigger than 50K.
Yes, which could make sense if, like, I think the intention there was to protect investors.
That's the policy,
of course.
the policy
but
goal.
in reality, the way that it plays out in the market is that it pushes retail investors into more risky investments because they can't build a diversified portfolio with 50K. And again, if we were to allow investors to take more control over their finances and invest the way that they want and maybe certify them as wholesale, then they can take advantage of the bigger tax breaks up to, I think, on the wholesale side, it's $200,000.
Okay. So how much of the ASIC submission do you have there?
Only page 30, 31, 32 and 33.
Oh, I wonder what was on those pages.
It's the stuff around that section that you just talked about.
Yeah. In their introductory comments around the need for reform to what they refer to as outdated wholesale tests, in quote, paragraph 8, they say, our view is that A, under an appropriately framed increase to the wholesale tests, the impact on business will not be significant and there would still be avenues for fundraising, end quote. I'll give you an opportunity to respond, Mr Bunter.
I think that's laughable, to be honest.
Okay. Ms Mack?
It's entirely inaccurate, and I would like to understand where they think they got their data from, because I would imagine that that was more of a finger in the air type estimation.
Okay. Mr Davis?
I would agree wholeheartedly with Adrian and Cheryl. I think it actually shows a lack of understanding of the angel and early stage investment market overall. And just if I can make two comments just relative to what Adrian and Cheryl have covered, I agree wholeheartedly with what they've talked about. Just on the crowdsourced funding side of things, one of the attributes I think Adrian talked about with angel investing is that it is often a hands-on style of investing, and so you tend to often invest in things that you have local proximity to or you meet the people, and you often don't get to do that in crowdsourced funding. So I think that's one of the subtle differences around angel investing. It's often a very personal style of engagement with the business. And all of these categories...
Just before you move off...
Yeah.
Sorry, just before you move off that, Mr Davis, and I hope I'm not going to cause you to forget your next point, but that argument that you're putting now dovetails with evidence we received from Dr Mark Humphrey-Jenner, who talked about the relationship between a business and an angel investor. He also talked about the relationship within an angel investor syndicate or syndicate itself as part of the culture or ecosystem of the investment equation. So an angel investor potentially provides more than just capital to the business.
Yes.
And the angel investor also provides the benefit of their insight, lived experience to fellow members of the syndicate. Is that does that relate to the point you were just making then?
Yeah.
Yes, exactly.
And you don't get that opportunity when you're investing via crowdsourced funding regime.
Got it. And your other point you wanted to make?
It's from ASIC's perspective. It should really be looked at. These different categories should be looked at as and rather than or. So the crowdsourced funding has a place in the marketplace. The exemptions under 708 and Corporations Act have a place in the marketplace. A general exemption that allows greater access to angel small investing has a natural place in the Corporations Act, but is not in it. And they should be looked at as alternatives rather than, it's and rather than this or that.
Understood. Ms Mack, you put the question at the outset of your testimony. You referred to a question I asked of some witnesses earlier in terms of what's the mischief? What are we trying to address here? What's the evil that we need to address? So after you raised that, I went back and looked through ASIC's submission to see they're proposing an increase in the net asset threshold from 2.5 to 4.6 million and to the gross income threshold from 250,000 to 461,000. Very material increases they're proposing. And when I searched their submission for, why, they say, paragraph 6, in the interim, ASIC has observed numerous instances of serious harm suffered by investors who are not financially sophisticated or considered wealthy by today's standards after entering wholesale-only investments, end quote. So that's the first point they make. And so then you search through their submission to say, well, where are these numerous wholesale investment structures that have gone disastrously? And they refer to, just trying to find it, they refer to two LM managed investments, which or LM, which was up in my home state of Queensland, actually, I think. And then they referred to, let me just find it. Here it is. It's in paragraph 119. In addition, the significant collapse of a number of registered managed investment schemes, and we've talked about Sterling, which was just open to retail.
Yeah.
Mayfair, which I'm interested to get your thoughts on. They then refer to these two examples: LM Managed Performance Fund, where more than 400 million Australian dollars was invested by over 4,500 members, and Equity Trust Premium Fund, where 56.7 million remained owing to members. I just want to give you an opportunity just to. This seems to be the evil. This is the mischief. People lost money in. I'll put sterling to one side. I don't think it's relevant. People lost money in Mayfair. People lost money in LM Managed Performance Fund. People lost money in Equity Trust Premium Fund. That's the evil. That's what we're trying to address. And if we increase the thresholds, so a whole cohort of investors who invested in those investment disasters who would be protected. How do you respond to that?
Personally, I would like to take that on notice because I think the number of wholesale investors in each of those schemes and how they would have been classified otherwise is relevant, as well as the dates in which those happened. My understanding is that the vast majority of these instances were well before some of the newer regulations where ASIC has had more powers to intervene, and they have utilized some of those powers in the recent years. So I don't know if you have the dates there of those three
Don't
instances.
have the dates. Very, very happy for you to take it on notice because I think this goes to, this is, from my perspective, it's a linchpin in terms of ASIC's argument. Mr. Bunter?
I think that's right. I mean, they talk about numerous examples, but they sort of outline two in that, so I'm not sure how.
Well, let's say three with Mayfair.
Okay, with three with Mayfair. So I still don't think it's a substantial number, and there's always going to be bad outcomes around it. I think the Mayfair one has probably got still some time to play out. I've sort of followed that from time to time as it is progressing through the courts and actions.
Okay.
But I think I'd agree with Cheryl's comments.
Do you want to take that on notice as well, Mr. Bunter, and give any additional thoughts you have in relation to that?
Also, just in the paragraphs that follow, 120, 121, a few indications of enforcement work that where investors who were retail were misclassified by entities as wholesale.
Yeah, there are.
Yeah.
That is correct. And if you've got any comments on that, the Chair, from my perspective, I look at that and say, well, that's not a question of the thresholds. That's a question of the system. The system, right?
Yeah,
which is still highly relevant.
Yeah.
In terms of
so maybe you
changing
might
to the thresholds.
Yeah.
But if you've got comments on those issues, that would be very, very useful. Now. Paragraph 129, they say, this is ASIC, further we consider that any increased compliance costs that would apply should the wholesale tests be revised or outweighed by the resulting consumer protection benefits. And basically say, well, if you've got to incur the compliance costs to make your offering available to retail investors to be able to access the capital because we've changed the thresholds, then that's the increase in those compliance costs outweighs the resulting consumer protection benefits. How would you respond to that?
Again, I don't think that they have done any research to back that up, and we are coming to you today with vast amounts of evidence as to what the detrimental effects of this would be in pursuit of consumer protections that, again, are trying to protect a small few of bad actors. That is very difficult to essentially protect against fraud if people are going to go and do that. So I think I would push back on ASIC to say, provide your evidence, because we have come here today with plenty of evidence to suggest otherwise.
Yeah,
I would suspect that ASIC's submission is actually probably hasn't even considered angel investors at all, and that as an asset class. If you look at, I do actually have the page I print out there, they talk about the compliance costs around sort of legal costs and some production time. The reality is if you wanted to tap into retail investors as a startup under this scenario, you would need to do a full prospectus, which would then need to be lodged, which have substantial costs associated. ASIC would also then turn around and say you have no basis for putting a financial forecast into your prospectus, so you would be unable to put any kind of forecast information into it. it would almost make the prospectus useless from an investor's perspective to make an assessment of an early stage startup.
Well, they actually, have you got page 30 there?
I do have page 30.
Paragraph 123 and 124.
Yep.
123, I would say, is accurate. They are subject to increased risk, but in exchange for taking that risk, and this is something that angel investors inherently understand and spend a lot of time thinking about, is the potential for high reward.
And the reason I refer to those paragraphs, they've actually made comments in the context specifically.
I think they make comments, but I don't think they have it in the context of what it really is in terms of the comments around the compliance and therefore what a startup would need to do in order to raise money from angel investors if they were to be classified as retail.
And I don't think that they've thought it through further. They've provided comments, but they haven't really thought through what the impact on the broader economy would mean if 50% of 50 to 80% of investing dollars stopped going into the technology asset.
Yep. And make an observation, I'm pretty sure you don't have this page. On paragraph 71, right, of their submission, they say, they refer to overseas jurisdictions. The jurisdictions discussed below, which are United States, United Kingdom, European Union, Singapore, New Zealand, either apply financial thresholds that are higher than those in Australia, or include adjustments to those thresholds to exclude the primary place of residence and other amounts from the calculation of an investor's net wealth, end quote.
So I've actually got on, I think it's page 3 or 4 of my submission, I actually provided a table that breaks down the differences between Australia, UK, and Australia. It does not include the other jurisdictions, but I would be happy to provide that on notice if that's something that's desired.
I'd be interested for you to do that because my reading of your table, which I found helpful, actually indicates it's actually the converse.
Exactly. That is correct.
So it just baffles me, and we'll ask this of ASIC tomorrow.
I'll be getting ready now.
Well, I'm sure they are, as to why they would make that statement, because it's, well, and especially in the context of what the UK went through, but which might have post-dated the submission, I'm not sure, so I should be fair. But clearly
It post-dated their submission to Treasury. It did not post-date the submission to this inquiry.
Okay. But clearly the thresholds applied, let me put it this way, the thresholds that currently apply in the United Kingdom, the United States, would, if we adopted ASIC's proposal, would be substantially, materially, dramatically, I can't think of another adjective, exorbitantly less than would apply in Australia. So much that I put this, I've got to dress this up as a question, put this question to you, so much that I would have thought if you had such a material discrepancy in that regard, which barely seems to describe it, that new startups, etc., would say, well, we just can't do this here. We'll go overseas. We'll go to the United Kingdom. We'll go to the United States. We'll actually take our ideas, our brains, our entrepreneurial spirit to a jurisdiction which actually has a more competitive regime. Is that a real threat if we would introduce these thresholds, Mr. Bunter?
Yeah, Senator Carr, absolutely, that is the real threat. And I think it's got another threat on top of that, is that I already invest in the US in startups through a platform called AngelList, which is a similar platform to Cheryl's one. So if the threshold, and I was unable as an investor to invest here, I would literally just transfer more of my investment dollars into the US market. So I would actually be supporting US startups rather than Australian startups or other global startups.
There's another threat as well, that we would reduce foreign investments from other investors overseas who are coming to Australia to invest. We have about 20% of our current investor base that I mentioned that is from overseas, and we regularly get questions from them genuinely baffled as to why they need an Australian certificate to determine their net wealth. And often they will say, you know what, it's too hard, never mind, I won't invest, I'm not going to put my dollars in. We've probably lost at least 500,000 at this stage, and we've only been operating for the last 2.5 years due to investors giving up, because how are they going to find a Australian accountant to provide a certificate on their assets that are located overseas? So if we increase it again and make it even more hard, we're going to see less foreign investment coming into Australia.
So we've just got a bit of clarity on the ASIC. 15th of May was the submission, and the changes in England were in February.
There you go. And this is in a context, those comments which you've just made, this is in a context where startups in Australia, be it in the tech space or fintech space, wherever, are crying out for capital. There's a dearth of capital. And in fact, in the previous term of Parliament, I sat on a fintech inquiry looking at the issue in terms of fintech or finreg, I can't remember, in terms of startups actually getting access to capital. And we had so many witnesses say it is so difficult to attract that early seed stage capital in the Australian market compared to some of the ecosystem, investment ecosystem in some of our competitors. So to actually add this increase in the thresholds on top of that already problematic market, investment market, is an even worse idea, isn't it?
Correct.
I agree.
Okay.
Clearly other jurisdictions though are playing around.
Sorry, Chair. Mr Davis, you had something to add on that?
Yeah, my question is...
Yes, so just closing out your commentary. Look, I agree completely with your comments there, Senator Scarr.
Questions, Mr Davis.
Question. Yeah, comments culminated in a question. Look, just one further observation in relation to ASIC, and this comes through both in their submission to this committee, but also their commentaries in relation to the business introduction services class order action that Adrian talked about earlier. There seems to be quite a misunderstanding between managed investment schemes like MISs and a typical early stage company that people would invest in. And so in even the commentary you referred to there around the stakeholder concerns, those paragraphs 122 through 125 in ASIC submission, they start off by talking about MISs. And the examples they've given where there have been significant losses by investors of $400 million or a couple of $100 million, any early stage company would love to have access to that much money. I mean, we're typically talking about, as Cheryl and Adrian have talked about, collective investments of less than $2 million, and often investments of $10,000, $20,000, $5,000, $20,000. So it's the two products, MISs and early stage companies, are completely different, and ASIC doesn't seem to understand that because they tended to bundle the two together, not just in this submission, but also in their, when they created the crowdsourced funding regime, they took away the business introduction service exemption class order for angel investment groups and only left it in place for MISs. So there seems to be a fundamental misunderstanding there with ASIC around this investment category and product.
Mr Davis, would you mind just, and I want to give you some quick homework because we've got ASIC before us tomorrow. If you could shoot a quick email to the Secretariat just setting that all out, so I can walk that through with ASIC. Would that be possible for you to take that question on notice but give us a quick answer overnight just so I can walk ASIC through that?
Yes, I could shoot that through. And I'd be interested in Adrian and Cheryl's comments on that as well. Is that your observation as well?
Yeah, absolutely. Fundamentally, the products that we're talking about here, Mayfair, Equity Trust, LM, these were complex products. And I can understand why there might be confusion around how that was applied and wholesale investors that may not have understood the underlying investment thesis that they were going into. Whereas the difference between that and investing in a startup directly or investing in an individual company via an angel syndicate and even into a VC fund. If you're going to go into a VC fund, they have a very simple mandate. We invest in early stage companies that are at this stage of business, technology companies. Like, it's a very simple mandate. There are no complex underlying derivatives. There's no complex, this happens to your house and we're putting this up and we're putting this as collateral. Like, there's no complexity here. You know exactly what you're getting into. And all of the PDSs that, for lack of a better word, that is being provided to investors in this instance are very clear about the underlying asset that is being purchased, and it's a very simple product. So I think Rob's point here is I'm very aligned with Rob's point here that there is a fundamental difference between the type of assets that we are talking about in the venture capital space and the early stage investing space than these complex trusts and investment schemes that were devised up that ultimately led to a number of large losses.
Yep.
So the differentiation, perhaps extending that, is not by the nature of the investor, but by nature of the product. That the products are sophisticated or not sophisticated, and that might be a more useful determinant of where the risk lies.
Yeah, and I think the other aspect of that is that the whole MIS concept is effectively unit trust investment structure. So sometimes angel investors and we as Sydney Angels will quite often group people together and use a unit trust as the collective investment vehicle because that's beneficial to the startup. But that's not an MIS in the traditional sense, how ASIC is sort of, I think, applying this for a wide scheme that has, hundreds and thousands of investors in it. I think Rob's comment around the class order for the business introduction services, I think, does confuse the concept of the MIS versus what an angel group actually does and investing in startup equities. And therefore, there's a substantial level of increased complexity, which would effectively require angel groups to go and get AFSLs in order to continue to operate. When an angel group is effectively run by volunteers as a not-for-profit organisation to sort of aggregate it, the cost of that becomes prohibitive, and I'm not sure that any angel group would pretty much exist in Australia if they were forced to comply with the new AFSL requirements.
Okay.
I agree.
Thank you. I was going to say that despite our most fruitful conversation here, clearly things are happening around the world where there's been this conversation because it's gone up, it's gone down, it's been changed in the US. You've got evidence here, the research paper that indicates they increased their thresholds and had a very negative impact in regional areas, perhaps not in the other areas. We've spoken about the Brits, they've gone in, they've gone out. We've had COVID, we've had, worldwide inflation peaking. We've had a few other wild cards. But clearly something's going on for multiple jurisdictions to be trying to calibrate this to a level where the risk-reward ratio is of sufficient integrity to meet the common good as well as the freedom of the individual, right? So there's a calibration that's live, really, as we undertake this inquiry. So it's probably not bad that we're doing it because it's actually happening of other places. But can I take you to the AFCA submission to the committee here?
I don't have that one, sorry.
Okay, so we might put that on notice for you to have a bit of an interrogation of that one. But some of the things that they've suggested here is they support increasing the wealth test, and that any updated test should exclude superannuation in the family home.
Look, again, I think we can look to other jurisdictions. UK has excluded pension, which super, as well as the primary residence. The US, on the other hand, has only excluded the primary residence. I think any push to exclude assets from our current threshold requires a reduction in that threshold, again, to prevent discriminatory actions.
So there's an interplay of those elements there.
Exactly.
Which is evidence you've given earlier. AFCA considers that a single test with two limbs, a wealth limb and a financial risk tolerance limb, may more effectively respond to the policy objective, reduce uncertainty for firms, and ensure wholesale designation properly applies to only those clients who have sufficient assets as a buffer to capital loss and are genuinely capable of assuming the risks. AFCA supports retention of the professional investor test as it's generally understood and applied. Do you have a view on that?
I think it's an interesting one. It says, I believe I did skim the AFCA submission. I believe it's more in the context of the broader MIS and retail, so I don't think it's coming at it from an angel investor perspective. So I think that's one component to it. As Cheryl said, if you're going to exclude assets, I do think you need to look at adjusting the thresholds. I think there's not an unreasonable argument in some respects to exclude the family home. But again, lower the threshold. I do think you need to work out how you treat debt on the family home, because someone could have had an unencumbered home, go and borrow against that home and buy shares. So if you exclude the family home and debt attached to it, you would be counting the shares but not the debt and not the family home. So I think there's a complexity around that.
So just in relation to that, Mr. Bunda, we had Mr. Morris from Ord Minnett who said, well, if you're sophisticated enough to manage to get a loan against your family home, he didn't have any issue in terms of you counting the financial assets you've generated from drawing down on that loan, be it the cash or the shares, as long as you just exclude the principal place of residence as an asset.
And I think that's not unrealistic. So you could still get a sophisticated person, and I think this is where the potential for greatest abuse is in the $500,000 product test. So you can have somebody that has a very expensive home with a lot of assets and equity in it. They could borrow $500,000 against that home and put that single $500,000 investment into one investment, and as a result of that, would qualify as a wholesale investor. So I think that's the potential biggest risk of abuse in all of these these tests. I think the application of a risk tolerance in addition to it is an interesting one. It's not unrealistic. However, if you ask somebody in a positive environment what their risk tolerance is, you'll get a different answer to that same person in a more negative environment. But actually, they've got the same genuine risk tolerance, but they feel differently at those different times when you actually ask that question.
You might get a different answer before lunch as opposed to after lunch.
You might.
Yeah. It's also worth noting that either of these measures will involve a new level of complexity, and we have seen this play out in the US and the UK, where people sell their homes and could temporarily qualify because they have cash in their bank at that moment, or if they're going through a transitionary period, and also it puts more pressure on accountants because it will become less black and white. It has to exclude this, but then how do you calculate that? What if the debt? So I'm not saying that you shouldn't, just that it's worth noting that it creates more complexity and more grey areas for people to.
So I want to add one point. I said in my opening remark that I think the family home issue is probably a little bit not as big of a problem as what a lot of people actually say, because and people use the example of the median house is $1 million or $2 million in Sydney, depending on where you are. The majority of properties are still actually owned by joint people. So when you actually count the asset on an individual test, you only take half the value of the asset to count the asset test. Oh. So to satisfy a 2.5, if you just wanted to use your family home to satisfy the $2.5 million test, you would actually need to have a $5 million property if it was jointly owned around it. So I think the problem is not quite as big as what people say it is, just by using the single Sydney property prices.
We can also give evidence that at Aussie Angels, again, we've got 1,700 wholesale investors. 7 out of 10 of each of our investors qualify via income, not assets.
And if you change the income from 250 to 461 a year,
50% reduction.
I'd be more than that.
For our data.
461.
461, it would be over 50. I know it would be over 50%.
You'd lose more than 50% of your angel investors.
Correct.
So, AFCA have a number of determinations in here that I'm just looking at the first two. The complainant was a corporate trustee of its self-managed superannuation fund, and we've seen a proliferation of self-managed super funds. We've also seen it being used as a tool of financial abuse. Post the withdrawal of funds during COVID, people figured out that it was there and now are looking for whatever mechanism they can to get their hands on it. So we've got people with balances under 50,000 setting up SMSFs. The complainant, this was a $75,000 investment in a wholesale invitation-only fund. Complainant said, unaware the fund was intended for wholesale investors. They did not meet the wholesale criteria, wanted a refund of its $75,000, and it's considered a systemic issue. Neither the complainant's financial circumstances met the wholesale investor threshold. The financial firm breached its obligation by failing to show it ascertain the complainant's investor status. That's the harm that this legislation is seeking to respond to. Corporate trustee, again, of an SMSF. Firm did not demonstrate that it met the requirements required by Section 708(10)(c) to record the trustee as a wholesale client. So this manufacturing of wholesale status. A determination 841469. Trustee, directors, beneficiaries of an SMSF, not aware of the significance of being retail clients until several years after being placed in a wholesale investment. The document had a place for signing if the complainant selected to be treated as wholesale clients. Neither of them signed the form.
I think that's a problem. That's not a problem with the test itself. That's the problem with that in those
individual
organisations not appropriately applying the existing one, because even in today's environment, none of those should actually have been treated as wholesale investors. And so changing the thresholds and the tests and that kind of stuff is not necessarily going to change that one, because you're still going to get someone who's going to force someone through and treat someone as a wholesale inappropriately.
And that perhaps is the clarity that we need about, like, what is the harm? I mean, what AFCA's seeing, what ASCA's having to oversee are the harms. And the fix that is being generated in the AFCA and ASIC response is their response to this harm that they're seeing, which seems to be at odds with the description of the problem from other people who are giving evidence to us
Even
today.
their own description of the problem. They're describing a problem that cannot be solved by increasing a threshold. If the threshold was different, that would not have stopped those investors who weren't supposed to qualify as wholesale already still being qualified as wholesale inappropriately. Like, the threshold wouldn't have made a difference in that particular, in any of those instances.
So what is it that's going on there, and what would your fix be for that? Like,
that's a bad actor. The financial product provider in that particular case should never have done that, and there are regulations in place already that prevent them from doing so. I would also argue on their point about systemic. I don't see these particular examples as being systemic, and I would love to push them on what do they consider systemic? What data do they have to show that these bad actors, these 4 examples, is actually a systemic problem?
So the next one is talking about case study 4. Financial firm had obtained a wholesale client certificate for the purposes of offering the client a wholesale product. The client was not made aware of the certificate. And that they'd been classified as the client.
That's
and
fraud.
this is just
How does the client, when either someone's fraudulently obtained a certificate and they're not entitled to the wholesale status, or they are actually genuine wholesale status. I think one of the solutions to this is that if somebody is being treated as a wholesale investor, is they get a very explicit declaration that they need to acknowledge that says you are being treated as a wholesale investor. It means you do not have these protections around it. And I wouldn't have a problem.
But that's assuming that they would understand.
No, I understand that, but at least there's been something they've been given, and I think this is an education piece that comes into it. Really, if you said to
I think it's more like a confessional, right? There's an absolution dimension to it for the person who's providing it, who always has more knowledge than the other one. Like, these people are being gamed.
Yes, I agree,
right?
and they're bad actors.
Which is
yes,
but we are actually hearing of an increase in SMSFs. And we have seen, sadly, in some of the people who declare themselves as professionals in the accounting sector, some considerable failure of professional standards, right? And this is feeding that. And not surprisingly, AFCA and ASIC, who get the job of doing the clean-up, are saying, this can't continue, right? And we're getting you guys saying, well, it has to continue as it is because it's difficult enough as it is, and there's enough checks and balances. And I'm not really finding the middle ground. So more enforcement.
Yeah, there needs to be more enforcement and more punishments for bad actors, so that the reward for being a bad actor and getting someone in when they shouldn't be considered wholesale, but getting them in anyway to get their 75 grand, the risk of doing that in terms of the punishment that you would get should be higher than the reward that you get from doing that. So again, it comes back to risk and reward and how we deal with bad actors.
So they say the financial firm didn't show that it was adequately assessing the client's suitability to be a wholesale client, and there had not been adequate changes to policy procedures or training to prevent the recurrence.
I mean, that's a problem with that particular firm. I think
it's going to be a bit whack-a-mole, though.
Yeah,
so this is why we're looking for something to deal with this, because while these things start out with 1 or 2 or 3, the next thing it's a conversation at the pub at Terrigal
Yeah.
about how you game the system, how you set up something. Don't have to have a qualification. You become the wholesale investment advisor, and you've got all this SMSF money potentially coming through to you. You take it and you run. I mean, that is the system threat with $4 trillion under advisement and an increasing amount of it seeming to go into SMSFs, where there's so little scrutiny and such differential knowledges between, you know, the accountant who's kind of spoken in reified terms and the less sophisticated investor who might be an older person who's particularly vulnerable at point in their life.
And I think that's right. And I think so you need to make sure you have appropriate regulation and processes to stop that kind of stuff happening, right?
So what does that look like, Mr. Bunter?
Well, not quite sure yet. But I was going to say is that one thing you've got to be careful of is that by doing that, you don't completely stifle another area and decimate something else around. I think some of this has to start with ongoing education, and it's always better to do more education and more awareness rather than less in those particular scenarios. So any level of additional acknowledgement in those kind of environments, I think, is a positive one that's actually going to, if it stops one person from being defrauded in that scenario, that's a positive outcome around it.
So can I ask you to have a bit of a think about what something would look like that begins to address those things that AFCA has put on the record, because, you know, they're dealing with the reality of people getting to them.
Yeah. One potential thing to look at is that realistically, it doesn't make sense to start your own SMSF in terms of the costs involved until your SMSF is, I think, at about 250,000. So you could potentially look at like actually setting that as a requirement, because realistically, like, we know that it doesn't make sense when you get to that, unless you get to that stage. So if you're trying to do it when you only have $50,000 in there, something's fishy, because the cost of it doesn't add up. And it could be because you're getting scammed into something.
Thank you. Thank you very much. The committee will suspend for a little afternoon tea break in a very civilised manner and return, what time?
Thank you for having us.
So 4 o'clock? Yeah.
4 o'clock, yeah. Thank you.
Thank you.
committee will now resume, and I welcome Miss Paula McCabe from the Alternative Investment Management Association and Mr Stuart Glynn from 1013. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. So for the Hansard record, will you please state your full name and the capacity in which you appear? I might go to Mr Glynn first.
Good afternoon, everyone. My name is Stuart Glynn, and I'm in the capacity as the Managing Partner of 1013 Management Proprietary Limited, or 1013.
Thank you.
And my name is Paula McCabe, and I'm appearing in my capacity as a Regulatory Committee member on behalf of the Alternative Investment Management Association, AIMA.
Thank you. Thank you very much. I now invite you to make a short opening statement, and questions will follow. Ms McCabe, do you want to kick us off?
Absolutely. Good afternoon, Senators. Thank you for the opportunity to meet with you today to contribute to this important debate concerning wholesale investor and wholesale client tests. As I said, my name is Paula McCabe. I'm appearing on behalf of AIMA. AIMA is a global industry body representing predominantly private fund managers who manage assets in the alternative space, including hedge funds, private credit, private equity, infrastructure, all things alternate. AIMA has more than 2,000 members worldwide in over 60 countries around the globe. While I take AIMA's submissions prepared in response to this inquiry as read, I'd like to offer the following high-level comments before commencing an open and free discussion with you. It is true the wholesale client and wholesale investor tests have not changed substantially since their introduction. However, we're not sure why they need to change now. We cannot see any clear policy reason to change the tests other than they just haven't changed in a while. AIMA is not aware of any fundamental flaws in the system or widespread harm that has arisen because of the current tests. Australia is not out of step with international markets with our wholesale tests. While there is some divergence in terms of the numbers used to meet income tests or the assets test, almost all comparable jurisdictions do use one or more of such tests. For jurisdictions that do adopt an income test, some tests are lower than ours, for example, Canada and the United Kingdom. Some jurisdictions include or exclude some assets from the tests, but the overall impression is that Australia is not out of step. Any changes to the wholesale tests need to be very carefully considered, for there are likely unintended consequences. AIMA has identified a range of potential unintended consequences that could arise if tests are changed without due consideration. Just a few of these unintended consequences may include less choice in financial products in the marketplace, where product issuers are unable to go retail. This leads to fewer investment options for Australian consumers and less competition in the marketplace among product issuers. Consumers will have less choice and be forced to pay more for their products. Further, young and educated people are interested in investing in funds with emerging market and venture capital strategies. While these assets might be perceived as more risky, it is precisely the younger generation with longer investment term horizons and greater risk appetite who should be investing in this important asset class. In the United Kingdom, we saw the government recently walk back changes they made to their wholesale test as it had an immediate impact on the venture capital industry, on seed investment and new fund manager incubation. New and emerging fund managers will not be able to test their products for suitability in the wholesale market. This could result in untested products going straight into the retail market. By raising product price and value tests, you risk forcing investors to be overly concentrated into a smaller number of investments. Less diversification can lead to poor investment outcomes as you're more susceptible to single investments performing poorly. By raising thresholds, you risk shutting out educated and willing investors who, as an industry, we've tried so hard to engage with and bring along the investment journey, such as women and younger generations who currently meet or strive to meet the wholesale client tests. By excluding certain assets from the net assets test, you could inadvertently encourage the wrong behaviours, such as excessive borrowing against those excluded assets, including things like the family home,
putting these assets at risk. There'll be a greater burden placed on our already stretched regulators if more consumers are forced out of the wholesale market, as there'll be an influx of Australian financial services licensing requirements, more schemes to register, etc. These are just a few of the unintended consequences by way of opening remarks. Finally, if change is really necessary, then we say that more work needs to be done. More work needs to be done to understand why the tests should change and how. As part of this process, we would expect Parliament to engage in detailed consultation on a range of options with detailed explanations, proposed transition periods, as change will take time for both product issuers, investors and regulators. We would hope for consultation on grandfathering provisions, which are absolutely necessary to ensure any person who no longer qualifies as wholesale under the current tests is able to exit their investment in an orderly manner, or where they can't exit, or it's not in their best interest to exit, is able to remain a wholesale client for the duration of their current investment, and also have consultation on the effective date of change. Once this extensive consultation has occurred and draft legislation would be prepared, then we would suggest that even further consultation would still need to be undertaken. This is not a quick process and shouldn't be rushed. There are no fundamental flaws as the current tests, and that change for the sake of change should not be done lightly, for there are a myriad of unintended consequences.
Thank you very much, Ms McKay. Mr Glynn, did you want to make an opening statement too?
Yes, that'd be great. Good afternoon, everyone. My name is Stuart Glynn. I'm the managing partner and co-founder of an early stage investment firm called 1013. So thank you so much for the opportunity to present, I guess, on behalf of 1013 and the early stage investment sector in relation to the inquiry into wholesale investor tests. As a bit of background, 1013 is deeply embedded into the Australian startup ecosystem, fostering growth and innovation. I've been investing in technology for the last 9 or so years, and 1013 has been around for about 5 years. Our firm has provided a platform for more than 700 sophisticated investors, ranging from individuals to family offices, to invest in early stage technology companies primarily. We are one of Australia's most active venture capital firms, and we have, as I mentioned, 700 plus sophisticated investors that invest via our syndicated investor platform into those companies. Collectively, our investor community has invested over $100 million into 50 plus companies to date. I guess I'm here today to really keen to speak about the potential negative impact to the early stage investment category and Australian technology if the changes to the sophisticated investor test go ahead at close to double the thresholds, which has been slated by some of the submissions. We would like to go on record that we're proposing no changes to the current investor thresholds and are firmly in opposition to raising them to almost double the current levels due to the likely negative impacts that we'll see as a early stage investment community and impact to the startups that we're investing in. I'm happy to provide insights from 1013, our investor survey that we have done, and discussed, I guess, why the proposed changes pose significant risks to Australian innovation in the tech investment landscape. To give you some guidance, we conducted a survey within our investor community to understand the impact of increasing the investor test threshold to around double what they are today, as was stated earlier in the year in some of the public sources. This was done in the first few months of the year. If the proposed changes to the income and net asset thresholds were implemented, we asked, so just to be clear, we asked at doubling the current thresholds, which is not exactly aligned with the current ASIC submission. We had responses from about 100 respondents. 42% said they would no longer qualify as sophisticated investors, and another additional 12% said they would be unsure of their future eligibility. This means potentially losing over half of our investor base, which is crucial not only for the capital that we're providing to early stage investment or early stage companies, but also for the mentorship, networking, commercial support that are provided by those individuals towards those companies. Australia's financial thresholds for sophisticated investors align with global norms. They, as already been mentioned, they're comparable to those in the UK, US, and some of the wider, I guess, jurisdictions. Raising these thresholds to the likes of 4.5 million in net assets and 450,000 in income would place Australia at a competitive disadvantage, making it much harder to attract both domestic and international capital. The UK, for instance, increased their thresholds, faced significant backlash from the ecosystem and negative impacts, and quickly reversed their decision to avoid further damage. This is a material U-turn in pretty quick fashion. ASIC's proposal is asking for us to close to double the investor threshold for wholesale products versus other mature economies. Doesn't seem to line up with the international standards. Also, angel investors are the bedrock of early stage startup investing, of startup funding. They provide not only critical capital but also support to those companies and founders at their earliest stages. Increasing these thresholds really cuts out a significant portion. We're saying over 50% of our investors, reducing not only access to capital but also the growth opportunities of Australian companies. So we want technology to become a cornerstone driver of economic growth and jobs across Australia, and we do really. I don't think we want to inhibit new companies to form that over time can become the likes of Canva, Atlassian, Airwallex, GoOne, etc. Many successful companies have been built, based in Australia. We want to see more of them, not less. And cutting off funding to these folks based on increased thresholds, we think puts a challenge to the early stage sector at a very crucial time. So it would be a real shame if many Australians lost access to supporting emerging sectors such as technology and startups, which are the companies of our future. I'm happy to stop there. I think we urge careful consideration of any proposed changes to the sophisticated investor thresholds, and would request a balanced regulatory framework that protects investors whilst continues to encourage a dynamic and diverse investment environment for the ongoing growth and stability of the early stage investment sector, our innovation sector, and the wider Australian economy at large. Thank you.
Thank you. Thank you very much indeed, Mr. Glenn, and thank you both for the submissions and the detail. In fact, I've asked I think I asked one of the witnesses this morning to have a look at your submission, Ms. McCabe, and give us the feedback on that, because they held quite a different view. Mr. Glenn, you talked about, the sort of sweet spot of providing sufficient protections at the same time as not stymieing investment and opportunity and growth and innovation. And there's been some debate about what is the ill that we seek to fix with this problem. Could I put it to you that in the submission from AFCA, there are a few scenarios where they describe some of the matters that come to them? ASIC have also, put in a submission which gives their view. Because they're so different from the views that you've advanced, could I ask both of you, Mr. Glenn and Ms. McCabe, to have a look at the ASIC and the AFCA submissions and provide on notice your responses to things that concern you about that? And the other thing is, what sort of systemic responses do you see to the problems that they describe that might meet the challenge that's presented there, at the same time as not compromising the necessary engagement with the market that you seek to maintain or grow? So that's just a couple of quans on notice to start with.
And just in that regard, Chair, just to develop on that theme, from my perspective, as part of that answer, it would be very useful to have your specific thoughts as to whether or not the examples which are used by each of AFCA and ASIC to justify a change in the thresholds are actually appropriate to make, are apt to make such a change. Are they relevant to making a change to the thresholds, or do they send us down a path of considering other changes to address the ills that occurred, or evil mischief that occurred in those examples? That makes sense.
And you'll get that from the Secretariat for consideration a bit down the track. But I've also got one question that's a little larger than just the topic we're talking about. You'd be perhaps aware that this committee is undertaking an inquiry into financial abuse. And one of the lenses that I think increasingly needs to be applied in the financial service sector is the weaponisation of particular products that are available in the marketplace for those who seek to harm others and perpetrate financial abuse, which we know escalates post-separation of intimate partners and can be embedded in the abuse of power within trust structures. And it's not just the financial sector that's got these products. It's happening in insurance, which is an associated financial product, but it's also happening with government entities as well. Perpetrators using any tool they can to hurt the people that they professed to love at one point of time. So can I ask you to think about maybe supplementing your submission to us with any consideration about financial abuse risks that are embedded in the products that you're already providing and how you might mitigate against that. And I'll point you to the work of Catherine Fitzpatrick and safety by design principles that I know are becoming part of the conversation in your sector. So two sort of quite significant pieces of work, if you can, afterwards to assist us. Can I just ask first if AIMA has any sense of what ills are currently operating for people who are really genuinely retail investors who are being caught up in the wholesale investor culture and product, and how is that occurring, and is there a fix that you can see for that problem?
Thank you. I mean, to be honest, we're scratching our heads to see exactly what evil is occurring. We're aware that in a number of the submissions of various parties, they name some, MIS, managed investment scheme failures. I mean, a number of them are retail schemes anyway, so, the change in thresholds wouldn't have impacted those particular schemes. And other products that were wholesale-only products, have involved other evils like misleading or deceptive conduct or fraud. And those sorts of things are going to happen regardless of whether it's a retail investor or a wholesale investor. What we do observe at AIMA is that whilst, regrettably, there have been some managed investment scheme failures, and whilst we feel very sorry for, the investors of those schemes who've suffered harm, it is a relatively small proportion of what is a very large pool of money in this country. Thank you to compulsory superannuation in this country, our savings industry is huge. And at AIMA, we would suggest that there have been greater corporate collapses than managed investment scheme collapses, the likes of HIH, Babcock and Brown, ABC Learning, etc., where billions of retail monies, shareholder monies, have kind of been wiped out compared to what is a relatively small amount of harm that has potentially happened in the managed investment scheme space. Another observation I would make is...
Before you jump off that, because you actually have provided the most detailed response there in your submission, and it does some of the things that I'm asking you to do even more carefully with the AFCA and ASIC submissions. You speak to the list of AFCA's consultation submission mentioning series of managed investment schemes. You identify them all: the 2005 Westpoint Group, debt structuring sold to wholesale and retail investors, 2008 Basis Capital, 2009 Great Southern and Timber Corp, noting that's just retail, Storm Financial Advice, Sterling Income, Retail Fund, Global Mercies, is it, or Mercares, or I don't know, Wholesale Fund, Fraud, 500k loss, Mayfair Group, 211 million, Retail Fund, Future Asset Management International, responsible entity in liquidation. And then you go on to talk about the ones you've just mentioned: HIH, ABC, Babcock and Brown. Very, very different levels of risk embedded and impact embedded in those two different models. So can you just expand a little more on what's going on with Babcock and Brown and ABC, and is that where the ill lies, in that part of the ecosystem?
Well, I mean, I think they're general corporate failings, businesses of, well, what would have been going concerns, as opposed to being, I guess, what we typically think of as a managed investment scheme being a pure kind of investment play. but I guess the point that we were trying to make as part of these submissions was that there's a lot of focus on some of these managed investment schemes or other products that have gone poorly, but there seems to be a bit of a blind spot when it comes to everyday investing that mums and dads do in the corporate space. And, I think there's this misconception that there's a lot of evil going on in the managed investment scheme space when that's not really the case. These are some outliers when you kind of look at the dates and the timeframes in which the Managed Investment Scheme Act has been in place since 1998. I mean, whilst it would be nice to have a clean slate and not have any failings, it's a relatively few failings really that has happened, and a number of these would have occurred regardless of the wholesale client test or the retail client, because some of these funds were available to retail investors in any event.
So your argument is this is the kind of failure level that we should fundamentally accept?
Well, I mean, it's not going to be a perfect system, but I guess from our perspective, we don't see, particularly once you back out the schemes that were registered schemes anyway, and you back out the failings that are due to fraud or due to misleading or deceptive conduct, we don't think that the failings are particularly dire or warrant big changes to many things, but in particular big changes to the wholesale client test.
Okay. So if there were to be changes, in what area would there need to be changes to address what you've described here as these failings?
Well, I mean, I think in these particular instances, most of these, in fact, all of these have predated the design and distribution obligations.
Which have been described as a game changer in this sector.
Correct. They came into place in October 2021.
Yep.
So we really haven't seen those wash through the system yet. ASIC's got, at the same time as DDO came out, design and distribution obligations, they have product intervention powers as well. All of those are designed to work in the retail space, of course, not in the wholesale space. Mm-hmm. But I think there are other tools being used by the regulator that have been relatively recently introduced to help clean up the Act, clean up the sector. Not that it needs, to be honest, it doesn't, that's a poor expression. It's not that there needs to be...
But that's the public kind of discussion, isn't it, that the sector does need a clean up? And that's where the impetus to do this sort of change comes from.
Potentially, but as I sort of said, but I think there is a misunderstanding of the so-called evils that happen. I think by and large the financial services industry in Australia is very healthy, particularly in the managed investment scheme space, because you're a trustee, you're a fiduciary. The service providers that we work with, the members, within AIMA, they are by and large very responsible corporate citizens. They're regulated with Australian financial services licences. Whether they're in wholesale or retail, there is significant regulatory oversight. And the breach reporting regime is another kind of recent change, which is used or should be used by the regulator to help ensure that good behaviours are occurring. You mentioned, I had the benefit earlier of hearing some previous speakers talking about potentially product issuers not appropriately monitoring members coming through and miscategorising them as wholesale clients when in fact perhaps they ought to have really been retail clients. Yeah. That's a reportable breach, absolutely, to ASIC. And if AFCA is becoming aware of these things happening on a systemic basis, then the regulator should be looking into those issues, because the licensee who's responsible for issuing the product to these people, or the licensee who's responsible for deeming or assessing a particular investor as being sophisticated, if they're not doing their job properly, then that's a breach of the Corporations Act, punishable. And that the regulator has the powers to be able to bring enforcement action against those bad eggs.
And the enforcement action, do you believe it's happening at a sufficient level to be a deterrent to people who are being encouraged to sort of raid their super and put it into SMSFs and engage in wholesale investing?
well, the members of AMA are terrified of the regulator. You know, the enforcement activity is, I think, at an all-time high. And as I said, I think by and large, certainly the people that we deal with, they're good corporate citizens, they're trying to do the right thing by their members. They do not want to get on the wrong side of the regulator. And so I think ASIC has sent a very, very clear signal to the industry that, you know, fraudulent, misleading or deceptive conduct, it's not acceptable. And, you know, the vast majority of people do not engage in that kind of conduct.
Thank you. Senator Scarr?
Thank you very much, Chair. Ms McCabe, again, thank you for your submission. It's a terrific submission. A lot of work went into it. Very helpful. Your last answer there to the Chair, you referred to fraudulent and misleading and deceptive conduct. That is unlawful whether or not you make an investment as a wholesale investor or a retail investor. Is that correct?
Correct.
So we're not talking about a situation where there are no obligations, no requirements with respect to wholesale investors. There are some fundamental legal requirements that must be discharged, whether or not you're a wholesaler, whether or not the organisation is dealing with a wholesale client or a retail client. That's correct.
Correct, 100%.
And perhaps the most powerful is the obligation not to engage in misleading and deceptive conduct or to commit fraud. Correct?
Correct.
Okay. Mr. Glynn, are you still there?
Yes.
So, Mr. Glynn, have you been following today's proceedings over the course of the day?
I've only followed the last session that you had, which was quite relevant to our sector. The last session you just had just before this one.
Okay, that's okay. I asked you that because I actually quoted from your submission to some of the witnesses at the start of the day from the law firms, and in particular the paragraph on page 2, which I found quite powerful. I quote, "A recent survey among 1013 investors indicated that should increased thresholds for net assets and net income as noted above be implemented, then 42.4% would no longer qualify as sophisticated investors, with an additional 12.1% uncertain about their future eligibility," end quote. So that's in the context of an increase in the net assets test to approximately $4.5 million. Is that correct?
Yes, that's correct. $4.5 million net assets and or gross income test to be $450,000.
Okay, so
at the individual level.
Okay, so it's under either one of those two limbs that current investors, 1013 investors, would no longer be eligible as sophisticated investors. Is that correct?
That's correct.
And what is one of the themes we've been talking about during the course of the day is consultation that should occur with the investors themselves. So presumably these are all people who've made a decision that they're interested in investing in the early startup tech space. They have confidence in 1013. So they've made a decision to invest money in this way. What's their view about these potential changes and the prospect that they might lose opportunities which they currently have if these thresholds are changed in the way that's mooted?
Yeah, I would say not very happy. I mean, look, these people are generally pretty passionate about the space that we're working in, which is early stage technology. You know, we invest in startups. It's classified as pre-seed through to kind of Series A, so like the early stages of a company's life in the technology sector. And 1013 does a bunch of work looking to, you know, we look at over 100 companies a month and we try and understand, and then we do due diligence on a handful of those, and we end up sharing ones that we're also co-investing in ourselves to the wider investor base, and they pick and choose the companies that they would like to invest in. We have a minimum threshold trying to make it accessible so they can build a portfolio of, you know, sort of $10,000 per company. So trying to make it available to those investors to basically build out a portfolio of early stage technology companies, but also learn and educate themselves on the future trends and the underpinning businesses. So they get to see like a full kind of like 5,000 word deal memo about each company, trying to outline all of the key aspects of the business, including risks and their opportunity, who's involved in the business, and then they make a decision if they want to invest. And we also run a bunch of educational kind of concepts, I guess like to try and educate our investors about the asset class and what it takes to invest in it, to get the right level of risk and reward and balanced returns in terms of portfolio approach, etc. But when we shared out this, the proposal and the update to investors and to do the survey, we also asked for commentary, and there was a lot of sort of commentary around that it would be very unfortunate if they lost access to the asset class on the basis that the thresholds have been close to doubled, and so I would say it wasn't warmly received, put it that way.
Okay. In their submission, ASIC, have you, Mr. Glenn, have you had an opportunity to read ASIC's submission?
I've got a copy of it, obviously relatively long, but I've gone through it in somewhat detail.
Oh, okay. And Ms. McCabe, you've read ASIC's submission, I think?
I have read it, but I don't have it in front of me.
No, that's
I'm
okay.
happy to talk to it.
So in one section, I put this to witnesses in the previous panel. ASIC says, and I quote, "There's a range of existing avenues available in the Corporations Act for those seeking to raise capital for limited offerings to clients with reduced compliance obligations. These avenues would not be impacted by our recommended reforms to the wholesale tests and would remain available for fundraising as explained below." End quote. They then provide two examples or two avenues for fundraising, which they say address some of the concerns that have been raised by a number of stakeholders. The first is through this CSF framework, which they say the CSF framework enables eligible small unlisted companies to raise up to $5 million from retail clients via the platform of a CSF intermediary. And then the second option they refer to is what's sometimes called the 2012 rule, where no prospectus or PDS is required to be given for fundraisings up to Australian $2 million where offers of securities or financial products are made to up to 20 retail investors over a rolling 12-month period. I'm interested in both of your views, and I'll go to you, Mr. Glynn, first, with respect to whether or not those two avenues for fundraising actually address the concerns which have been raised about access to capital, especially in the early startup phase. Mr. Glynn?
Sure. Thank you. So I guess the CSF framework for, private companies to raise, like crowdsourcing, is effectively what that governs. I guess in terms of the size of the industry, I'll probably start there. There's only a couple of platforms that actually even offer CSF, offers out there. There's probably two or three of reasonable size that actually make offers. So one is in terms of actually the capital available via the retail industry via CSF is quite low. If you look at the gross numbers, there is a report. I'll try and find it. Maybe we can take that on notice around the current size of that market, but it's relatively small in comparison to the venture capital industry. The process that a startup has to go through to actually get that capital, one is they have to change their structure, shareholders agreements, etc., which come at legal costs. But not only that, it also makes them have a relatively cluttered or large shareholder registry. They have to share out publicly their information around their business, which can be sensitive information for there's competitive reasons. You don't want your information going out fully into the public sector. Venture capital funds sometimes will not invest into that structure, so then that company is inhibited for follow-on or future capital fundraising. So it can have a challenging sort of outlook if it's after they go through a CSF or a crowdfunding kind of process. Sometimes they'll not be able to raise for future venture capital funding, and often the crowdfunding angle is quite beneficial for direct-to-consumer companies, but not necessarily for all other companies. So it's often the benefits are that there's a direct-to-consumer opportunity. You can get your users to actually buy into buy equity in your company. But there is, I guess, a convoluted process is what I would say. Your information is getting out there to the wider market, and the industry is not actually equipped right now in terms of the platforms and the actual scale of capital that is in the industry to actually address the requirements to support the early stage startup ecosystem. There's not enough capital flowing through that mechanism at the moment because of those reasons that I just mentioned. And then to address the retail investor side, which is the 2012 rule, fundraising up to $2 million from retail investors. I think again, this is an early stage. You need to build at the early stage investing space. You need to build a portfolio of companies, otherwise you're at risk of losing capital loss because of the high risk nature of early stage investing. And so we try and educate all of our investors about this. We make it accessible by making it to $10,000 per investment or per deal. But all of our investors are wholesale. When you're talking in this sort of scenario from a retail investor perspective, if you only have 20 people at $2 million, that's talking about $100,000 cap. But then again, doesn't give you a diversification. So then the reality is that if you take on retail investors, then you're not actually, and they're wanting to put in $5,000-$10,000, you're not going to be able to get the capital that you need as a startup. The second aspect that probably hasn't been covered is that this also goes towards staff. So when you're issuing ESOP or I guess like options in the company, which is often used as a tool to incentivize teams within companies with a portion of equity via the sort of option scheme, that is also counted under this rule. And so because a lot of your staff are often retail and don't qualify for wholesale, then if you issue equity, that is deemed to fall under this 2012 rule. And this happens is very consistent in most startups. They often issue out, I guess, ESOP as part of compensation to staff, and that will reduce the number of people that you can actually raise money from under that retail scheme. Does that make sense?
Yep. No, and that last issue you just raised was one which wasn't touched upon by our previous witnesses, but the other points you've raised are consistent with what we heard in the previous panel. Ms McCabe, is there anything additional you'd add to ASIC's solution?
If I could perhaps comment on the 2012 or the small-scale offering exemption is what we tend to call it. Agree with what Stuart said in terms of, obviously it's a $2 million limit in a 12-month calendar. So it's a rolling period. It's not a, 1 January to 31 Dec period. So it is a little bit difficult to administer. But more importantly, I think it is an exemption that is not very well understood, particularly in the managed investment scheme space. While the exemption is designed to exempt a product issuer from having to provide a product disclosure statement, and therefore from the requirement to have to register a scheme with ASIC, it doesn't exempt you from all other obligations. You still are providing a service to a retail client. You still need a retail AFSL, which, if you're trying to if you're in the business like Stuart is in, you're not going to have a retail AFSL. It's not clear that the exemption extends to other retail-oriented kind of consumer protection provisions. So, for example, it's not clear that cooling off rights don't exist. Confirmation statements, are still required. So I don't think people understand the narrow nature of the exemption, and it is certainly not a complete solution to raise capital in this context.
Okay. I'll put another proposition which has been put forward by ASIC, and this is in their proposals to change the wholesale tests, and this is in their key points in section D of their submission, the last key point. We do not consider such increases would have a material impact on the fundraising community. End quote. How do you respond to that, Mr. Glynn?
I mean, I think the only way we can kind of respond is the survey that we ran with our investors, which was saying that likely more than 50% of our investors would no longer be able to invest in the category. And if you take that, we've invested $100 million, and we take a blunt instrument and say, okay, well, that means that we'll have half of that money would never have been invested into the early stage community, and we're just one player in this environment. In this whole ecosystem. So if you extrapolate that out to the impact that this will have in terms of ripple effect for availability of capital for these early stage companies that we, I think would like to see succeed. Yeah, I mean, it doesn't make any sense. Effectively, we believe it'll have quite significant impacts to the early stage funding environment, and it's already likely. You can point to a market like the UK that increase the threshold, not even, I believe, to as high as we're talking about here. And within a period of months, not even years, they rolled it back, which is very, very fast movement, obviously highlighting, well, I believe, the negative impacts that were felt across the ecosystem. So, my response would be, I think there will be significant negative impacts to the early stage funding ecosystem on the basis of those thresholds going through.
Can I just ask a question at this juncture? Mr. Glynn, some may say that the risk embedded in that 100 million is way too high, that 50 million on risky ventures is sufficient, and perhaps there's a disposition of that kind that is part of this conversation in the public place. So I invite you to respond to that, either today or on notice. But I think this is an opportunity to switch to Ms. McCabe for your excellent schedule about the jurisdictions. Clearly, Australia is not the only place that's looking at its current settings around sophisticated investor or wholesale investor standing and status and restrictions and opportunities, because there seems to be some movement and clarification going on in places you've indicated here, and we've heard throughout the day, the United States, United Kingdom, the European Union, Hong Kong, Singapore, Canada. They're the ones that you've put in, and others have also considered New Zealand. Is part of the answer to our question is, like, why is this important? Answered in other jurisdictions, because they're doing something too. It can't be nothing if everybody's having a look at it.
I don't know why every jurisdiction is looking at this. I do think that certainly in Australia, and I would suggest that in the comparable jurisdictions that you've just mentioned, I imagine a similar phenomenon is happening. Our access to financial products and our access to investment opportunities is far greater now than what it was, historically. And I think that's through the use of, it's because of the advancements in technology, like we have information at our fingertips now. I think we are more engaged with our savings. We are more able to be self-directed. We're more able to be self-educated. And so I think, we're more interested in investing more broadly than just the kind of bog standard opportunities that are put forward to you.
And the regulatory regime that managed that previous period is now something that everybody's looking at, because we're going, well, hold your horses, because it looks like there's a massive rush to diversify products in the system. And so this is a historical moment almost to say, well, that was then, this is now, let's have a look. But it's talking into a different context that you've just described.
Yeah.
Is that an explanation?
Possibly. I think so. I think there's also a little bit of, someone else is looking at that. Should we look at that too? I mean, the regulators do get together
fence,
and, they routinely talk with each other and say, these are the issues that we need to be looking at or we ought to be looking at. I mean, ASIC routinely follows what the UK, or examines what the UK and the European Union are doing, for example. So, I think that once one regulator does something, tends to be a little bit of a knock-on effect amongst the global regulators.
They obviously didn't hear that one that your mother says to you, if your friend jumped off the harbour bridge Would you follow them? So,
I would have loved to have had you as a teacher.
oh my goodness, it was fun. So, Mr. Glynn, do you have a view about this social phenomenon of regulatory review in multiple jurisdictions around the same issues at roughly the same time, with a range of different responses?
Look, I think it probably goes back to like what the international standards will look like post reviews of these, and obviously time will tell. But we can only sort of point to the ones that I've reviewed and then tried to implement changes and what the results have been, because we don't actually know what the results will be of other ones. But even if you look at it, at current benchmarking, I guess you could say, like Australia right now, to me, is broadly in line or towards the even probably higher end with the current standards. And so if we have a review and we say, okay, let's go and take the thresholds and take them from 250,000 for income up to 450,000, then let's increase the 2.5 million net assets to 4.5 million. If you go then and benchmark that to everyone else, I think we'll probably be the highest in the world by quite a long stretch. And so, not to say what we should be in market, but it makes us uncompetitive. But from a review perspective, and where not only investors will look to put their capital, but will even other companies and will there be other knock-on effects of the basis of that, because we sort of make it quite a restrictive place to invest because of the thresholds. And so, I think I broadly look at it as we generally look to some of the larger markets, whether it's the US and UK, to benchmark and say, are we in line, or does it make sense? And broadly, I think we already are in line. And then the increase would make us, in my opinion, out of line, or quite above the market or the wider sort of market. But don't have a comment, I guess, on why the reviews are sort of happening. I would suggest it's for similar reasons that there are being raised from the likes of ASIC and regulators, etc. That we're sort of talking about of how do you make sure you've got a healthy financial ecosystem that actually enables the right balance of regulatory control, but also ability for folks to invest via different financial products and having the right protections in place. And so I don't have a broad scale comment on that, but I think we're broadly quite close to market already.
Okay, thank you, Mr. Going back to you, Senator.
Yeah, thanks, Chair. I was just going to ask a follow-up question on that, because I'm trying to reconcile the observations you just made, Mr. Glynn, and Ms. McCabe's very useful table with this comment ASIC has at paragraph 105 of their submission. Overseas jurisdictions also use tests that employ financial thresholds to distinguish between retail and wholesale clients. Other jurisdictions generally impose higher financial thresholds or exclude certain assets when determining whether an individual meets the relevant wealth tests, end quote. Which to me, there seems to be a disconnect between that statement and what the existing thresholds are overseas. Can you provide any insight into, am I missing something there, or do you agree with my statement that that doesn't appear to reflect what the actual current position is in the major markets of capital with which we compete?
I agree with you. We cannot equally we can't reconcile the statement made by ASIC with the findings when we've done the deep dive into what other comparable jurisdictions are doing. I think Australia has, for a long time, considered itself to have relatively low wholesale client tests, but actually, when you look at it, it's not the case.
Correct.
We're not out of step. There are some jurisdictions that are perhaps a bit tougher than us, and there are some jurisdictions that are easier than us. There are some jurisdictions that exclude assets like the family home, and there are plenty of others that don't. There's a mix, but when you examine it as a whole, we're not out of step with the international market.
Which begs the question, and you probably don't have an answer to this, and I'm wary about putting it on notice for you to do the additional research, but it begs the question how the other thresholds tracked in the other jurisdictions over time, whether or not we all started at or about the same amount 20 years ago, and none of the jurisdictions have materially updated those thresholds, or whether or not at the time we introduced the thresholds, we were had higher thresholds than our international competitors, and they've caught up. Do you have any insight into that?
I don't have great insight into that, but what I can offer is that at the time that the thresholds were set, I think at least insofar as, when Financial Services Reform Act was introduced in 2002, the objective was to say, well, let's distinguish between wholesale and retail clients. The default position, of course, is that everyone is a retail client unless you're proven otherwise. So you don't just fall into becoming a wholesale client, you actually have to...
It's an enactment.
It's a positive decision to become a wholesale client. And they set the thresholds at the relevant time on the basis that they felt that, well, wholesale clients are, for want of a better expression, big enough and ugly enough to look after themselves, and they don't need to benefit from the same consumer protections that retail clients need to. I don't know if at the time those thresholds were the right value set, but they were what was set, and I think that at the time that's what they felt was, an appropriate kind of balance to ensure that people who ought to benefit from the consumer protection provisions, continue to be so protected. And if you were able to qualify as a wholesale client, then, based on those thresholds, you didn't necessarily you didn't need the benefit of those protections. So hence, we kind of think that coming up with whatever the right figure is, which we are very comfortable with what the current thresholds are, we do not think that changes need to be made to them. But when coming up with those, should any changes be made, heaven forbid, those sorts of objectives need to be taken into account. Like, why change them? What are you trying to achieve? Have we moved away from thinking that more people need the benefit of consumer protections, or perhaps there are alternative ways to achieve that? The regime is already structured such that you basically have to opt into being a wholesale client. Maybe there needs to be a consent regime, a stricter consent regime, so that it's more clear when you are opting into that particular regime that you are accepting the risks of foregoing some of the consumer protections that might exist to you, that you would otherwise be afforded to you, and that you positively acknowledge and understand that you're losing those rights, but you understand and acknowledge that, and you'll bear the risk of any associated consequences.
And in that regard, you're referring potentially to that recommendation 11, I think it was, from the quality of advice review.
Yeah, similar kind of concept, that you're basically consenting to go into the regime. I mean, we already have a similar kind of concept for one of the wholesale client limbs, the sophisticated investor limb, under 761 GA of the Corporations Act. But maybe a compromise is to, have that kind of consent regime apply to more of the wholesale client limbs.
Okay. I think we're getting to the end of our time. So, Mr. Glynn, one final question for you. A number of stakeholders who've made submissions have emphasised the need to ensure that if the thresholds are changed, there needs to be appropriate transition provisions, grandfathering, etc. I would just like to give you an opportunity from the perspective of 1013 to outline why that is important in terms of your business and investment structures, potentially.
Sure. Yeah. So we don't have a fixed fund structure. So all of our investors are always having to be active, sophisticated investor with a valid 2-year 708 certificate, or wholesale investor certificate. And so we don't make offers. We have to continually monitor that we're not making offers to anyone that's not a sophisticated investor, doesn't continue to qualify, and if they're not, then we remove them, or we don't make any financial offers. And so I guess there's a handful of considerations around this. if you're going to grandfather and increase the thresholds, then one, we would need to obviously check that everyone has a valid certificate, which would basically be quite significant sort of overhaul when you're trying to deal with 700 plus investors. So there's considerations about the operational constraints and extrapolate that to a lot wider. But also when you're making investments in early stage or in companies, some of the grandfathering would be if you invest into a fund, like a venture capital fund, then you get a test once when you make that first investment, and then that fund can go and invest for you for the rest of the time, right? And they will do capital calls to you, and you will still be required to pay them, even though you may not still qualify, which is not the case for I guess a syndicated investment product like Aussie Angels, who was on before, or 1013. And so, how does that grandfathering happen if you've already invested in a company and then they do a subsequent capital raise? Do you have the right to continue to invest, or are you now cordoned out because are you on the sideline because you no longer qualify and you're no longer able to continue to support that particular investment or that particular company, even though you met the criteria 6 months ago? So it's always I guess a point in time.
Sorry to interrupt.
I don't know if that makes sense.
No, it does make sense. And in that scenario you just outlined, that means you're exposed to dilution. So you've bought in at a certain stage when you're able to. The law changes, so you're no longer potentially able to participate in subsequent capital raisings. Therefore, your interest is diluted and you can potentially lose value that way, correct?
That's correct. You're exposed to dilution and also future economic uplift, I guess, or from the exposure to the I guess further equity within the business. And so dilution does impact your financial returns over time. And so we often counsel to try and maintain and try and continue to follow on invest into the companies that are going in the right direction and maintain your ownership so you maximize your outcome as an investor. And oftentimes this is quite important in the early stage, I guess in the startup ecosystem where you have generally a wider portfolio of companies, and then there is a power law where some do extremely well and you want to have more ownership than less, and you don't want to be carved out from being able to only invest in that in their first, in that initial round and then no longer further down the track. I don't know if that makes sense.
No, it makes a lot of sense. Ms McCabe, on this issue of transition and grandfathering?
Yeah, I mean, we would see a couple of challenges with it. I mean, if you have a relatively illiquid investment strategy, allowing an investor to exit on the basis that they no longer qualify can be tricky to do because you may not actually be able to exit the investor. Similarly, if you force an investor out, you're crystallising tax outcomes for them, whether they be CGT losses or CGT gains. And, certainly a lot of the products in AIMA's world are longer-term investment products where you're in there for the long run. And if you force someone out earlier than expected, it has unintended consequences for them. And it genuinely may not be in their best interests to be forced out of a particular fund.
Okay, excellent. No further questions from me, Chair. Oh, sorry, Mr. Glynn.
Sorry, could I just make one more comment on that? Grandfathering of the existing holdings that you have would be like an absolute requirement because these are illiquid businesses that you're investing in. There's not a liquid market where you can just go and sell your shares. If you do, it's often at quite significant discount. And also the company, it's very difficult to actually try and force the company as a very small minority shareholder to enable you to just sell it. So we educate our investors that this is in a liquid asset class, and you have a holding period, and the way you exit is your position is when that company has a liquidity event, such as they're acquired or they IPO on the stock exchange, or there's a secondary transaction. That cannot happen. I guess it would be very, very difficult to try and manage having to exit, positions because people are no longer qualified as wholesale investors. The way it works today is if you no longer have, a wholesale certificate, then you can't invest in future investments, but your existing investments probably need to be grandfathered if there is a new test. Hopefully that makes sense.
No, it makes very good sense to me, Chair, and no further questions from me.
Thank you. I just had a question about the education qualifications, which have been the subject of some discussion today. And I've jumped on to the ASX, which has shares courses getting into the share market, 8, what is a share, why and how to invest, risks and benefits of shares, what to consider in an investment, how to buy and sell shares, record keeping, market indices and market sectors and share market investment strategies. And then having done the first one, you can check your understanding with a little quiz. Now, this appears to be something that you can pick up free. I haven't been asked to pay for anything just yet, so we'll see what happens. But the registration of completing such a course, is that the kind of education that people need? Should there be an independent place that people could say, well, actually, I've learned about investing in, one of the, I think, the kinds of investment you talked about in infrastructure, which might particularly appeal to a group of people in the construction sector who might be not sophisticated but decide they really want to, they know something about that, they sense what's coming and they'd like to be a part of it. What would they need to do, and where would it need to be registered in order to make them eligible to become a wholesale investor?
Well, I mean, at the moment, they're the only kind of education requirement is if someone is trying to go under the 761 GA test, which basically says that a financial services licensee or a representative of a licensee has sat down with you and has assessed whether or not you understand the merits of the product, the value of the product, the risks of the product. Do you have experience of investing in these sorts of products before? And basically, do an assessment of you to work out if you are sufficiently sophisticated to invest in this particular type of product. I mean, because it's quite a subjective thing for someone to do, and, if you get it wrong, there's risk associated, obviously, with getting it wrong. It's not something that we see as being widely used across the industry. So I don't think we at AIMA necessarily advocate for a kind of blanket education type requirement. I think we are more in favour of a consent and acknowledgement requirement. I think courses like what the ASX offer are broadly available and they're not necessarily designed for people who are looking to, become a wholesale investor. It's for people who are just self-directed investors in all types of products. But I sort of go back a little bit to what I said earlier. I think we are, as a population, much more engaged with our savings. We are much more self-directed. We are much more self-educated. We are more clever than we were, 20-something years ago when this regime was introduced. I don't think that, reducing the number of products that you can access by, changing the wholesale client test is in line with that increase in education that we have and the level of sophistication that your everyday investor has in investing in all sorts of different products.
If you have any thoughts about what something in the education space might look like in terms of like micro-credentialing for, I want to engage in a new product that's come onto the market. There could be a short course that you do and then you just register that you've done that and it's approved and tick and off you go. What might a system of that kind look, and who would hold it, who would create the product in terms of the assessment tool, and is that a way to engage more people in wholesale investing with less risk, a demonstrated way of showing that they've done the reading rather than just an investment, deep dive through some algorithm that's on your phone that leads you to a dodgy provider of financial advice.
And that is potentially, a risk that exists. People can structure things cleverly so that if it's a multiple choice type exam, and you've got multiple attempts at doing it, people can potentially,
At its best, that's called mastery learning, but at its worst, it's called manipulating the test.
Yes, potentially.
Yeah.
Maybe there are opportunities like that. I mean, going a little bit off-piste, and this is not relevant to the wholesale investor test, but, basic education in schools around investing, superannuation, all of that sort of stuff, I think that needs to happen. Obviously, that's not necessarily for the purposes of trying to encourage people to become wholesale investors, but just ensuring that, the next generations are economically literate, financially literate to invest in.
Scam protected.
Yes.
Scam aware.
Yeah. Scam aware, all of those sorts of things. I think that would be a worthwhile policy area to focus on.
Right. Thank you very much. Can I thank Ms McCabe and Mr Glynn, who are our last witnesses for the day. Can I thank all the witnesses who've appeared, and to Hansard and Broadcasting, I thank you for your assistance as well, and to our Secretariat, and of course to my colleagues here, Senator Scarr and the Deputy Chair, Mr Alex Hawke. Thank you very much, and the committee now stands adjourned.